My lords.
Everything will come tomorrow, please. Please give all the memos. Please give all the memos. It will come tomorrow. Very good. What did we say? Give the memos. It will be listed tomorrow. It will be listed tomorrow. It will come tomorrow. Please give the memo.
My lords, one small submission requesting for 230, my lords, and there is a 50 lakh cyber fraud, my lords. Investigation agency and the accused has find hands and trying to siphon off the money, my lords. And
There's no freeze of the account.
Yes, there is, my lords.
And nothing will happen. It will come tomorrow. Give the memos. We are not even asking you today. Give the memos. It will come tomorrow.
They sent an email stating that the money will be released within by 6 o'clock, my lords. And they sent email to me that like my case against the accused is closed, and they will release the money to the accused.
Requesting that the matter to be taken up at 2:30. Threat of an arrest, my lord. Threat of an arrest, my lord.
By whom?
By the consumer forum.
The warrant issued. Yesterday also you had moved. We told you the same thing yesterday.
Now I have ascertained, my lord. My order, which I succeeded before the district consumer forum, was challenged before the state forum, and the order was modified. Immediately, I made an application yesterday for review, and I've sought for suspension of that sentence, my lord. Suspension of the non-bailable warrant. The state consumer forum has refused to entertain my application.
Then you are coming here as what? An appeal?
My lord,
go before the National Commission.
My lord, I am ready to deposit the entire money, my lord. I am ready to deposit the entire money. If it could be taken up at 2:30, my lord.
So get the demand draft.
I will get the demand draft, my lord. I'll get the demand draft
and get the order copies.
I'll get the order copies. Gratefully.
Please give the memo, madam. What's the urgency?
Pertaining to Commonwealth thing, my lord, it was supposed to be listed yesterday, my lord. The opposite council have been filed their power, my lord. Okay, my lords, the urgency is, my lords, the selection will be will come to end by day after tomorrow, my lords. The urgency is, my lords, to stay the selection list.
ಆಯ್ತಾ ಹೇಳಿದ್ದು ನಾವೇನ್ ಹೇಳಿದ್ವಿ ಮೆಮೊ ಕೊಟ್ರೆ ನಾಳೆ ಬರುತ್ತೆ ಅಂತ ಹೇಳಿದಲ್ಲ ಇನ್ಯಾವ್ದಾದ್ರು ಬೇರೆ ಭಾಷೆಯಲ್ಲಿ ಹೇಳ್ಬೇಕಾ Yes. CMP we are not going to take up. What has happened? The disposition. The disposition, eviction order has been passed.
Matter, my lord, arising from dismissal of two connected matters, company petitions. Arising from two company petitions, my lord, there is an inherent grievance of violation of principles of natural justice, my lord. My lord, there is an urgency in this matter, my lord. My lord, if this matter is not taken up today,
what will happen?
My lord, statutory limit will be.
Nothing will happen. It will come. Good.
Respondents Sanda, in the name of petitioner Sanda, is conducting a meeting on 5th of January. Urgency, the meeting is convened.
File a civil suit, sir. It can't be taken. Then why Kodi? We'll dismiss it tomorrow. Give it.
2:30.
Yes. Ashtana. Yes, Mr. Shidra.
Yesterday's matter is now at serial number 83.
We told you people are moving memos left, right, and center.
Yesterday, my lords ordered to list the matter in the preliminary hearing. Now it is in the B group.
B group, Allah. Preliminary hearing, 83 Allah.
I believe it is in B group.
B group.
Huh?
B group.
B group. We'll take it up in the afternoon.
Please.
My lord.
Serial number 47, my lord.
Just a moment, please.
Okay.
You don't want it to come up tomorrow? Better. Itkolli memo ನೀವು ಕೊಡಿ ಮತ್ತೆ. Yes.
Adjournments. Serial number.
List number 1, page number 6, serial number 38 to 40. Page number 7, serial number 41 to 47.
Serial number 51, my lord.
47
number
ವರೆಗೂ
47, my lord.
ಹಾ.
Serial
Yes.
number 47. I am for the respond number for this in this case, my lord. This matter is date given on 31/26, my lord. Without informing them, the petitioner move the matter, my lord.
So they have moved the matter. Have you informed them that you are going to seek for adjournment?
And some 8/12/2020 is the matter listed.
Please wait. Please wait.
Page number 8, serial number 48 to 52.
51, my lord.
49 at the request is not settled. So both matters not settled.
No, they are ready to pay the amount. It's only with regards to the quantum of the money. What they are proposing is a settle sum and what.
So you're still discussing settlement? 49, the counsel for the petition submit that though the report from the KMC indicates that the matter has not been settled, the parties are still exploring settlement. Given to 3 weeks time, they'll endeavor to report settlement. Released on source. Interim order earlier granted is extended.
51.
Both the cases.
Serial number 51, my lord. 2 weeks time.
At the request of counsel for the petitioner, February interim order.
18 February.
Interim order extended.
Page number 9, serial number 53 to 59. Page number 10, serial number 60 to 64.
61, my lord. I informed the other side also. I am for petitioner. It may be taken up.
The request of counsel for the petitioner, February.
18 February. Page number 11, serial number 65 to 71. Page number 12, serial number 73, 72 to 77.
Lord, I appear for the petitioner. Interim order may be extended.
Request of the respondent released February. Interim order earlier granted is extended till next date.
Case number 72, my lord. Case number 72.
February.
72, my lord.
72, ಹೇಳಿ.
Prayers for the time after vacation.
ಏನಿದು ಪೆರೋಲಾ? ಪ್ರದೀಪ್ ಅಂದ್ರೆ ಪೆರೋಲ.
Appears for the petitioner.
ಪೆರೋಲಾ ಗೊತ್ತಿಲ್ವಾ? Released on 8/1. 76. Yes. At the request of counsel for the petitioner, February.
18 February. Page number 13, serial number 78 to 83. Page number 14, serial number 84 and 85.
Yes, madam.
88, my lords. I appear
88.
for the petitioner, my lords. The state has filed objections and are vacating the application which hasn't been served on us, my lords. So any short date may be granted, my lords.
Some non-compliance is there.
We'll do the
Or
needful.
SOB.
We'll do the needful.
2 weeks to comply with the office objection. Released on soon.
8 February.
My lord, serial number 101, Indus law is on record for respond number 1, my lord. But the petitioner has filed a withdrawal memo.
101 memo for withdrawal dismissed as withdrawn. 102 memo of withdrawal dismissed as withdrawn. 104 dismissed as withdrawn. 100 dismissed as withdrawn. 99 dismissed as withdrawn. 98 dismissed as Eastern memo of withdrawal. 98, 99, 100, 101, 102, 104 dismissed as withdrawn. Yes, Mr. Sridhar.
My lord, serial number 97, teachers salary ಆಗಿಲ್ಲ ಬಸ್ ಡೀಸೆಲ್ ಕೊಟ್ಟಿಲ್ಲ ಅದಕ್ಕೆ ಇಂಟೀರಿ ಮಾಡಬೇಕಾಗಿದೆ ಸ್ವಾಮಿ. ವಿಶ್ವಮಂಗಲ ಸ್ಕೂಲದ್ದು.
Yes.
2:30ಕ್ಕೆ ತಾವು ತಗೊಂಡ್ರೆ ನಾವು ಅದರ್ ಸೈಡ್ಗೆ ಹೇಳ್ತೇನೆ ಸ್ವಾಮಿ.
97 ಹೇಳಿರಿ ನೋಡೋಣ. 2:30
ಮಚ್ ಒಬ್ಲೇಸ್. ಮಚ್ ಒಬ್ಲೇಸ್.
114. Yes. Two weeks to comply with office objection. February. Interim order.
18th February. List number 1 for being spoken to, serial number 1.
Yes.
Tajuddin Ahmad.
Kalburgi. Matter has been moved for being spoken to. Learned counsel for petitioner submits that there is a typographical error in line 2 of Roman para 2 of the operative portion at page 4. The same is accepted and corrected. The word Bangalore is replaced by the word Kalburgi. So also the commencement of parole from 17/11/2025 is replaced by 22/11/2025. Registry to issue fresh certified copy.
Serial number 2, Vasudeva Naidu.
Yes, Ms. Naidu.
Is an accepted matter. Issue before this honorable court date termination. I have filed a movement. Tender notification, tender document I have filed. The page number 20.
Pass on. Serious end up in another.
Accepted matter.
Was present on that day.
Pass on.
Just seek it.
The accepted matter, he can't go before arbiter.
Can't. I just was not present on that day.
Yes, pass on. You were not present. Mr. Chanchud was present.
Yes, Malas, I didn't meet him morning.
Fresh matters, serial number 3.
Hmm. 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 There's no interim order that you saw. BMTCR.
HR Renuka.
HR Renuka is directed to accept notice for respond counsel for the petition serve 2 sets of the petition along with annexure and said counsel. IA 1 of 25 and 2 of 25 are allowed. Released February.
18th February. Serial number 4, Vachan GA.
Hmm. Hmm.
The owner of the vehicle, offending vehicle has not made a party to the claim petition. So I filed a application to stay the further proceedings until the conclusion of criminal proceedings.
Until the why should criminal this be stayed?
Because I am not the owner of the offending vehicle.
That you establish here. Criminal proceedings have nothing to do with these proceedings. It can't be stayed.
No, until the conclusion of the criminal proceedings.
Not necessary.
Because even the claim.
United India Insurance error.
So Janardhan Reddy.
Sri Janardhan Reddy is directed to accept notice for respond number 5. Notice to respond number 1 to 4 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. Claim petition under section 166 of the MV Act having been filed for compensation. The petitioner in MVC number 346 of 2021, the petitioner had filed an application under section 10 of the Code of Civil Procedure for stay of those proceedings pending the culmination of the criminal proceedings which had been initiated under section 279 of the IPC on the ground that the petitioner has been falsely implicated and the said aspect would have to be decided by the criminal court seized of the section 279 proceedings. The said application having been rejected, the petitioner is before this court seeking for the opposite reliefs. Having gone through the impugned order, having gone through the impugned order, I am of the considered opinion the same cannot be faulted with, inasmuch as the criminal proceedings and the compensation proceedings under section 166 of the MV Act can simultaneously proceed. If at all the petitioner has a defense as regards his identity and of the vehicle not being involved, it would be for the petitioner to establish the same in the civil proceedings. He cannot seek for the civil proceedings for compensation to be held up pending the criminal proceedings. Petition stands dismissed. It's a good try, but sorry.
Serial number 5, Sharath M.
Speak in the mic or speak loudly.
Milots, whereby kept the savings bank account as well as the fixed deposit of the petitioners without on stop status and fees, without issuing a notice first and without taking an order of any court or authority. They have unilaterally kept.
Where is the order?
There is no order in that. There has been no communication order. That's when I approached the Reserve Bank banking composition orders. That is when I forwarded on the basis of the case complaint filed by someone unrelated to the bank account itself. Because the State Bank of India has kept the account.
Who are you? Indian Medical Association.
I am the chairman and member of the Indian Medical Association board committee members. Fact is that
Where is the association? Association is not a party.
association, because Indian Medical Association, that account is a committee which was formed to organize a national conference here in 2011. There's a conference committee which was established. The funds to collect to organize a conference were opened in the Indian Medical Association Act. That was done by Indian Medical Association conference. It was pursuant to the completion of the national conference. Since there was money left over, 33 lakh rupees was left over in the account of the Indian Medical Association Act fund. The conference committee members, by minutes of they organized a core committee. It said in the core committee.
But you have not made the Indian Medical Association a party.
The Indian Medical Association members is not responsible for the account itself.
State Bank of India, Rama.
Sir, Vignesh Shetty.
So Vignesh Shetty is directed to accept notice for respondent number 1 and 2. Counsel for the petitioner served 2 sets of the petition along with annexures on the said counsels released February.
18th February. Serial number 6. Ajay Kumar.
There is no medical leave for lawyer. Inconvenience at that. In what is it? Notice on. So when do you want it? After vacation. Sri K. Krishna is directed to accept notice for respondent number 1 and 2. Counsel for the petition furnish 2 sets of the petition along with annexure and said counsel. The 3rd week of January. IA 1 of 25 is allowed.
22nd January. Serial number 7. Nagesh, yes.
The challenge annexure ENB.
ಯುದ್ಧ ಭೂಮಿ ಹೋರಾಟ ಯುದ್ಧ ಭೂಮಿನೂ ಬೇಕು ಹೋರಾಟನೂ ಬೇಕು. There is no interim relief you sought for. ಎಲ್ಲಿದೆ interim relief? ಏನು ಕೇಳಿಲ್ವಲ್ಲ. There is no interim relief.
ಕೇಳಿಲ್ಲ.
Sought for quashing of the order of the appellate tribunal. There is no interim relief you sought for.
Take R1 my lord.
And AGA accepts notice for respondent number 1. Notice to respondent number 2 and 3 is deferred for now. Released tomorrow.
Serial number 8.
Limitation. Issue notice to the respondents returnable by 27/1. Notice to respond number 2 is dispensed with in view of the memo which has been filed by the petitioner at the sole risk, cost and peril of the petitioner. Though the proceeding in MVC number so and so shall go on, so and so court is restrained from passing final award in the matter. Process fee and copies to be furnished by end of day tomorrow, 19th.
Serial number 9. Ravindra P.
Remission. And AGA accepts notice for respondent. Remission and parole or only remission? And parole. Released on 12th or 13th?
13th, sir.
13th.
Serial number 10.
Mr. Siji Malayali. HDFC Bank. Defreezing. And HDFC
Francis Xavier.
Francis Xavier for respond number 1, and AGA for respond number 2 issue emergent notice to respond number 3 and 4 returnable by 8/1/2026.
serial number 11, Manjunath Kasar.
ಬೇಗ ಹೇಳ್ಬೇಕು.
Issued by ordered by the CBC court and the issued by the capital machinery person. The challenge is that is the fact is that your lordship.
You have to challenge that order. You can't file a writ petition. It's not a Lok Adalat matter alla idu.
No. What happened?
Facts irbodu. The forum for you have to file an appeal. Criminal miscellaneous number.
So there is no appeal, only writ petition.
Only criminal.
The thing is that my lordship.
So 22 2014 ಮಾಡಬೇಕು ಅಂತನಾ? ಸಿವಿಲ್ ಸೂಟ್ ಇದೆಯಾ? ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಪಾರ್ಟಿಷನ್ ಏನಾದ್ರು ಇದೆಯಾ? ಹಾ.
The fact is that one.
The
respondent here is secured with death certificate. Saying that his mother was died in house number 140. He ended up Mysore. And he secured the non-available certificate from the corporation. And filed a series before the trial court.
Yes.
Trial court has perused the documents and said that and passed on the saying that the corporation has to incur the death data in the register and issue the death certificate regarding the mother. Wherein there is a procedure in Mysore City Corporation. Since 2010, there were 43 burial grounds in Mysore City Corporation. All the burial grounds are put compound fully and a gate with the watchman shed. In the watchman shed, a number was painted. Anybody wanted to bury the body of their family member, they have to go and contact the watchman and the intimate and along with the medical certificate and get the permission from the watchman and bury the body. And he will put the matter.
How are you concerned with this matter? Who are you?
I am the property owner.
How are you concerned with Suvarnamma? Suvarnammani?
Landlord. Put me in position and received his self-expression and cultivating property.
Is there a sale deed in your favor? So power of attorney has gone with the death of the person.
But that is the dispute here.
How can there be a dispute?
Because he is not secured the dispute properly managed.
Who are you, Mr. Counsel? You are only a power of attorney holder, which power of attorney has expired with the death of the person.
It has not been expired, Your Honor.
Not at all. Here.
Because there is a, I will submit to Your Honor. I will reach out to Your Honor.
Then Mysore City Corporation error.
Gaurav GK.
Gaurav GK for respond number 1, learned AGA for respond number 3, issued emergent notice to respond number 2, returnable by February.
18th February.
You are nobody in this matter, please.
12, Sukanya HD.
Register. And AGA accepts notice for respond number 1 and 2, issue emergent notice to respond number 3 and 4, returnable by end of January.
29th January. Serial number 13.
Post before a bench of which SGRJ is not a party. Wait, can you mention before drop bench or you'll have to mention before the chief? Chief will have to pass orders. Please follow up with the registry.
14. Hurley.
Petitioner applied for the renewal of passport model. He made an application on that as per the NHAE model. That application was not considered and issued notice model as a lawsuit can issue NHAE case 21 model. Now directed the petitioner to apply the fresh passport model. No reason whatsoever on that. You may have your lordship.
Please note that you have not yet submitted the required supporting documents as stated during your visit to PSK Bengaluru, which was more than 59 days ago.
We have that petitioner submitted all the required documents for that.
It be presumed that you are not interested and closure of the file.
Submission is that you invite into the office for that. The reason for refusal for that there is a criminal petition is pending. The criminal
Yes,
case is
madam.
registered against Karnataka.
What are the documents that you had sought for and
My
did you
lords, here
seek
since
for
the
it in
criminal
writing?
case is pending, we've asked for, they've applied for a normal passport, my lords. So we've asked for documents of acquittal in case there's an order, because it is a normal passport.
So did you ask
There
for it
is-
in writing or orally?
My lords, orally maybe.
Why orally? You should put it in
We'll
writing.
put it in writing, but this, since there is a criminal case already pending, we cannot proceed with a normal passport.
Fair enough, but look at the submission.
I'll instruct.
I don't know what it is. If you make that clear in your letter, they'll know what it is.
And I produce the FIR copy also of that. Petitioner brother wife has lost the 498 amount. She is the accurate number 5 month.
Is a charge sheet been laid?
No more.
Those documents you'll have to furnish. Nimatra itkondre yen prayojana illa, Mr. Ali. You'll have to give it to them. They also don't put it in writing. You also don't give it to them.
My lords, charge sheet is filed.
Charge sheet is filed.
Urgency is that mother. The petitioner daughter is residing in Australia mother. The baby was born mother.
Your urgency may be whatever, but you can't claim urgency without giving the documents. And directly coming to this court without, in petition, you are not even mentioned about the criminal proceedings. And charge sheet illa ant helli hedidira. Nothing you have said.
And my submission is that mother, even with the lordship can see that mother, that even criminal case is pending mother cannot deny renewal of passport mother. If this is get permission from the concerned police, it's not nice that mother.
That is what you should have mentioned in your petition. Otherwise, it is suppression.
FIR of produced and mentioned it mother. Petition mentioned the pending that court also mentioned. 11th ACR mother.
Don't make us get into it and get into. Yen, madam, there's a charge sheet late.
Charge sheet is filed, my lords. Now, we cannot issue a
Petitioner is
normal
implicated in the charge sheet.
There is
So now short validity. passport.
short validity with a travel permission in case there's a travel.
When you come, please disclose everything. Because all these matters are going scanned there, they're getting instructions coming. Otherwise, we'll have to just adjourn the matter and you won't get any relief. Don't suppress things. And suppression agogide ನೀವು ಸುಮ್ಮನೆ ಇದೆ. They are agreeable for a short validity, that is why you are getting the order. If they are not agreeable, you won't have got it. Ms. Reshma Tamaya accepts notice for respond number 1, 2 and 3. Petitioner is before this court seeking for the following leaves. Petitioner had applied for issuance or renewal?
My lords, reissue, my lords.
Reissuance of a passport which had expired on 3/8/2024, alleging that the said application has not been considered. The petitioner is before this court seeking for the aforesaid relief. Ms. Reshma Tamaya, learned counsel for respondents, submit that there is a criminal proceedings in CC number 1522 of 2020, which is pending before the 11th ACMM Court Bengaluru, wherein a charge sheet has been laid for offences under section 498 capital A of the Indian Penal Code, wherein the petitioner has also been implicated. And it is for that reason that the application could not be processed. Even if the petitioner is an accused in those proceedings, I am in the considered opinion that the right to travel being a fundamental right under Article 21 of the Constitution of India, and taking into consideration that the petitioner wants to travel to Australia, where the naming ceremony of a grandchild is to be held, the petitioner cannot be deprived of such travel. Of course, such travel would have to be subject to conditions and subject to prior permission and conditions that may be imposed by the 11th ACMM Court Bengaluru, seized of CC number 1522 of 2020. In that view of the matter, I pass the following order. Writ petition is allowed. Respond number 3 is directed to consider the application of the petitioner. Petition is allowed. A certiorari is issued. The letter dated 16/5/2025 at Annex H issued by respond number 3 is quashed. Respond number 3 is directed to consider the application for reissuance of the passport submitted by the petitioner in terms of the above observation and issue the passport within a period of yavatide.
Yeah, go and fix the date.
You have to go and fix. Within a period of 15 days from the date of receipt of a copy of this order. The travel of the petitioner shall however be subject to prior permission to be obtained by the petitioner from the 11th ACMM Court, Bengaluru, in CC number 1522 of 2020 and subject to such condition as the said court may impose on the travel of the petitioner.
BM Siddhappa.
May I please, Madam?
Yes, Mr. Siddhappa.
Madam, one food inspector has filed a complaint against petitioner and 10 others, stating that the petitioner used the login ID of food inspector and uploaded ration cards for having sold the property, against which they lodged a complaint with the police. The police have investigated and filed the B report. And B report has been accepted by the trial court. Even notice has been issued. They have not filed any objections and not contested. On the same footing, the respondent has passed the order assigning the same reason that you have misused the ID. They have not.
Same reason.
Same reason.
AGA accepts notice for respond number 1 and 2. The operation and execution of the order passed by respond number 2 in case number so and so dated 2/8/25 at Annexure E is stayed since on an earlier occasion a similar complaint had been filed investigated by the police. A B report submitted had been accepted by the court seized of the criminal proceedings.
Lord, this order is passed subsequent to the order of this honorable court.
Once the investigation is done,
Lord, two investigations, that is a criminal investigation, Lord. You were on the report madbittu, it is proved that he has done that anta.
Place it on record. Especially once the B report has been accepted and you are not challenged.
I agree, but they have conducted internal report, it is proved.
How can that be?
Serial
Police
number
investigation, you don't want to accept. Again, you will conduct one more.
16.
Yes, Arun.
For the respondent, you are one.
I own property of Jersey Road, which is about 4,500 square feet. My watchman that I had installed in the premises is now refusing to move out. He filed a suit for injunction against me. Initially, temporary injunction is granted on the basis that he's a tenant. An injunction is vacated. Then he files an MFA. MFA is dismissed with a specific finding.
Is there a direction for police help granted by the court?
No, but there's an observation made in MFA that he has to hand over possession on demand.
Page?
At page number 109. Para 23. Mary.
You have to execute this. You can't ask for police help.
But execution, I am not the plaintiff. So the Honorable Supreme Court holds due process of law is observed either when the occupier files a suit to protect his possession or the owner files a suit for ejectment. In either of these cases, the due process of law will be fulfilled.
He had filed a suit for injunction which came to be dismissed. You are the defendant. You want now for police help to evict him. You have not taken any proceedings.
I'm not required to. That's what his lordship says in page number 109.
Yes.
Para 23 This Maria identical fact.
Yes.
In view of the second position of law, as held in case of Maria Margarita Square of United, the plaintiff who was admittedly permitted by deceit to stay the portion of the fruit property for the purpose of taking care of the said property, continues in possession of the property only on behalf of the defendant. The plaintiff cannot be held to have acquired any interest in the property and is under an obligation to hand over possession to the defendant on demand Hence, it's clear that the plaintiff cannot seek injunction against the defendant. But the Honorable Supreme Court can.
So where is the demand? And after the demand, what is the process to be followed?
I have mentioned in the writ petition, filing of suit not in a humble submission is unnecessary because the Honorable Supreme Court says only one paragraph with the Lordship's permission. Otherwise, we're not a watchman, we're not holding on to
Even a trespasser.
against true owner.
Even a trespasser against true owner.
Settled possession. That's exactly the issue that was decided by the Honorable Supreme Court.
We'll issue notice and we'll come back. We can't grant you this ex parte. It is as good as allowing your petition. And AGA accepts notice for respondent 1 to 3, issue emergent notice to respondent 4, returned by February.
Not. I entered into a joint development. The entire issue started from saying joint development agreement with the previous.
At present, we are not even convinced with your position. We'll have to hear the other side. Until that, nothing can happen. You let the service happen. Service won't happen.
I will also serve behind some.
He's so close to you that you'll.
I've known him for 20 years as a watchman.
You are at dispute with each other. We can't give you answers. Next.
We request January some date, third week of January. Request.
17, Ravi Shankar.
Almost 2 years is holding on, my lord.
Yes, good.
First.
Yes, next. Yes.
And in the year 2021, my lord, the respondent number 1 constituted managing committee for Anjuman-e-Imamia for a period of 3 years, my lord. Now, my lord, the time has been expired, my lord. Annexure E, page number 44 is the approved bylaw, scheme administration bylaw, my lord. As per the page number 44, my lord.
Yes.
Annexure E, my lord.
Yes.
This is the scheme of administration and bylaws. Then, my lord, subsequently, my lord, the board of meeting held and on 17/11/2025, my lord, at page number Annexure D, page number 40, my lord. The resolution is that, my lord, at
page number 40.
40, my lord.
This is on
17 September 2025, my lord. Resolution at page number 41, my lord. May I read, my lord? Resolution. The matter is discussed in detail and it is unanimously resolved to appoint Sri so-and-so enrollment officers to enroll the members to the above work institution within the jurisdiction of mentioned in the above approved scheme of administration within a period of 2 months and submit the voter list to the board within that period. After the resolution, my lord, the enrollment officer has issued notification at Annexure A, my lord. The Annexure A is contrary to the approved bylaws, my lord.
How is it contrary?
Contrary, my lord, at page number 19, my lord, of Annexure A, my lord, regarding subscription of the payment, my lord. Ordinary members, page number 19, A, my lord, ordinary members, my lord. By paying 720 as non-refundable towards 3 consecutive years annual subscription of rupees 20 per month, so and so, my lord. This condition has not been forthcoming in the approved bylaws, my lord. As per the approved bylaws, my lord.
What is the subscription rate?
At page number 45, my lord. Ordinary members shall pay minimum monthly subscription of rupees 20. There is no 3 years condition imposed in the approved bylaws, my lord. One another violation is that, my lord, regarding documents, my lord, at page number 19, my lord, documents to be submitted along with application form by all the ordinary members, life members and the pattern members. There are 8 category has been imposed, my lord. As per the approved bylaws, only
any one of the following documents.
Please, my lord. As per
one Kodi.
As per the approved scheme, my lord, at page number 46, applications for membership, my lord.
Yes.
ID proof, that is third line, my lord.
Yes.
Other
voters ID and driver's license. The permitting even passport and bank passbook.
Ration card and other things has been inserted. Moreover, my regarding
Supreme
payment
Court has now permitted 13 documents to be considered as identity proof.
Please.
It's fine. You can't find fault with that.
Insofar as subscription is concerned,
subscription of 3 years, let us hear them why they want to do that.
Now, my lord, I am seeking.
When is the elections have not been announced? It's only enrollment.
30 is the last date, my lord. 30 of this month.
Thirtieth ಎಲ್ಲಿದೆಯಪ್ಪ? 30th of January 2026, last date.
Please,
January, not this month.
Corrigendum.
Page 17.
Then now, my lord, corrigendum has issued, my lord, at page number 21, my lord.
21.
21. 30th December 2025 is the last date.
Shri P. Usman is directed to accept notice for the petitioner, for respond number 1. Issue emergent notice to respond number 2, returnable by January 2nd week.
14th January.
The operation of Annexure A, insofar as the demand made for 3 consecutive years annual subscription is stayed till the next date of hearing. However, it's made clear that the payment of subscription fee by ordinary members as required under bylaw 5 of the bylaws of scheme of administration stroke bylaws of the Waqf shall be adhered to by all concerned.
Please, ma'am.
18th, Dharani Krishna.
Appearing for the petitioners, my lord, the petitioners are residents of Chamundeshwari layout, ward number 12, which is previously numbered as ward number 10, Belhanka zone. So my grievance is about one RO water plant that is operated by a contractor under a contract from BBMP. This contract was issued issued in the year 2015. Since then, there was no fresh contract that was issued, and moreover,
Shri Venkatesh Arbati is directed to accept notice for respond number 1. And AGA accepts notice for respond number 2. Counsel for the petition furnished 2 sets of the petition along with the annexure said counsel released on February.
18th February.
My lord says probably by the end of January as possible. There is a time bound. There are dues to the tune of over 10 lakhs for the past 5 years.
Instructions.
19th Vijay Kumar.
And AGA accepts notice for response. She seeks for and is granted 2 weeks time to obtain instruction, make a submission as to whether the petitioner is functioning at the concerned location.
The respondent has rejected my application.
Next one.
Next one, we have already adjourned your matter. At the current location whether compliance have been made with the applicable rules. Released on
22nd January.
2nd January.
The respondent has rejected my application.
Rejected.
Rejected, madam.
Ek rejection agiradu. Why is the rejection?
Insisting the petitioner to get NOC from the respondent, my lord.
Who is the
respondent? Are the police and Gram Panchayat, my lord.
You'll have to get all the permissions from the Gram Panchayat.
14th.
Building plan sanction thondidira? Have you obtained the plan sanction?
Building for registration, my lord, but refused to register the document saying that.
Seeing all these matters where sheds are put up. Not, what have you done here? Have you obtained the building plan sanction? Gram Panchayat in the license ella thondidira? Have you obtained any license? Trade license ella bekala?
Resolution has been passed. Resolution has been passed.
Your resolution may be passed by your club, but you have to comply with the other applicable rules. Have you complied or no?
In section, madam.
But the writ, his prayer may be seen, my lord. Writ is not maintainable. When endorsement is issued, then he did not challenge it. He sought a mandamus again, same thing, my lord.
And not to insist upon license can't be granted. Not to insist upon license cannot be granted. And AG accepts notice for response 1 to 6. Notice to respond number 7 is dispensed with view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. Essentially, what the petitioner seeks for is to grant permission to the petitioner to run a recreation club without obtaining any license from the concerned authorities, including respond number 7. It is but required for the petitioner to obtain such permission from respond number 7 as are applicable, including building license, plan sanction, building license, occupation certificate, barala, building license and trade license for carrying out such activities as the petitioner intends to do. Same not having been done, the petitioner cannot insist that the respondents have to permit the petitioner to run the recreation club without such license. In that view of the matter, no grounds being made out, petition stands dismissed, reserving liberty to the petitioner to approach the concerned authorities, obtain the necessary license, and thereafter approach the respondent.
20 also same.
Even 20 also same. 19 and 20.
My lord, in this petition,
Continue.
My lord, society has got a registered, my lord.
You can,
But
that is
my lord-
your first step of calling the resolution, passing the resolution. Admiral, you have to get
I
all
will
the
get the
permissions.
instruction in both matters because, my lord, I don't
You
have
get the
any
permission, then
information.
apply. If you have the permission, you apply. They'll consider it.
Till
the
then, my
same
lord,
21.
get the instruction, that's why, my
Narendra
lord. Whether
19 and 20,
licenses
AG
obtained or
access
not.
notice for respondent released on 22nd.
In both matter, my lord.
This was not, both matters.
Please.
If you have placed the licenses and permission that you obtained, then we'll direct them to consider.
Please. My lord, serial number 15, my lord. Kindly hand delivery may be added, my lord.
15.
15, my lord. BMC.
15 and delivery.
21.
Secretary for the petitioner. For repeated, my lord, police notices, my lord, issued by BMTF, stating that, my lord, there is encroachment of a Bikara footpath. My lord, I am developing, my lord, a layout. There was a footpath, my lord, running across the property, for which, my lord, that has been realigned, my lord, pursuant to the sanction by the government, and, my lord, with the order passed by the Tashildar at annexure. Yes,
130/1 also Road, Purvankara.
this is subsidiary, my lords.
Place, post matter before a bench of which SGRJ is not a party. You should bring it to our notice. You should not be doing this.
No, it was subsidiary, my lords.
Just because the name is different,
I'm sorry, my lords.
bring it to our notice.
Lord, I'm sorry, my lord. I did not know this particular company,
There
my
is
lord,
the same.
recently formed, my lords.
It doesn't matter.
Yes, yes.
It's a subsidiary.
It's a subsidiary, my lords. It's a
Still
subsidiary.
look at the cost title.
Yes.
But
The
name is
registered
different.
office is the same, but recently, my lord, it has been
Your
acquired.
client not to do this.
Well, I'm sorry, my lords. Lord, your lordship may kindly, for tomorrow, my lord, there's some
You can't
urgency.
do that. You follow it up. You can only say post before a bench of which SGRJ is not a party.
Some urgency, my lord, that is.
If you had done it rightly, it would have gone before the right bench. You have
Lord,
tried.
No, my lord, this is, my lord, I'm sorry, my lord, I'm sorry.
22. GS Muralaya.
Issue notice to the respondents written up by 27/1, though the proceeding in MVC number so and so shall go on. So and so court is restrained from passing the final award. Process fee and copies to be furnished by end of day 19, failing which the interim order will stand automatically vacated.
23. KV Narasimhan.
Here for the petition. Clause 16C, my lord, is the tender condition, page number 30.
Page number?
30, my lord, 30. 16C, my lord. Hitherto, what, my lord, was being done is, I was being permitted.
30, there's no 15. A, B, C, D there.
C, my lord.
16C. Okay.
Yes, my lord, please. The bidder should have carried out repair of failed distribution transformers of at least 708 numbers, totaling in any of the capacities ranging from so and so kVA in any of the 5 preceding financial years. In BESCOM, my lord, is the restriction that is made now.
Oh, idu. A, B, C, D, matte B and C.
B and C, please. I'm on C, my lord, after B.
Which C are you?
My lord,
The first C or the second C?
The second C, my
Second
lord.
C.
Pardon.
The bidder should have carried out repair.
My lord, hitherto, my lord, in any of the ESCOMs, my lord, had I done the work, my lord, they would be considering. My lord, I have been repairing the transformers, my lord, in other ESCOMs. The very same tenders, my lord, which were passed by the BESCOMs, my lord, permitted such a participation. This is the first time, my lord, that they are restricting it to the BESCOM limits.
Let it continue within BESCOM.
In BESCOM, please.
Who has issued this?
Vellore issued by BESCOM,
BESCOM.
please.
When is the final?
My
last
lord,
date?
the bid, my lord, 29/12/2025 is the final
They
bid.
are BESCOM here.
HV Devraju.
HV Devraju is directed to accept notice for respondent number 1 to 3, counsel for the petitioner to serve 2 sets of the petition along with annexure and said counsel released tomorrow. I 1 of 25 is allowed.
Preliminary hearing.
In preliminary hearing. ನಾಳೆ ಎಲ್ಲ ಬರೀ preliminary, no B group will come tomorrow. ನಾಳೆ ಯಾವುದು B group ಬೇಡ. ನಾಳೆ only last half day. Only second list.
24.
My lord, and for the petitioner, my lord. My lord, the fifth respondent assaulting us to the petitioner 9/12/2025 at around 9:30 PM, my lord. The petitioners went to the Kenji hospital, my lord. Can you see, my lord? Page number 24, my lord. This is the MLC issued by the, my lord, KCH hospital.
Where is the wound certificate?
That is the MLC, my lord.
MLC, page?
Page 24, 24. 24. Annex C, my lord. Alleged assault by one Shivashankar. The now matter referred to the surgery. The patient referred to the surgery, my lord. The matter very serious, my lord. Then police not registered the complaint against the fifth respondent, my lord, despite complaint. D also, my lord. Annex D, the son of the petitioner.
CT of brain, chest.
Please, my lord.
But I will take notice and the instructions may submit
Tomorrow.
Obliged.
And AG accepts notice for respondent number 1 to 4. Notice to respondent number 5 is deferred for now. And AGA seeks for a day's time to obtain instruction, make his submission.
Great, my lord.
As regards the status of the complaint filed by the petitioner.
Please.
25. Sunita PC.
Respondent number 1.
Lord, I appear for the petitioner, my lord. My
ಏನಿದೆ?
lord, ಇದು,
Regard to apportionment
mother
of-
apportionment is only challenged by the petitioner, my lord.
Hmm.
Mother-in-law, my lord, has filed a claim petition before the MACT, my lord. There, my lord, when the matter is set down for cross-examination of the petitioner, my lord, they, caveated herein has filed an application order 1 rule 10(2), my lord. That was without hearing me, was allowed, my lord. I have not challenged. Then thereafter, it was referred to Lok Adalat, my lord. Joint memo is filed by the petitioner and also caveated herein, my lord. Claim for full and final settlement of 20 lakhs, my lord. Thereafter, my lord, they filed a memo for apportionate of the amount, my
Where is
lord.
the joint memo filed before Lok Adalat?
Section D, my lord.
Page?
Page, my lord. Is at 34, my lord.
Annexure Jyoti, just give us the page number.
Page number 34, Annexure D.
4.
34, my lord.
And page
The petitioner having filed the claim petition claiming the compensation on the account of injuries or damages or an account of the death of the legal heir, the respondent insurance company has agreed to settle the claim.
You
as
are
full-
also a party?
Yes, my lord. I am the first petitioner, my lord.
Yes. Your
Full and
thumb
final
impression.
settlement, my lord. Thereafter, my lord, they files a memo for apportionate. After that, my lord, they files an application for claiming full compensation amount, my lord. That is not for me. Even then, my lord, they have not proved the dependency or estate, nothing, my lord. Only on the ground of
Now petitioner is the,
first petitioner.
petitioner is, who is the petitioner to the deceased?
Mother-in-law, my lord, mother-in-law,
Mother-in-law.
mother-in-law.
Mother-in-law of the deceased.
Please, my lord. I have filed the claim petition, my lord.
And
In the-
petitioner number, respond number 1?
They claims to be the legal heirs of
Mother and
deceased, my lord. Father
They
and
claim
mother.
to be andre artha ಏನು ಮಾಡಿ?
Father and mother, my lord.
Correct ಆಗಿ ಹೇಳಿ. Don't try to do this.
No, my lord. Claim,
Don't try to say mother is,
ಇಲ್ಲ, ಇಲ್ಲ.
they claim to be.
ಇಲ್ಲ, legal heirs ಅಂತ.
So respond number 1 is the mother.
ಅಲ್ಲ, 2 and 3, my lord. 2 mother, 3 father.
Respondent
Respondent
in this petition.
Petitioner 2, 3.
Respond number 1 is the mother, respond number 2 is the father.
Father.
Where is the daughter? Where is the wife of the deceased?
Lord, deceased is Soumya. In a
Soumya,
motor
my lord,
vehicle
she's-
accident, husband, wife, children died.
All of them.
4 petitions
pe-
were
four.
filed. One petition filed by the respondent number 1 and 2 came to be withdrawn with liberty to make an application in MVC 73/24 for impleadment. They came on record as petitioner number 1 and 2. My lord, so far as the other 3 petitions are concerned, the death of son and my lord, grandchildren are concerned, the petitioner has received, my lord, sum of rupees 30 lakhs, in which, my lord, the respondent number 1 and 2 have not claimed anything.
So you're claiming only on account of your daughter.
Please.
What is the apportionment made now?
90% and 10%. 90% to the
And,
father
pity-
and mother, 10% to the.
When joint memo is filed before the Lok Adalat, my lord, question of, my lord, the kindly see the reason, my lord, given by the.
When you're doing the joint memo, you should have worked out the apportionment at
ಅದು
that time.
ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಮಾಡ್ಲಿಲ್ಲ.
You have advised properly at
ಇಲ್ಲಿ
that time.
ಬಂದ್ಬಿಟ್ಟು ಡಿಪೆಂಡೆನ್ಸಿ and estate they have stated, my lord. They were, even then they were not proved before the trial court, my lord. Even there is no material was placed before the.
Is there any possibility of mediation and settlement?
So far as the other 3 petitions are concerned.
Other, they have no legal right, my lord. They have no legal right at all.
Is there a possibility of a settlement if we refer to mediation, or you want us to decide whichever way you
And
tell us?
efforts were made before the tribunal. It did not materialize.
Efforts were made by whom?
By the councils and the parties.
So is there a possibility on mediation?
Please, my lord, it may be referred to the mediations, my lord.
We will make an effort.
Just because you're sitting on 90% doesn't, don't.
Please, my lord, we'll make
If
an effort.
90% may become zero also.
Please. Because the.
Because she is a blind, my
You
lord.
are basically at the most coming under section 15, which won't happen.
The trial court considering all these aspects.
So don't sit on 90% and say,
even otherwise, my lord, the respondent would have been entitled in the other petitions. They gave up everything.
obviously you are not going to be entitled there.
My lord, grandchildren so far as under the estate
How are you entitled there?
would have been entitled, my lord.
Then you are advising your client wrongly. Please advise them properly.
And they received 30 lakhs.
Please advise them properly. Whatever they have got also they may lose.
And will advise.
They may lose. Just because there's a wrong order passed, you can't sit on that wrong order and claim I'll get 90%.
Will work out.
It's an explicitly wrong order. In terms of apportionment of 90% is explicitly wrong. We can set it aside, or we can allow you to go for mediation.
We'll make an effort in the week.
Settle it properly, so all of you can walk away happily.
We'll make it.
P. Mahadev Swami, who has filed caveat for respondent number 1 and 2, accept notice for respondent number 1 and 2. Shriram General Insurance, Yarama.
This is Shivannegowda.
Shivannegowda accepts notice for respondent number 5. Notice to respondent number 3 and 4 is
Maybe
dispensed
dispense
with,
with, please.
since the issue involved is only as regard apportionment, which is a dispute between the petitioner and respondent number 1 and 2, as regards which respondent number 3 and 4 would have nothing to do. Both the councils submit that if the matter is referred to mediation, there's a possibility of amicable resolution being arrived at, considering that the dispute is between the in-laws, the parents and in-laws of the deceased, and the considered opinion that this is a fit case for the use of mediation tools to resolve the dispute between the parties. As the matter is referred to mediation, the director KMC is directed to appoint a suitable person as a mediator to try and resolve the dispute between the parties amicably. Since the order is passed in the presence of both the council, they shall appear before the director KMC on
First week of January.
Next.
January na December
January.
1st.
6th January at 2:30 p.m.
Please, my lord.
Released on March.
Before that, my lord, annexure may be stayed, my lord. Annexure
Pending
A.
consideration of the over petition.
So far as interim order is concerned, my lord, and since it is referred, they will take advantage and drag on the proceedings.
No, my lord, we'll not drag
We
on.
will not withdraw.
We'll not drag on, we'll
will not
present.
withdraw.
Commission will place it on record.
Please. We will
It's the
not.
same thing as the interim order. We have to grant the interim order when it's going for settlement. the submission of learned counsel for respondent number 1 and 2 that they will not withdraw any amount which has been which is held in deposit before the MACT is placed on record.
Lord,
Please, madam.
refer to the collegial mediation center. All the parties are from collegial taluk.
Please.
Much obliged.
10th March, serial number 26, Agra Jayan.
My lord, it's a tender matter, my lord. Transportation of food grains, my lord. As per the tender notification, the condition is, my lord, the quintal of the, per quintal, they have charged 47.77 paisa, my lord. But when the petitioner was uploading the application in e-procurement portal, it was showing 44.77.
Page number really, where
Mala
is this?
28, mala, page number 28.
28.
In table, mala. Cost per quintal 47.77 paisa, mala.
Really the cost per quintal. This is for transport.
Transportation of food grains.
Cost per quintal of transport is 47 for
77 paisa.
8 kilometers.
Yes, mala.
Hmm.
But when the petitioner was uploading the application, it was showing only 44.77.
Where is the printout of that?
I have produced here, Malan. Can you see the page number 67, Malan?
Page?
67. This is the first petitioner application, Malan. In that ECB INR is 44.77. In all three application also, it's taken 44.77 itself, Malan.
This is filled by you or system?
It's filled by me, Malan.
Huh.
But in a e-procurement portal, it was taking only 44.77.
How can that be, madam? When the tender documents are there, you are aware of this.
Yes, my lord. But it was taking 44.77. All the petitioner, three petitioner has uploaded, my lord.
Not possible. Let us ask them if there is any.
No, my lord. It's not a type of
Committed by the petitioners.
No, my lord. It's not.
No, para 6. It's apparent it seems to be a mistake by your client.
No, my lord. Procurement portal only has taken 44, my lord, because three petitioners, my lord. It's not done by a one petitioner. Three petitioner also filed 44.77 itself, my lord. Page number.
Verify and make your submission. And AG accepts notice for respondent number 1 to 4, seeks for a day's time release tomorrow. Mugdogidya. When was the last date for the tender?
Page 14, my lord.
Tender has been issued. Work order has
I'm
been.
making out.
Place it on record tomorrow. Release tomorrow.
In fresh matter list.
In in preliminary hearing.
Grateful.
27.
For the petitioner
The
in this
one of
matter, my
25.
lord. My lord, the show cause notice is at page, annexure A, my lord, page 29. My lord, my foreign contribution regulation license comes to be suspended by virtue of the show cause notice cum suspension order, which is dated 4/12/25. My lord, there's no inquiry pending against me and no allegations whatsoever until 4 December 2025 was ever made. Summons were not issued. Notice was not issued with respect to any pending proceedings. Such being the case, my lord, all of a sudden 4/12/25, they issue this show cause notice cum suspension order, wherein without, my lord, any basis or any
Shanti
proceedings.
Bhushan and DSJ is directed to accept notice for respondent number 1 and 2. Counsel for.
Well, I'm
You're already there.
I'm ready. I have the.
Ready. Ready.
Yes. Lord,
Show cause notice issued, heard.
no. Show cause notice has been issued. We have not received any reply.
You have issued.
Yes. What is challenged is the show cause notice. Please have a
Show
look
cause
at.
notice.
It is a show cause notice.
Cancellation.
Suspension order.
Lord, please have a look at page 29.
Yes.
Yes.
It is a show cause notice.
Come suspension
Come
order, my
suspension.
lord.
Yes, you reply to them.
Please, my lord, however, in fact, they've issued a
There
show
is
cause
suspicion
notice.
right now.
Please, my lord.
We
Please.
can't allow you to carry on the receiving the money and
So,
transacting.
my lord, the suspicion
lord,
is of
I-
seriousness. My lord, would your lordship kindly have a look at para 4 in that order? And whereas the activities of the association are in
Yes.
para 4. My lord,
We saw
I-
that.
consonance with so and so purpose specified in the registry which attracts violation of section 24F6 and then not 5. And whereas the association's aforesaid activities are in violation of section 2456 and 18 of FCRA and rule 17, therefore FCRA registration of the association is liable to be cancelled under section 14. Further, to stop misutilization and illegalities, FCRA registration needs to be suspended pending consideration of decision to cancel. Now, please have a look at 12.4, my lord.
We are
of,
only
the-
permitting them to submit a reply.
Yes.
When will you
My
submit a
request
reply?
is
Immediately
this.
pass on within 1 week. my lord.
My lord, my request is this, my lord. I have staff salaries to pay, my lord, regardless of the allegations made. That,
Staff salaries will be paid in the first week of January.
my lord, please,
When
last
will you,
week
when
of
will you
December.
reply, madam?
My lord, if I may kindly submit, my lord, I have made a requisition to them along with a reply. Now, my lord, this is not substantiated at all. I'm not even aware of what are the allegations against me. Section 12.4 is what they invoke. 12.4 F6 indicates, my lord, that harmony between religious, racial, linguistic groups is being affected. That is the ground which they have invoked to issue the show cause notice come suspension order. Now, my lord, I am only working with garment factory owners and I am only investing these funds which are received.
Give them the reply.
I-
There's only a show cause notice.
Please, my lord. Now, since yesterday I have in fact issued a response and I've
You have-
also.
You
Please,
already given a response.
Please, I've issued the response and I've made a
How many days will
requisition.
you pass the order?
2 weeks. 2 weeks. Before first week January.
ಇವಾಗ
that-
1 week ಅಂತ ಹೇಳಿದ್ರೆ ಇಲ್ಲ.
ನಾನು 2 weeks.
MN Kumar ಕೇಳಬೇಡಿ. MN Kumar, don't listen to it.
2 weeks.
My lord, in
You
fact,
just said 1 week. We are thinking of giving you lesser time.
10 days, middle ground.
1 week is what you said already.
please.
Petitioner
the
is
act,
before this court
may I-
seeking for the following reliefs. What is essentially challenged is the show cause notice comes suspension order. Learned counsel for the petitioner submit that though a reply has been issued yesterday,
Please.
the operation of the petitioner, more so in regard to payment of salaries to the employees, is been adversely affected.
Please.
Learn ASGI submits that the reply which has been furnished would be considered.
I have not received any confirmation of receipt of the reply. Lordship.
The
may record
reply, if received, would be considered within 7 days and necessary
from the
orders.
date of receipt. From the date.
If received, please allow us to pass. The reply, if received, orders would be passed thereon within 7 days from the date of receipt. The said submission answers the grievance of the, would answer the grievance of the petitioner in as much as the salaries, if any, being required to be paid would be in the first week of January. Hence, the orders, if any, passed by the respondent would be before that date.
Please, my lord.
Placing the submission of learned ASGI on record, the petition stands disposed.
Correct.
In fact, you lost 1 day. Receipt is yesterday.
No, it is dispatched yesterday is what is said.
It's issued. They'll receive it today, my lords, for sure. I'm grateful. my lord.
28, Ajit Kalyan.
Yeah, for the similar matter, my lords have
Similar matter in the ENS.
disposed. This is with regarding to Ashraya screen.
Ashraya.
Mandamus.
Akkupatra and.
Yes, ma'am.
Yeah.
Could be same. Yesterday it was.
Same order.
29,
Here for the petitioner, my lord. Petitioners have challenged the notice issued by the second respondent directing them, my lord, to hand over the possession of survey number 245/2, my lord, and purported exercise of power under section 4(1) of the Karnataka Public Premises Eviction Act.
Public premise.
Yes,
This is SLO.
yes. He is not authorized, my lord. I have the notification. Secondly, my lord, under the act, my lord, if he is an authorized officer, he has to give a notice. Hold an inquiry under the Karnataka Public Premises Rules.
Yes.
And thereafter he pass an order, my lord.
Where's
Straight away he passes
where's
the
this
order.
order?
Annexure A is the order, my lord. Page 27, my lord.
Bhuswadhinadhikari, Mysuru Abhivruddhi Pradhikara, Mysuru. He is not the.
He is not
estate
the authorized officer, my lord. I have all the notifications in this book, my lord, wherein he is not designated an authorized officer under section 3. My lord, this land, my lord, it doesn't belong to the authority, my lord.
That is a different issue.
Yes.
Whether he is authorized or not.
He's, my lord, I have the notifications, my lord, I have make it available. These are the notifications.
Learned Sri T.P. Vivekananda is directed to accept notice for respond number 1. Learned AGA accepts notice for respond number 2.
Like both are same.
Spacey can't be the same.
It is.
SLO is always the state.
Yes.
Ex-spacey, a perusal of Annexure A series indicates that the notice for eviction has been issued by the Special Land Acquisition Officer in his capacity as a Special Land Acquisition Officer, not as the Estate Officer or the designated authority under Section 3 of the Karnataka Public Premises Eviction of Unauthorized Occupants (Close) Act 1974. In that view of the matter, the operation of Annexure A series A1 to A14 issued by the second respondent dated 3/12/2025 is stayed till the next date of hearing. Learned AGA to secure instruction make a submission as to on what basis respond number 2 has issued the said order notices stroke orders. Relist on
Office, I'll give it right now.
Relist on say third week of January.
Please.
22nd
Just for
January.
hand
One of
delivery.
25 is allowed.
Hand delivery.
And delivery order.
Please, grateful.
30.
My lords, and for the petitioner, my lords, the petitioner is challenging the actions of respondent number 1 and 2, my lords. They have frozen the bank account of the petitioner, my lords. Respondent number 2 has received a complaint. It's based in Gujarat, my lords, Mehsana Taluk.
Where is the complaint?
My lords, I don't have the copy of the complaint, my lords.
Where is the communication from the bank?
My lords, it's in the Annexure B, my lords. It's at page number 40, my lords. Pardon, my lords. Page number 43, my lords, of Annexure B.
That's the reply to you. Where is the first order communicating?
My lords, nothing has been communicated to me, my lords, except for these, my lords.
Kindly find bank, page 40 you have produced it. Tier 2 transaction.
Yes, my lords, there are two.
Transaction is 50,000, disputed is 15,000.
This was given by the bank, my lords.
And another dispute is 10,000.
Yes, my lords.
Your layer 8 there.
My lords,
So
the
it is
coordinate bench
25,000.
has, in the similar matter, my lords, it's covered by, my lords.
Indus-Ind there.
The Nataraj
Nataraj for respond number 1, issue emergent notice to respond number 2.
My lords.
Returnable by so and so. The grievance of the petitioner is that despite they've frozen it only to 25,000.
No, my lords. He's not been able to withdraw any money, my lords. Also, this is his salary account, my lords. On a monthly basis,
That will
his
be
salary is
considered
being-
later.
My
You are
lords.
playing online games.
No, my lords, no, my lords.
That is the reason why a
It was
lot of
sent-
this
no, my
freezing
lords.
is happening.
This was sent by an unknown person, my lords. We have no,
Unknown person sent money to you.
my lords, that is the instruction I got from
Good
petitioner.
friends you have.
My lords, the thing is, my lords,
Ask your, one of the reasons that finally we found out
No, my
now
lords. He has
is
no
because
objection,
these
my
online
lords.
games and the
he will cooperate with the investigation as, my lords. Till
grievance of the petitioner is that the entire bank account of the petitioner has been frozen, though the request made by respond number 2 is only to an extent of 25,000. In that view of the matter, respond number 1 is directed to restrict the lien on the account of the petitioner insofar as the lien notices received by the respond number 1 in respect of the bank account of the petitioner relist on so and
My
so.
lords, if I may place this on record.
Not necessary.
Please, my lords.
31. Naveen Jayan.
31, my lord, I will take notice. He has challenged the virus of the Rules, my lord. So the reservation fixing my lordship for the SC/ST, 24.1% without fixing any reservation for the women category.
The reservation is only for societies.
Societies.
Nobody else gets reservation. Individuals are not considered.
I will take notice, my lord, in rules, my lord, in Transparency Act, this honorable court has upheld that.
What the petitioner has challenged the amendment brought out to clause 6 of the Karnataka Essential Commodities Public Distribution System (Control Order 2016) issued by respond number 2. Issue notice to the learned Advocate General, learned AGA accepts notice on his behalf. He also accepts notice for respond number
all the
1, 2, 3, 7. Counsel for the petitioner to furnish 2 sets of the petition along with annexes on the learned AGA and the AG's office. Relist on February 1st week. IA 1 of 25 is allowed.
Short date. They are contemplating to issue, my lordship, a short date.
They have to file their objection to a challenge.
Please.
They won't file it.
32.
In this case, I appear for petitioners, my lord. This also Ashray Yojana Akupatra issued, my lords. Annexure B, my lords, your lordship kindly look at it. In page number 29, my lords, there was the inquiry, your lordship. You read it, my lord.
Where is the representation that you have submitted?
Representation I am making now, my lords. That
Is
earlier
memo-
point of view, Ashray Yojana Nivasigala Sangha has made representations, my
Where
lord.
is the representation?
They have made, my lord. So in Sangha, for and on behalf of.
If you don't give us a copy, if you don't give them a
511
copy,
order
how are they
make
going to act on it?
Representation is there. They ಕೊಟ್ಟಿದ್ದೀವಿ. ಈಗ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
Last time you sought for time to furnish the representation.
Amendment ಮಾಡ್ತೀನಿ, representation ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ. ಅದೇ ಹೇಳಿದ್ದು sir.
ಇವಾಗ ಹೊಸದಾಗಿ ಕೊಡ್ತೀರಾ?
ಹೌದು sir. Please consider.
Let him give it.
Lord, I have instructions in some of the matters where these Hakkupatras are issued, my lord. Tahsildar told that they are all fake Hakkupatras. So,
an
my lord,
order.
very cautious in.
Pass an order.
Please, my lord.
Not only that, if it is fake, take action.
Please, my lord. We
Definitely,
are doing that,
definitely.
my lord.
Now, in terms of annexure
But if it is
B,
genuine, please give
Please,
it.
my lord. That will be.
Please.
Petitioner is before this court seeking for the following.
In this matter, there is no representation.
Adi-
Please.
He is going to submit a representation.
representation ready.
A mandamus, what has essentially been sought for is a mandamus for allotment, for issuance of allotment letter and handover of possession to the petitioner. On inquiry with the learned counsel for the petitioner as to whether any representation had been submitted to the respondent in that regard. Today, he fairly concedes that no such representation had been submitted. In that view of the matter, reserving liberty to the petitioner to submit a representation, if so advised, the petition is disposed, directing the response to consider the said representation within a period of 60 days from the date of submission of the representation. It's made clear that this court has not expressed any opinion on the entitlement of the petitioner.
Much obliged.
Obliged.
33. Abhijit Sharma.
Although I appear for respondents 8 to 10.
Yes.
Your lordship had initially kept this matter for 28th of January.
Why has it been moved?
My lord, they have filed a memo for urgency because these petitioners are suffering. They are being harassed badly by the respondent 5. And
We told you we'll dispose the matter directing RERA to consider. You don't want to consider. You
My
made
lord,
allegation
my-
against so many people.
My lord, as per your direction,
You said
we are-
you will produce them. You
we
have
have
not produced them.
This is the, I have already filed and this is the copy of.
I've received this memo this morning, my lord, 500 odd pages. Frankly, I haven't had the time to see it yet.
My lord, I have some
500 pages. What we are getting is only some 5 pages.
I've received a
My
memo
lord, I
with
served it long
526
back.
pages.
They are,
No, I've received it by an
proceeding the
email
court
of 8, 9 a.m.
What
today.
what we are getting today is a memo of probably around 5-6 pages.
I have served them the copy 2 weeks back, the petition copy already to respond number 6, 7.
No, not the petition.
And
copy,
last
sir.
hearing
I'm
also,
referring
last
to your
date of
memo.
hearing also, I served the copy to their colleague. The petitioners, as per the direction of this honorable court, have withdrawn their complaint from the RERA and also filing an affidavit and also producing the list of.
And withdraw, we don't know what you are doing and what you are advising, Mr. Sharma. You have to proceed before the RERA. You
My
can't
lord,
be coming for a relief to restrict them to cease and desist from recovering money, and all the proceedings are before the RERA, which RERA is concerned with.
My lord, we have withdrawn all the complaints based on your direction and also.
We have not asked you to withdraw, please. And don't make that submission. We have told you to proceed before the RERA.
Oh, my lord.
Now you are coming before us saying you have withdrawn, so consider this matter.
There are other cases where people have obtained the orders from both RERA and writ. I produced that list also. You may kindly have a look at that. 64 cases are there where people have taken dual benefit from both the forums. And they have.
Our main relief is to restrain the bank from ceasing and desisting from recovering pre-EMI and EMI amounts.
Yeah, my lord, that is not in the power of.
Based on your complaint before the RERA as to whether they have violated, not violated, subvention scheme was before the construction, after the construction. These are all facts which have to be ascertained. We've already disposed the matter.
My lord, all other petitioners have taken the relief from here. RERA is not giving any such relief.
We have disposed finally. The interim orders you are speaking of, we haven't seen. We have asked you to see the orders.
My lord, in my case,
we have disposed.
In my case, I have withdrawn my complaints from RERA on this condition that we will get a relief from this court. That is the reason we have withdrawn.
You advised your client wrongly. We can't help you, please.
My lord, because last hearing I said it is either this or that. So we have chosen this.
We have told you specifically it is RERA, not here.
It does not have power, my lord. Otherwise, why would people come here and take the relief from this court? There are 64 cases. I myself have
produced. Don't try to do this. You are putting your clients into trouble.
My lord, now they don't have a protection. They have withdrawn from the RERA also. Now
nobody asked you to withdraw.
My lord, because you are not giving the relief, that's why we have, because you said that it is either this court or that court.
No, we did not say that. We said go before RERA.
RERA does not have power to stop the bank from EMI.
Other cases. 28(1).
My lord.
Please see our order. We already.
But I have submitted the affidavit of
We have directed the RERA to consider all these issues because they have to consider it. We understand your problem.
My lord, moreover, these are victims of double sale. They are not even legally owners of that flat. They have been sold a flat which already been sold earlier to other people. And that documents also I have produced as a proof.
You may have the
so they are suffering from all sides.
But that will have to be before the RERA, not here.
My lord,
your only relief, final and interim relief is not to recover money from you.
Yes, my lord, that is
subject to what?
Because that is the only relief people are.
What are we going to decide here?
My lord, the RERA orders are on paper. They are not getting any relief, refund in terms of refund in their account.
Next third.
34.
My lord.
Yeah.
My lord, they don't have any protection now. Where do they go? Now they have withdrawn from the RERA as well.
Don't make us say things you won't like now.
Hello, I appear for respondent number 5 to 6, seeking a PASO senior counsel on his legs, my lord.
PASO.
35. Rohan Patari.
On the last date of application, Lord should ask how many complaints have been filed.
As if there's proportionate. It's proportionate, fine.
We will just explain the case to you. What has happened is, there are 5 FIRs, madam. There are 5 FIRs which have been registered as a predicate offence.
Only 5?
No, I will just make my submissions. There are 5 FIRs which have been made predicate offence. One is 421. One is 413.
What are the amounts involved in this?
My lords, each FIRs have different amounts. My lords, apart from that, what has happened is there are certain people who have filed. They have filed for complaints, lordship, which says that they are using bots, because of which we have lost. And those complaints run into 298 complaints.
Oh.
298 complaints. Lords, this is a. Last time lordship asked me. Lords, what has happened is during the period of search, if I may submit lordship.
Generally, all the complaints are the same. No, this is reasons to believe.
Lordship, yes. During the search, what we have carried on. Lordship, lords may come to page number 93. Lords, 2 accused have been arrested.
93.
93.
Of what? Of the petition.
of the petition.
This you are not numbered. So 93. Yes.
My lords, if this is the remand application of two persons. One is two are the directors of Windsor Private Limited. This is accused number 1, Soumya Singh Rathore. And in that lordship, my lords may come to page, in the same page, 1.1, 413 is registered. Next page, lordship, 1.2, page number 94, 426 has been registered. 1.3, FIR number 32,
421. Yes.
Now, my lords, what happened? Based on this, ECIR got registered on 6/11/2025. After registering the ECIR, we went for search. Now, my lords, if there are 2 pages which is very important for the consideration of the court. Page number 95. If I may read those 2-3 pages.
Yes, please.
During the investigation conducted, 2.1 lordship. During the investigation conducted by Directorate of Enforcement under the provisions of PMLA, certain incriminating records in the form of digital records, emails, seized during the course of the search and seizure under section 17 of PMLA at the residence and official premises of Soumya Singh Rathore, Windsor Games Private Limited and other accused persons. Lordship, there were 3 such proceedings which took place. One is in Windsor Games Private Limited, that is the...
And 2 other residences.
2 other residences. Analysis of the documents collected during the investigation revealed that Windsor Games Private Limited has indulged in various fraudulent practices to cheat gamers, users, thereby causing huge financial loss to the users. The major findings of the search as below. Usage of algorithm or software. The company claims to the public that the real money games offered through the mobile applications are free from any of the bots, algorithms, or automated devices, and assures a fair and transparent gaming environment while participating in or subscribing to such RMGs. However, the evidence gathered during the search proceedings, lordship, that is at the 17 when we were there, that was the questioning there, establishes that the company has in fact deploying concealed algorithm called as PPP, Pass Pair Performance. Under the mechanism, when a real-time user engages in RMG, the software selects the historical gameplay profile of an existing user from the company's database and uses it to generate automated gameplay. Further, the real-time participant is not informed the opponent is not a human player, but an algorithm controlled profile. Furthermore, the users whose profiles are utilized for PPP-based automated gameplay have neither been informed nor have they been provided consent for such use of identity or gameplay history. At no point of time, PPP derives matches. Does the company disclose or indicate to the live participants that they are competing against an algorithm? The investigation has revealed, this is important, that the PPP-enabled games resulted in illicit gains of approximately 177 crores to the company and corresponding losses to the genuine users over the past 14 months only. Now, my lords, when we went for search, there is a cloud data what they maintain called as an AWS data. That is the
Amazon
Web Services data. Now, my lords, when we started downloading the data, we got to know that there are 177 crores which have been illicitly gained, and that has been compiled and I have given it in the sheet which has been given to you. That is all complaints saying that bots have been used. Now, my lords, through this undisclosed and deceptive use of algorithm, the company has misrepresented the nature of the gameplay and thereby cheated bona fide participants, causing huge financial losses. Unethical and destructive practices. The company has effectively created an ecosystem that restricts the users from freely withdrawing the funds from their own user apps, wallets, by imposing a series of restrictive terms and conditions. While users are permitted to add money to their app in the wallets without any limitation, they are not allowed to withdraw these deposit funds at their discretion. Only the winning amounts earned through the game are eligible for the withdrawal. In addition to this restriction, the company has imposed daily withdrawal limits which are decided by the user's loyalty level. Even at the highest loyalty level, the maximum permissible withdrawal is below 1 lakh per day. These limitations substantially curtail the user's access to recover their own deposited money. As a consequence of the above restrictions, users are effectively compelled to continue playing more games in order to convert their deposited funds into withdrawable winnings. This structure coerces prolonged gameplay, thereby increasing the likelihood of financial loss, particularly in view of the company's systematic and undisclosed use of PPP algorithm in RMGs, which manipulates game outcomes of the detriment to the genuine players. Rampant blockage of users' invalid apps. The company's terms and conditions confer upon the discretion to block or unblock in the company's wallets for the purpose of preventing malpractices or fraudulent activities by users. However, analysis of the data furnished by the company indicates that the wallet blockages were carried out arbitrarily and without any valid or documented grounds. Now, this is very important again. The misuse of discretionary power is further corroborated with the substantial balance observed in the company's escrow account amounting to approximately 43 crores. This is apart from the 177 crores, which remains classified as payable to users as on that date. The existence of such significant pending amount evidences that the user wallets were blocked indiscriminately and arbitrarily, preventing legitimate users from accessing the withdrawing from their own funds. Therefore, my lords, there are escrow accounts which have been maintained, which have been safeguarded by them. These are amounts which are nothing but to be payable to those users who are not even complained. They don't even know. So there are gullible players in the games. They don't even know whom to complain. Now, apart from this, Lordship, there have been several complaints which have also been filed.
Do you have any regulation for this? Does the state union have any? You are appearing for the ED. Mr. Kamath, do you have any regulation for these online games?
I have not gone through this file yet.
Certain it is not there. No standard.
Is there any, from your knowledge, is there any regulation?
As far as my knowledge, I undertake instructions on that part, Lordship. Because, Lordship, the point is, my lords, what has happened is when they play and they put the money, they have been withheld against their own wishes to.
But should the union not bring about any legislation for this?
That, my lords,
Could I just clarify, my lord?
So let me further complete, my lords, please. Now, let's after this, when the investigations, the search operations were going on, now, lords, we came to know that there are foreign subsidiaries which have been formed by the company, fully owned foreign subsidiaries. The company has 3 subsidiary companies, out of which 2 are foreign entities, and details are mentioned as below. That is Winzo Inc. USA, Winzo SP PT Singapore, and there is one more wholly owned subsidiary in India that's called as Zo Private Limited. Now, my lords, analysis of the ODI documents, these are nothing but the overseas direct investment documents furnished by the company. It is seen that the company has mentioned the nature of business as other creative arts and entertainment activities, those companies. However, this entity is into business of running RMGs, even those wholly owned subsidiaries who are situated outside India. Evidences gathered during this search, again the search comes in, Lordship, revealed that the management of these foreign entities are being carried out from India only, including the day-to-day operations, maintenance of books, of accounts, and managing foreign accounts. The stakeholders, directors who are now presently the accused, also the directors of this company, have systematically diluted their shares in the company periodically, and these funds are transferred to US-based subsidiary, and it is also seen on 22/1/2025, that is when the search was ended. The total available balances in the foreign accounts are around $55 million US, that comes to around 499 crores. Investigation also revealed that the global operations that is hosting all type of games, that including the RMGs, are undertaken under the single app, same platform that is operated from India. Now, Lordship, I just want to mention one point here. 22/8/2025, there was an ordinance which is brought by Government of India with regard to banning of the apps. Now, but Lordship, by the effect of they being wholly owned subsidiary operating outside India, they've been still using the apps even now, and it's being managed even now.
So is this app one of the apps banned?
RMG is banned. Yes.
All RMGs are banned without naming. Where is that notification?
I will have to produce that.
You will have to show it to us.
I will. Now, Lordship, that may I read further, Lordship. Furthermore, the company, after banning of RMGs by the union government, has entered an agreement with its foreign subsidiary for transfer of intellectual property rights in order to transfer the relevant RMG software, technology and database to USA. It is suspected that this arrangement is nothing but to shift its operations of RMGs from India to foreign nation, where it's a legal one. Also, the transfer of 25 crore user data is also a theft. Now, therefore, Lordship, now when we found out these things, and my lords have produced the reason to believe, my lords, in the, my lords, this is the reason to believe what, the basis of which
Presidential assent, it has not been notified in the official gazette. Where you got that from? There's some act that you mentioned, Promotion and Regulation of Online Gaming Act 2025.
that is the,
Do you have a copy of it? Yes, we already have an act for that.
it is an act.
Come
Any
into force
violation
on
of that
1/10/2025, my lords. 1/10/2025.
Not prior to that.
No, my lords, not prior to that.
According to you, before that, you were
All the-
unregulated.
It was unregulated. It was
You could do-
unregulated.
You could do what you want.
No, I can't say that, my lords. I can't say I can do what I want. Anyway, let them complete. I'll point out, my lords, what has happened. Now, the freezing that has taken place is for 505 crores. I'll just point that out.
500 crore for this is nothing.
My lords, even according to them, 177 crores.
we
I'll
have-
just point that out, my lords.
If we
I'll
have
point
even
out.
10 crore of players of 100 rupees, 1,000 rupees, what would it be into
My lords,
numbers?
according to them now, 177.
Yeah,
I will
we'll-
point it out.
We'll come to you. Let
Yes,
him
my
finish first. In October, they have stopped the business.
Which is the problem. It says unless it is constitutional, unless you are prohibited. Only if you are prohibited, it becomes illegal. Otherwise, it is not illegal.
In the
See, online gaming was allowed throughout. Now it got regulated only on 1/10/2025. Prior to that, it was not an illegal act.
We are not seeing anything subsequent to that. All related.
Correct. Now, once more, if it is unregulated, that doesn't mean you can do anything. If you're not prohibited by law, it can't be an offense.
Prohibitions, 567, and the offense, section 9. Both 567 and 9 come into force.
Post. People want to know if something is not declared as illegal, then they can't find fault with it.
individual has lost. If you do the net calculation, actual amount of claims is more than 200 crores. The company has sustained cumulative 250 matches. So if you, for example, take a subset of all the games that the person has lost, of course you're going to reach a number because there will be wins and losses. With the wins are far more than zero.
Total number.
298 complaints you have.
298. This is apart from those, our other five.
The FIRs registered.
Please, that's what happens is, Lordship, there are complaints which will be given. There are several other complaints across India which have been registered with the consumer forums also, because the players who play, they would not know that there has to be an FIR which gets to be registered. So therefore, what happens is, Millards,
you make it part of 1930 now.
That's why this is the data which
If you
we
make
got
it part
from
of
the-
1930, it will be available to you.
Please, Lordship. And therefore, Lordship,
This is the seriousness that you are will ask them. But if this is a seriousness, then you'll have to show the seriousness from your end to
please, Lordship.
where that act that you mentioned. What does it say?
It's called the Promotion and Regulation of Online Gaming Act 2025. Well, we have.
You have it. All iPads sent will be confiscated.
I've retained mine, Millards.
Senior counsels are very smart. That's what Mr. Chinnappa also did the other day. He asked his instructing counsel to give.
I did not bring today, Millards. I forgot in this side.
We should have had it.
Can you open it up again? One more. Five, 6, 7, and 9 may be relevant. Post 110/2025.
So no money can be used in 5. No advertisement in terms of section 6.
6. 9 would be the punishment section.
No transfer of funds. You have blocking power under section 14.
Actually.
You can block their game. You have the power.
Lordship, this is
Yes.
on and from. Lordship, then, Lordship, if I may, page number 50 of the petition.
50, 50.
50, please. 50,
Yes.
and if I may, page number 39. This was the Caesar Panchnama which happened in the residential premises of one of the directors. Now let's page number 50, Annexure C, what they have mentioned. This is the Panchnama which has been drawn at the premises of the petitioner company. Now, my lords, if my lords may kindly come to because they made some allegations. Page number 53.
Yes.
Third, last para, fourth para. Mary.
Yes.
During the course of such proceedings, statements of Soumya Singh Rathore and Pawan Nanda were obtained, so according to section 50 of PMLA. They were provided with ample time for rest, refreshments and meals during the course of the recording of statements. Further, they were allowed to gather the data and reconfirm the veracity of the facts and the data that were being presented and stated by them during the course of the recording of the statement from other employees of the office. It was observed that Ms. Soumya Singh, one of the directors present, frequently moved around on premises at short intervals and interacted with various employees who are participating in the search proceedings, which caused intermittent delays in recording a statement and also resulted in attempts to influence the submissions of other employees whose statements were being recorded during the course of the search proceedings.
This will all be available in the CCTV.
It is all, my lords, there because they made allegations that she did not get sleep, etc. That's one aspect I need to bring it to the notice of this court. Page number 56.
You have to get back on two things apart from your other arguments.
Please.
Number one is number of complaints. Now you say there are 5 FIRs which have been lodged, predicate offences, but 298 complaints have been received, which though not an offence would have to be looked into.
That we are, what my instructions are, then, Lordship, that would be converted into 66(2) for enabling the other law enforcement agencies to register an FIR in that respect. The action is on because as and when we are getting to know about it, there are more complaints which have been received.
You should just enable 1930 for this, so everybody can complain.
Please, Lordship, I will instruct them.
193, your contention is a cyber fraud.
Also.
Using internet meets for that amounts to that. So 1930 could always be made available.
Please. That's page number 56.
Yes.
Page number 56, the last para, Lordship. This has been written none other than the witnesses who are there, because the typed copy is placed at page number 66. 66 is the typed copy. May I read, Lordship?
Repeatedly failed to cooperate.
The search was conducted in my presence. During the procedure, Soumya Singh Rathore repeatedly failed to cooperate with the officers. She moved around the premises throughout the recording of her statement and repeatedly interrupted the officers who were questioning. She also attempted the employees whose independent statements were being recorded. Despite all this, warranting officer and his team remarked throughout the profession and found all the individuals being examined during the search. Now, my lord, this is the conduct of the petitions when the search was taking place. Now, after this search, Lordship, we took the 17(1)(a), 17 the freezing orders. That is at page number 43.
Yes.
This is read, Lordship. Whereas so-and-so assistant director, second para. During the course of the search, it was revealed. What was revealed, I given as reasons to believe that Windsor Private Limited is engaging in criminal activities associated with the scheduled offence in case where there is a proceeds of crime is derived from the customers who are made to play with the algorithm software, being made aware of the fact that they are playing with the software algorithms, not humans. The entity is also limiting withdrawals of the monies held by the customers held in the wallets of Windsor Private Limited. Proceeds of the crime is derived from Windsor Private Limited in the form of bet amounts placed and lost by real customers through the unscrupulous use of the algorithm software which were received by the entity in its bank accounts. Such proceeds of crime are further being routed, layered with the company through routine financial transactions are parked in the bank accounts, financial investments, instruments, digital assets in order to obscure the true nature of origin. My lords, I want to pause here. Now, what has happened, my lords? The 500 crores what we have frozen in the accounts. Now, to that equivalent of the 500 crores has already been offloaded to those subsidiary, wholly owned subsidiary companies. So therefore, on this basis, when we got to know about it, we thought we should arrest that 500 crores.
Saying financial investment instrument, virtual digital, as they've been converted into cryptocurrency.
Yes, cryptocurrency is also there. Therefore, my lords, it is not impracticable to seize. The reason why we could not seize, my lords, is because it's in virtual world. So investigation under PMLA during this search reveals that following cryptocurrency accounts is involved in the following money laundering through the above mentioned modus operandi. It is not practicable to seize such proceeds of crime immediately, which is parked in the below mentioned bank accounts, escrow accounts, financial investments. Further, the investigation in the PMLA during the search also revealed that money has been transferred by abroad entity subsidiaries under the false pretext, and there is likelihood that the balances of the below mentioned bank accounts, escrow accounts, and the financial investments, which represents proceeds of crime directly, indirectly derived from the scheduled offense, might be dealt in a manner which is frustrate the accounts. We have also, this is the wallet which we have also frozen. Similarly, we have frozen other accounts on page number 45.
What is the value in the crypto wallet?
20. It's supposed to be 25 cents, my lords.
There's no amount mentioned here.
25 cents. I'm instructed there is some 9 lakhs account in that. That point
That's
of time. ಅದೆಲ್ಲ ಸ್ಟೇಜ್ ಇದೆ ಯಾಕಂದ್ರೆ 22nd ಮಾಡಿದೆ 18th ದಿನ ಏನಾಗಿದೆ ಗೊತ್ತಿಲ್ಲ.
Not even one Bitcoin.
Page number 45. Now this is the freezing order which has been given under 17(1)(a) for all these accounts, Lordship. Lordship, after this, Lordship, we summoned, after this, it ended on 22nd. Since they were not cooperating, we summoned them for coming here and deposing the statements. Page number 20, Lordship. Para 22. They came at 10 a.m. Despite the above, in respect of the complete operation, the petitioners directly, promptly complied with the summons and appeared directly. They were subjected to interrogation from 10 a.m. until 6 p.m. at which juncture they were placed under arbitrary and unlawful arrest.
This is recorded on video?
No, the arrest is not recorded on video.
And this interrogation at 105 would apply to this?
No. This is summons. This is section 50 summons. We recorded the summons, we gave the summons on 22nd to appear on 26th 10 a.m.
BNSS could?
05.
The operation of 105 would be very important.
That is answered in Vijay Madan Lal Chaudhary with regard to the overriding effect of section 17 as well as section 15 lots.
When was that judgment rendered?
22.
This is 23. This act is 23. So there is a subsequent enactment which is coming.
No, this is PMLA.
Maybe, but with 105 is.
No. Even then, the overriding clause of section 4 and section 5 of erstwhile CRPC as well as the BNS of 4 and 5 remains same. There is no change in that with regard to 4 and 5. And read with section 71 and 65 of PMLA. That has been, I'll come to that, Lordship. Now, Lordship, before I come to that, they say that 6 p.m. they've arrested. And we've arrested the two directors, Soumya Singh Rathore and Pawan Nanda. My Lords may come to page number 179 of their. Certain allegations were made saying that we are not taken care of them. Page 179. Lordship, this is the order by the PMLA special judge when we produced them before the PMLA special judge at 10:30 p.m. in the night and when we arrested. Now, Lords, page number 79, last para, that has been typed at page number 184 from Lords to consider. May I read? I have inquired, this is the PMLA special judge writes, I have inquired with A1 and A2 and generally they have seen in good health condition. On inquiry, they have no complaints of any ill treatment against the ED officials. No complaints against ED officials. They have stated that all the arrest formalities and arrest papers are notified to them and their relatives. Next, Lordship, it's important. A1 has stated that she has been arrested at 5:25 p.m. and A2 states he was arrested at 5:50 p.m. Their allegation is they were arrested after sunset and also it is contradictory to the court records. And Lordship, they were citing a document at this place, page number Page number 50, not 50, Lordship. Page number.
Written statement.
22nd, you told it is not given.
76.
76. Page number 76, Lordship.
Seventy-six.
They claim that this is an additional submission on 22nd November, which apparently was not received by us. They have made this statement now in the writ petition. Nowhere that statement was made at that time of arrest, at that time of production before the
When
PM.
was the production?
Production at 10:30 a.m. on 26/11/2025. 10:30 p.m.
25. And this is 22/11.
22/11, because that day the search ended. So their allegation is that after the search, we have written a letter which has not been taken by them. But my lords may have to note, this letter was never mentioned first at the time of arrest, at the time of production before the PMLA judge, or at the time of seeking for ED custody, or at the time of judicial custody. Now this letter has come up only at the time of writ petition. In the first given opportunity, they should have given. They have not given it. So we are unaware as to the contents and also the veracity of the document. Lordship.
Reduce it and record the CCTV footage. CCTV, how many CCTV footages? 16 CCTV.
Lordship, after this, Lordship, the investigations are going on and the writ petition gets filed. My lords, as of today, Lordship, in terms of 17.4, because they're also seeking for defreezing the accounts or staying the. As of today, I'm given to understand that we have filed the report with the adjudicating authority within 30 days that we have to do in terms of
17.4.
17.4.
17.4 is done.
17.4.
So he has time to pass on.
Now that Lordship, if I may read 17.4.
PMLA coding.
Just a report.
May I read?
Yes.
17.4, Lordship. The authority seizing any record or property under subsection 1 or freezing any record or property under subsection 1A shall, within period of 30 days from the date of such freezing or seizure, as the case may be, file an application requesting the retention of such records or property seized under the subsection 1 or of the continuation of the order freezing under the subsection 1A before the adjudicating authority. Now, Lordship, we have filed this
retention
before the adjudication authority. Now, Lordship, if they are aggrieved, they can place all the materials before the adjudication authority, which is a statutory mechanism which is been provided under the Act. They can go before them. They can place all those materials before them. If the adjudicating authority feels, yes, it is correct, because the magnitude of the issue is such that they can place all the materials and they can get a relief. So far as they're asking for the staying the monies which have been frozen, well, my humble submission in this regard will be that since the equivalent money has already gone out of India and that we are trying to safeguard. Now, reason, my lords, is I have to make one submission also on instructions yesterday, that these monies does not go into government of India. These are monies which will be restituted in terms of section 8.2 to those who have lost money.
Yes.
So therefore, my lords, considering the magnitude of the issue, I would only urge this honorable court to direct them, let them, since the mechanism in place, let them go before the adjudicating authorities, my first prayer with regard to the interim prayers of what they have sought for on page number 32, Lordship. They have stated, the first part is that they have stated that stay the operation of the impugned freezing orders or 21/11/2020 passed by respondent. So in this regard, I would only request the Honorable Court to direct them to go before adjudication authority, place whatever materials before them. And I would urge that process of understanding and also the documentation to be seen in light of what I have provided the data. It would be difficult for a 226 court to do that, is my sincere submission.
Yes.
B, direct the respondents to produce before this Honorable Court the CCTV DVR seized Panchnama. My lords, with respect to this, on the last date of occasion, my lords had directed to produce a copy to the court. We have given a copy to the court. That is with the PMLA court as of date. Now, my lords, in so far as if they're asking, because my lords had also suggested that they can view the CCTV footages also, we have no issues, let them see. They also saw.
That was a consent order.
Please, my lords, please. Now, my lords, in so far as whatever records they want, including CCTV footages, now, my lords, they are at liberty to come under section 21. They can make an application before this. What all the documents they need,
you will furnish.
we will be able to do the needful under section 21. Now, my lords,
If they make an application at 21, you will furnish the
please, my
copies
lords,
of the
please,
CCTV.
please, my lords.
Yes.
Direct, third one, lords, direct the respondent to produce before the Honorable Court the reasons to believe. That I have already provided to this Honorable Court.
To produce before the court, not to furnish to them.
I cannot, I have no instructions.
The prayer only is that. So, yes.
That is to form an informed opinion by this Honorable Court. Number D, stay the use or production of Panchnama in any proceedings arising out of. Now, my lords, I have reservations on this.
No, that Mr. Agarwal
Please,
did submit that.
So therefore, my lords,
it can be seen in conjunction with CCTV.
please, my lords.
So B and D will go together with regard to CCTV.
Please, my lords, please.
So also would E go along with CCTV.
Please, my lords.
Now that you are making a categorical submission on instruction,
Please.
that if they make an application at 21,
Please,
you
my
will furnish the CCTV, which is recorded.
Please, my
So B, D and E will be taken care of by that.
Why I may even make just 1 minute of submission. Now, my lords, at this stage of investigation, what I am also given to understand is, Lordship, the data is in all cloud, AWS. Now, my lords, told to tell this, that they have not been given the data to us. The reason is, Lordship, the AWS cloud data is maintained by AWS. And without that data, we are handicapped to do any investigation for that part. So therefore, my lords, my only submission would be that let they be even directed to give that data.
We can
The reason is, my lords, and also one more thing they told, Lordship, that there are 200 employees who salaries. My lords, we have nothing against them. We are all for them. And
that may come under Article 23.
My lords,
we can't direct that.
My lords,
you follow your investigation methodology.
My lords, with respect to my submission is, my lords, 200 people they have sought for salaries and all. It's before the PMLA court, which is under consideration. Now, my lords, for the purpose of 200 people and the company, the entire public cannot be held at ransom. That is one point. Second point, Lordship, if they have anything with regard to those 200 employees, we will consider it. We are not. And for that reason alone, Lordship, we have left 2 bank accounts untouched.
How much is the money in
14
that?
crores. 14.5 crores has been left untouched in the bank accounts of this petitioner company, considering the fact that they have to give salaries. HDFC Bank.
How many employees are there? 200.
As per their claim, 200.
Yes.
Which
As per you.
They have not
You
given.
don't know.
They are not. So therefore, Lordship, there are 2 bank accounts. One is HDFC Bank account and RBL. So put together, there are 14.5 crores, which is still in the bank accounts, which they can satisfy these salaries. So therefore, on that count, if they were to say that freezing, etc., that is our counter to that. And my lords, at this point of time when the investigation is going on, we have a slim period of 60 days to file our prosecution. It's already around 20 odd days. Now, my lords, at this point of time, my only earnest request would be that the data what they are given as against our data, Our data may be taken into consideration in terms of the Supreme Court judgment. The reason is, my lords, these are all data which is ongoing, coming as and when we are investigating. So therefore, that is my sincere request in this regard.
So your submissions are threefold. One, because of 4 predicate offences and 298 complaints which have been received, there's enough material to proceed against them.
Please.
And you would be enabling 1930 for receiving other complaints.
Please.
And the complaints which have been received, you will process it under section 66 of the IT.
66, yes.
That
So
is
one-
the submission as regards the complaints which have been received.
Please.
Insofar as search and seizure is concerned, those allegations, you are ready to give the CCTV footage and if an application under section 21 is made.
Please, please.
Insofar as the payments to be made to the employees, you have said 14.5 crores would be, is already available.
Yes.
And if there's anything more required, if they give you the documents, you will release to that extent.
Pertaining to their employees.
Pertaining to their employees. Obviously on verification. If they furnish the documents on verification, insofar as salaries are concerned, you are ready to do so. Probably you will caveat it by saying not to the promoters.
They are also employees, Lordship. I have.
Their salary would be something
There is-
different.
No, but on aspect of this proportionality, what they were telling, Lordship, my only submission is, section 17 is a wider section, even read with section money laundering section. In 2019 also, the amendment was made because these are all matters where there are concealment which has come into picture. There is a concealment of the money. So this concealment would be known only because there are FIRs which are yet to get registered. So therefore, my lords, my only submission is we are trying to arrest a situation where the money does not go out of India.
Have you blocked their gaming portal?
No, that is.
Section 14
No, they
provides.
themselves have blocked it.
Because section 14 of the Act provides for that.
My lords, but the point is, my lords, what I'm given to understand, for the outside India operations, it is being used. It is being used.
You can use it in other countries if they
No,
want.
if in India, if it is banned, even for outside India, it is being used. Because it is
From
being
India.
controlled from India.
From India.
From India. The app is from India. With the same employees, with the same banking transactions, with the same infrastructure, with the same office.
Well, it's on instructions, we say, from
We'll
August.
come, we'll come to you. We are trying to understand what their position is. So, as regard that, you have no jurisdiction, we have no jurisdiction.
No, my only submission is with regard to that. The reason for the freezing orders, which are, my lords, I leave it to the court. The reason is, my lords,
That is for the
500 crores, my lords. It is so
That's a
many
different thing. No, insofar your last submission is concerned,
Please, please.
you can make that submission, but can we pass any orders on that? We cannot. Because it is beyond a territorial jurisdiction also. If any country is aggrieved by their functioning of the platform in their country, it is for them to take action.
Lords, one submission, this 177 crores, what I mentioned, is for the period from May 2024 up to August 2025.
Where is the confiscated iPad? You have taken it back. Very smart. You haven't given. Section 14 applies territorially or extraterritorially?
No, it is, tab is different.
Ideally, print ತಗೊಂಡ್ರೆ
That I.
ಕೊಡಿ ಅದೇ ಕೊಡಿ ಇದು ಕೊಟ್ಬಿಡಿ ಅವರು. Not section 14, it is
14 minutes. Blocking. It's probably section 1, subsection 2 may be noticed, my lords.
Section 1, subsection 2.
Information Technology Act. Section 1, subsection 2.
Subsection 2, it applies to online money gaming services offered within the territory of India or operated from outside the territory of India.
Within India.
So
Not
within,
outside India.
yes, my lords. Or from there if they're operating. But if we are operating here and in any other country, it's legal, my lords, online gambling, that is safeguarded.
In any case, Lordship, this is before the act came into force.
Even what we are looking at is your submission we cannot consider
I
as
will
regards other countries. That is for those countries to take action. If they think the way that you do, they could take action.
Well, it's on one more. Not they alleged that there were statements which were taken during the night and other things. They are given a circular, which may not.
The CCTV footage will, that answers all those things.
Please.
We had to go into it if you had said we won't give the CCTV footage. Since you have come forward to say we are going to give the CCTV
In terms
footage
of
if they
section
make an
21, if they make, in terms of section 21, if they make, we will do.
Don't qualify it, then we'll have to get into the qualification. If they make an application, the entire CCTV footage you are giving them. If they make an application for the CCTV footage,
Okay, we are.
you're good, because we'll record your statement on
Please,
that.
please.
Yes,
Sorry, they qualified it, my lords, for
no
that.
qualification.
Yes, my lords, for that.
We asked them, if there's a qualification, then we'll have to go into the qualification.
Yes, my
There's no
lords.
qualification.
My lords, the matter is tomorrow. The bail matter is tomorrow. The whole concept of wanting the CCTV footage is for the purpose of the bail, my lords. And 21 may be noticed, my lords.
One, before he asks it, we'll only ask. When they make an application, within how many days will you give it?
My lords, it takes 12 hours to copy.
That's your answer.
Yes. And
Before you do
Yes,
the
my lord.
one-page argument.
Ila, just to say 21, there is no need of any application, nothing. Entitlement, 21 may be noticed, my lords. It's like, my lords, if an FIR, if I have to make an application to get a copy of FIR, it would be quite ridiculous, my lords. Kindly notice 21, it's your entitlement to get it. And when they say they've given it to the court, my entitlement, they should give it to me. Where's the concept of filing an application, asking them to give it to me? And even 17.4 is not an inquiry, my lords. 17.4.
Shall be entitled to obtain copies of records.
They should be giving it to me, my
If you
lords.
don't want, how do they know you want it?
Alla, my lords, application, iga, probably.
It's not saying it will be furnished. The word used is not furnished. The word used is entitled. Entitled is an application.
Just give it. My lords, we will do it right away, my lords. If they say 12 hours because tomorrow is the bail, I don't want to go more on that. So, my lords, my first part of what we wanted, my lords, is the CCTV footage. That is answered. Now, the second aspect of this case is only about the freezing aspect of it. These are the only two things, my lords, that we are really looking at in so far as this is concerned. Now, my lords, when it comes to...
Do you want to push that here or do you want to take it up before the adjudicating authority?
My lords, it doesn't happen before adjudicating authority for the reason, my lords, 17.4 may be noticed.
Yes.
It is not an inquiry, my lords, under 17.4. 17 is search and seizure, my lords. 17.4, it is reported to him. There is no inquiry that takes place under 17.4. Can I just point out 17.4 for a minute, my lords? If the whole 17 is seen, my lords, search and seizure, after they seize it, in 17.4, my lords, the authority seizing any record or property under subsection 1 or freezing any record or property under subsection 1A shall within a period of 30 days from such seizure or freezing, as the case may be, file an application requesting for retention of such record or property seized under subsection 1 or for continuing of the order of freezing served under subsection 1A before the adjudicating authority. Now kindly notice 18, my lords. I'm sorry, 8. 8 would be where adjudication is later, not now, not under 17, my lords. 17, there's no adjudication at all. And my lords, quashments that have taken place, which I will point out, is of this freezing order. The Delhi High Court in 2 cases sets aside the freezing when it's disproportionate. Similarly, opto circuit, my lords, as I'll point out, So, my lords, in my respectful submission, 17.4 would not come to the aid of any inquiry, my lords. Now, my lords, insofar as whether it has been proportionate, so far as this defreezing is concerned, my lords was pleased to see the act, my lords. My lords, the act came into force on 1/10/2025. My lords, prior to 1/10/2025, online gaming was not an illegal activity.
Which act? The Gaming Act.
Gaming Act, my lords.
Even then it will come under cheating if you're using your algorithm.
If it's going to come under cheating, if I've not paid back, I get it under the IPC, my lords. But in so far as saying
There's a
online,
very serious allegation which has been made against you. If you're
I
going
will-
to use, and that is what is the big issue. Most of your platforms, there are trading platforms which say that if you don't trade, we'll be deducting 10%.
I'll just come to that, my lords.
Forcing a person to trade. We received a complaint about it. Why we are saying is we received a complaint about it recently. Somebody had sent a letter. We didn't know what to do with it. Somebody had sent a letter about some cryptocurrency trading platform. IQ option or something. Some option something it was. Saying some judgment of us, they read and said you should take action. The complaint is that I am a member of it. I have got some money in it. I have been receiving emails that I should trade. The market is not good. I don't want to trade. They have threatened that if I don't trade, 5% will be deducted.
That's a case of cheating, my lords. Allegations, ingredients of
That
cheating,
is a
which is being
terms
made.
and
I
conditions.
will just come
and
to
that
it.
condition, similar condition. That's what it was a deja vu for us when Mr. Madhu mentioned that you can't withdraw more money than 1 lakh of rupees, and you can only withdraw your winnings. That is the allegation made. We don't know the truth of it.
My lords.
Today we are not deciding the
We're
truth
not
of
deciding because I'll just point out on proportionality, my lords. Ultimately, here it's a case where freezing is proportional to what the allegations are. It comes down to that, my lords. Now, please notice, my lords, page 40. I'm sorry, I'll go from page 93, which was read by them. Kindly notice, my lords, the 4 FIRs that they mention, they themselves mention, that is a predicate offense.
Yes.
My lords, page 93, kindly notice the first predicate offense, FIR number 413, was registered with.
Should it be restricted to this predicate offense?
It should.
And or the complaints which
No,
are
my
there?
lords, when it comes to PMLA, it is restricted to the predicate offense. My lords, the schedule offenses which are there, my lords, they're the predicate offenses. PMLA flows from the schedule offenses. So from that offense, if there's going to be proceeds of the crime, and that proceeds of the crime, if there's a process or activity, this.
Can we take such a technical?
No, but that's how Vijay Madan Lal Chaudhary, my lords, everywhere.
In the cyber fraud matters.
Yes, my lords, but when it comes to PMLA, that is how
so
it is.
many complaints on these kind of matters.
Yes, my lords, when it comes to PMLA, it is a case of money laundering of the proceeds of crime, which arises from a predicate offense.
In the other matters where we are handling the defreezing, one of the reasons why money has found its way into that account of that so-called innocent bank holder is because of online game, and amount has been credited, and that's a fraudulent transaction. Therefore, his account has been frozen.
I get that.
And thousands of accounts have been frozen because of that.
Yes. But my
Thousands.
yes, my lords, my respectful submission when it comes to PMLA, my lords, PMLA, it's like a parasite, my lords. It has to have a host. The host is the schedule offenses. Now we have about 157 schedule offenses. So once there's a schedule offense, and from that schedule offense, you have proceeds of crime. Cheating, 10 crores, that's proceeds of crime. Even then PMLA doesn't kick in. This 10 crores, if you're going to be doing a process of or activity that is laundering, that is the starting point of PMLA. PMLA can't be applied for anything else, my lords. That's the reason this predicate offense, they themselves state, this is a predicate offense, and this is how I get power and jurisdiction. Their entire power and jurisdiction comes out of that. Section 3, my lords, is bang on it. 2(1)(u) is proceeds of crime, my lords, under this act, PMLA. 3 has to be read with 2(1)(u). And Vijay Madan Lal Chaudhary, they very clearly said, there has to be this predicate offense, there has to be a proceeds of crime, there should be a process and activity for the starting point of PMLA. That's why, my lords, we find the mentioning of predicate offense. Otherwise, it could be any.
So you want to rely upon, you give
My
us.
lords, my lords should notice now the predicate offense. According to them, my lords, at the time when they're freezing the accounts, for them relevance is predicate offense.
Yes.
Page 93, please notice the first FIR, my lords.
Hmm.
In the first FIR, there was no money involved at all.
Hmm.
FIR in 413, for an offense under 420, it's alleged that the complainant's PAN number was posted on the website by an unknown person without the complainant's permission. Such unknown person misused the PAN number and played the game, and therefore they wanted action. This FIR is stayed by our honorable court, my lords. A challenge to this first FIR is stayed. Now we'll come to the second FIR, my lords, which is at 1.2. Second FIR involves an amount of 7 to 8 lakhs. 1.2 at page 94, my lords.
Yes.
FIR number 426, line about 6 in the bottom. The loss was about 7 to 8 lakhs. So this is one predicate offense. Third, my lords, 1.3. In this FIR, the amount involved is 2.50 lakhs, my lords. The third FIR, 32, Delhi, a fraudster posted as a complaint's brother-in-law in Australia, citing an emergency, and his loss is 2.5 lakhs.
Several lakhs of rupees were made to multiply, including to Windsor via Paytm UPI.
We have the FIR also with this, my lords. 2.5 lakhs. So totally, my lords, in these three predicate offenses, it is a case of 10 lakhs. Fourth predicate offense, which they mention, 1.4, this is subsequent to the registration of the ECIR. ECIR is registered on 6/11/2025. My lords, that date may be very, very relevant. This is what was read out now. The FIR gets registered on 24/11/2025 after the registration of the ECIR. It is not a predicate offense. So, my lords, as we have in our case, my lords, the three predicate offense, amount involved is 10 lakhs. Now, for this 10 lakhs of rupees, my lords, the freezing which they have done is 505 crores, my lords. I'm a company having 250 employees, my lords.
How much is their salary?
We've got the whole calculation, my lords. As on today, I'll give that.
Leaving out the promoters.
Yes, leaving out the promoters, my lords. So 505 crores is what is now attached, and they said we have left two accounts having 14.5 crores. No, my lords, the two accounts which they have left is 1.55 crores. It's there, my lords. We have that also. Current accounts, two current accounts.
How much is the salary for the employees?
Please, my lords. The 250. Yeah, can you pass it? There's a sheet prepared on it.
Amount in crores.
Yes, well,
So
amount in
salary
crores.
is 465 crores.
No. First one, my lords, 113 employees' salaries. 113. The total is coming up to, with the all marketing, technology, utility.
No, this is not
statutory
salary. This is what you are given is vendors dues. There's something
dues, my lord. In the bottom portion, you're not given this.
employee
two-
salaries and plus bonus.
Bonus, my lords, 113
113 what?
crores, my lords. It's all in crores. Then, my lords, marketing. Now, my lords, probably marketing what we had spent. Now it doesn't.
You anyway stopped the business. So
Yes, no, this was for, my lords, as on December 11th, 2025. That was the expenditure, my
you are
lords.
carrying on your business outside India.
Are we? No, August. No, but here outside India. Separate. Yes, well, I wouldn't, because without properly knowing it, I wouldn't. my
Please
lords.
get information by
Yes,
asking.
my lords, that's all.
If you are carrying on business outside India, you are earning from there, you can pay from there.
No, we don't have any accounts. My accounts are seized here.
You also
But
have
they've left
accounts
to-
in America.
No, not here.
You make a statement, you have no other
I will,
accounts,
my lords, this
no other
company-
business outside
Yes,
India,
my
you
lord,
make
this
a
company
statement.
whether it has.
Not this company, subsidiaries or promoters, or anybody related or associated therewith. Don't try to qualify it.
Yes, my lords, I'll find out. I'll give that whole detail. So my lords,
Company
please
is
notice.
promoters, associates, subsidiaries.
Yes, my lords. So my lords, so far as this case is concerned, on the basis of the proceeds of crime, now what is being frozen? Now, when we freeze the account, my lords, the Supreme Court says reasons to believe that we get in the act, my lords, we get it in about 8 different sections, my lords, 5, 8, from 16 to 22. Everywhere reasons to believe, it's way above suspicion. So when you're going to be freezing an account, which is under section 17(1)(a), you will have to give reasons to believe why you're going to be freezing this much amount.
Yes.
For which, my lords, you will have to say the proceeds of the crime is this much, and that necessitated the freezing of this. That should be there. Now, please notice the freezing order itself, my lords. Anywhere do they spell what's the proceeds of the crime?
Yes.
Because your freezing should be proportionate to the proceeds of the crime. Can I just point out, my lords, they read it, but it doesn't contain at all what's the proceeds of crime.
In this case, what is your turnover that you have done with these games?
My lords, according
And
to
what is the amount that people have brought into your gaming? How much people have lost? And if you are using the algorithm, it has to go back to those people. This is not the regular case.
I get, my lords.
For you to apply the regular way of working on it.
My lords, can I just clarify the game, my lords? According to them, 177 crores, which they say, are persons who have lost in this online gaming, my lords. Now, when online gaming happens, as my lords would know, you'll have win and loss.
Lose.
So the
So
correspond.
that's why we asked you, how much are the wins that you have given to people and how much are the losses which have happened? Simple question.
My lords, on instruction, they say the wins are 220 crores. So net loss to me is 42 crores. But my lords, how the company would get it is, my lords, they would get commissions on the transactions done. How the company survives, even if it has a net loss.
Place it on
I'll
record.
place it.
Place it on record.
Yes.
What is the total amount which has come in
Come
by
in,
people?
which, yes, my lords, which
What
we
is
have
the
paid.
payout which has
Payout,
happened?
yes, my lords. Because
Because
they say only the losses is 177.
here, the house always wins in a casino.
Yes, my lords.
No problem.
House always wins.
But that's because the stakes are against. But here, if you're using an algorithm or a
There
bot,
can be chances of company also losing. Unless, my lords, unless, probably, my lords.
if you're using an algorithm or bot, at least in a casino or this is worse than a lottery. Lottery, 1 lakh tickets are sold and this is how much it is. Chances of 1 in 1 lakh. Here, if you're using from what has been shown to us as a statement made by one of your own employees, to overcome which you gave that letter of 2211 to say that has not been taken into consideration. And the search which that person has done and he has given the report, which is part of the reasons to believe, clearly categorically indicates that you are mapping and matching. And it's not a real player versus a real player.
No, it's not a real player versus
So
real.
if it's the algorithm,
It doesn't. My lords, for instance, cricket online betting, my lords. Next ball, what is going to happen? They'll bet. There'll be a 2 run scored. There'll be 4 runs scored. So you're not playing against.
That is not before us. If that was before us, we would have dealt
That's
with.
online, my lords.
That is not before us.
Online betting, cricket betting.
Fortunately
anyway.
for them, it's not before us. What is before us is this matter where if you are not matching a real player to a real player and you're matching a real player to a live player to a algorithm or a bot without informing that person that you are going to be playing against a bot, and that bot is tuned by you to win, it is a big issue.
Probably that's not the case, my lords.
Then
That's
how
not
is
the
the bot
case.
trained? Are you trained the bot to lose?
Training the bot to play honestly.
Have you trained the bot to lose?
I don't know, my lords. Anyway, my lords, I'm going
bad
to
luck
stick.
it has come up before
I get
us.
it, my lords. I'm going to be sticking to PMLA alone, my lords. My lords, the
that's
larger
why we-
understanding. Yes,
Before
my
you
lords.
went into that, Mr. Chota, we said
Yes, my
this
lords,
is
my lords,
not a
can I just
matter
give the-
where the regular PMLA principles would apply when that is an offense vis-a-vis person to person. This is a offense in rem.
Yes, my lords, even for an offense
It
in
will have to
REM,
be
it is,
classified as an offense in REM.
my lords, for an offense in REM also in my respectful submission, my lords, when it comes to PMLA, it is the predicate offense.
Okay. Are you
We
going?
can't expand beyond the predicate offense when it comes to PMLA. Vijay Madan Lal Chaudhary or whichever, my lords, they would say,
Facts are different. What was the offense?
no, law, my lords, where they
Where
say,
the money came in. Facts and law have to go together.
for PMLA starting point, my lords.
PMLA starting point also. The
I
facts
can't
and law
have
will
an-
have to go together. This is a offense in REM where lakhs of people, if they are cheated, and 298 complaints have been received, but not complaints filed.
No, that's the difference,
to
my
see
lords.
that.
Now, ED, my lords, when they investigate, they don't investigate the predicate offense at all. They are only concerned, my lords, they step in when there's proceeds of crime. So predicate offense, if they get the information as rightly pointed out, my lords, they won't register it, they won't investigate it. At best, under 66(2), they pass on the information, my lords. That's all they do.
That's what they said they will
So
do.
now the starting point of this ECIR is only these 3 FIRs. And of these
Are
3,
you going to give a guarantee or a security for the amount released?
my lords, but what my instructing counsel says is, according to them, it is 177. For 177, we will give the guarantee.
177 plus 43 plus 50 plus something. Add it, we have to add it up. There are different heads. We saw that also. There are different heads which are there. And there's already
my lords,
$49 million which
proper-
has been transferred out.
My lords, my lords, everything can't become proceeds of crime, my lords. In my respectful
don't
submission,
know. We don't
when the
know right
act, my lords, when the act comes into play on 1/10/2025, my lords, all these events which they say is prior to the act, then, my lords, at that point of time, it was not an offense. It was no illegality to it. Online was allowed to be conducted. My lords, I get restricted only when an act comes into place saying that what you're doing is illegal, my lords.
So
Still,
you're basically you're not willing to give any
no,
security.
no, my lords, please don't take it like that.
Question is that answer you give it, then you argue.
My lords, no, my lords. My lords,
You may not like the questions, but
my
you
lords,
have to answer
it
the
depends
question.
what's the quantity, my lords. 505 is what is seized, what is frozen, 505. But according to them, it's 177 plus the 2
If
FIRs.
500 crores have to be released to you, are you willing to give a security for it?
Yeah, it's a, my lords, we will give it. We will give a security, my lords. They should be satisfied with security. Because Delhi High Court also, my lords, has done the same.
I'm told that there is a flight risk of these 2 persons. There is flight risk.
Flight risk is for bail, my lords. I'm not arguing a bail application here.
No, right. If they're giving security for you, consider it to get back. What kind of security?
My lords,
Let's,
I'm given to understand.
We'll
the
give a
wholly
bank
owned
guarantee.
subsidiary.
My lords,
Let us ask what
bank
kind of
guarantee itself. Bank
bank
guarantee.
guarantee.
So they'll be secure, my lords, even to that extent. My lords, in fact, in Ram Luthra versus,
We examine it, bank guarantee is being given. We are getting the whole thing.
There's one submission. The wholly owned subsidiary of this company, which is Joe Games Private Limited, they have 200 crores. And Lordship, one more submission.
That is not before us.
that's
But then
not
it's a wholly
frozen.
owned subsidiary, the entire operations.
Have you seized
Frozen
that account?
No, we have not seized it. We cannot, we did not.
We can only deal with what is before
I'm
us.
just submitting, and also Lordship, in one of the FIRs which was filed,
We are presuming that you want 700 crore guarantee. No.
in one of the FIRs which was filed in 547,
You get that, yes.
55 crores have been already frozen by the state police, Delhi police.
My lords, I've just explained the proportionality. The judgments on proportionality, my lords. One judgment of the Supreme Court, Opto Circuit, my lords, where they say, if it's going to be a case of freezing, you will have to do it in a certain manner. I'll just rely on 3 paragraphs in Opto. My lords, paragraphs 10 to 12, my lords. Keep the other judgments ready. Next is Ramalutra. 10, my lords, the scheme of PMLA is well intended. While it seeks to achieve the object of preventing money laundering and bringing to book the offenders, it also safeguards the right of the persons who would be proceeded against under the Act for ensuring fairness in procedure. Hence, a procedure including timeline is provided so as to ensure that that power is exercised for the purpose to which the officer is vested with such power, and the adjudicating authority is also kept in the loop. In the instant case, procedure contemplated under 17 of PMLA, to which reference is made above, has not been followed by the officer authorized, except issuing impugned communication dated 15/5/2020 to the AML officer seeking freezing. No other procedure contemplated in law is followed. In fact, the impugned communication does not even refer to the belief of the authorized officer, even if the same was recorded separately. It only states that the officer is investigating the case, seeks for relevant document, but in a tabular column abruptly states accounts have to be debit frozen, stop operation. It certainly is not the requirement that the communication addressed to the bank itself should contain all the details. But what is necessary is an order in the file recording the belief as provided under 17(1) of PMLA before the communication is issued, and thereafter the requirement of 17(2) of PMLA after the freezing is made is complied with. There is no other material placed before the court to indicate compliance of 17 of PMLA, more particularly recording the belief of commission of the act of money laundering and placing it before the adjudicating authority, or for filing application after securing the freezing of the account to be made. In that view, the freezing or the continuation thereof is without due compliance with the legal requirement and therefore not sustainable. Then, my lords, they try to equate it with section 102 of the CRPC. That Supreme Court says, no, it can't be done in that manner. Paragraph 12 may be noticed, my lords. The action sought to be sustained should be with reference to the contents of the impugned order or communication, and same cannot be justified by improving the same through the contention raised in the objection statement or affidavit filed before the court. Then, my lords, at paragraph, then the quashment, my lords, they would say paragraph 16, in terms thereof, the communication dated 15/5/2020 is quashed. We direct defreezing of the account. Liberty is reserved with so and so. Now, Delhi, my lords, Delhi High Court in Ramalutra versus Enforcement Directorate.
Yes.
My lords, paragraph 16 may be noticed, my lords. In the opinion of this court, the manner in which all the liquid savings of the petitioner have been completely frozen appears completely unjustified, especially when the allegations against the petitioner are merely on the realms of speculation at this stage. The letter dated 22/1/21 issued by so-and-so attaching the petitioner's entire deposit to the tune of 6 crores, coupled with the assets attached in the provisional attachment order, the total assets attached are cumulatively worth 9.23 crores, which admittedly, even as per the ED's own case, the total amount received by Centrum from so-and-so is only 5.60 crores. Some opportunity ought to have been granted to the petitioner before passing orders attaching all her accounts and deposits. Attaching all her assets was totally unwarranted. Keeping in mind the status of the petitioner and the above facts, it's directed that in place of the attachment of the assets of the petitioner, as per the provisional attachment order, the petitioner shall voluntarily keep a fixed deposit of 3 crores and shall not dispose of the immovable property number so-and-so. Details of the fixed deposit of 3 crores shall be provided to the ED within a week, subject to the above terms being complied with within a week.
This is why we asked you
Yes,
what security.
and
will
also, my lords, and also I'll point out one more ruling, my lords. JK Tire. In JK Tire, my lords,
give. Yes.
paragraph 107 may be noticed, my lords. It's at page 68, my lords. Page number is in the bottom. In the present cases, it's noticed freezing orders were passed, freezing several bank accounts belonging to 66 companies, as recently observed by the Supreme Court in Radhakrishna Industries versus State of Himachal Pradesh. In the context of GST law, freezing of bank account is a draconian measure. measure. The observation of Supreme Court reads thus. Then they extract it, my lords, to say how it could be draconian. And next page, such freezing of bank account could lead to disruption of personal lives and or of businesses. Thus, measures such as freezing of bank accounts ought to be proportionate and taken to the extent required. If any clarifications are required from authorities in the contracting state, the ED ought to seek those clarifications prior to resorting. Yes, please. So, my lords, 108.
None of this has still happened.
No, none of this has happened.
Still happened.
Yes, my lords. As of now, when you're freezing, that is what we would see, my lords. At the time of freezing, what is it you could have frozen? Proportionate. Yes. Now, if they find something more, my lords, it's always open at that point of time. But my respectful submission is we go on the predicate offense, my lords. Yes. So, my lords, we are willing to give the bank guarantee, my lords. Day-to-day operations, my lords, whatever that we run, we have 2 other platforms, just not online gaming, my lords. 2 other aspects that we do. Content creation and micro drama. These are the 3 that we do, my lord.
Creation for what?
I'm sorry.
Content
Social media, all for social media. But that doesn't involve gambling.
So what are the number of people who are employed in content creation and social drama, and what is the amount required?
My lords, my understanding is the full business, my lords. These 3 platforms are there in the full business.
You will have separate accounts for each one of them.
No.
If you don't have, we can't help you. If you have made it into hodgepodge, it will remain a hodgepodge.
No, my lords. So, my lords, to the extent of this entire amount, my lords, a bank security that could be given, my lords, bank guarantee that can be given, so that at least our operations can continue. And so far as CCTV footage is concerned, we'll straight away ask for an application in 12 hours. It will enable us to argue our bail, my lords. This is the prayers that we have.
So, rest of it we'll reserve.
One more submission.
Bank guarantee, are you acceptable, not acceptable?
I have to
You
take
get instruction and make your submission. We'll have it in the afternoon? Paso?
Please, I will ask. That's one submission.
Yes.
Section number 23 and 22.
You have relied only on these 3 judgments. Though you have referred to Vijay Madan Chaudhary, you have not referred to or relied upon it in your arguments. We are not going to be dealing with it.
No, my lords, no. I will not, because it expands the scope of the relief I'm asking. My relief that I'm asking is these 2 folds, my lords. Yes. Defreezing of the account and the CCTV footage for me to argue my bail matter. These are the 2 reliefs I'm restricting.
Yes, Madhu.
Once, last 2 minutes of submission. Page number 292 of my
292 of your what?
My citations, madam.
You filed citations.
I'm just giving now.
You're not relied on anything till now.
I'm giving, madam. Adu second volume, second. Adralli, page number 292, madam. Idu itkolli. Continuation.
We'll only be referring to citation which are referred and relied on during argument.
Please,
nothing else.
Please.
You may dump 1,000 pages. We won't be referring to it.
Page number 292. Now, these judgments, what has been cited by the senior counsel, is all prior to 2021. Now, this is a judgment, Vijay Madan Lal Chaudhary, which came in 2022, bench of 3 judges. Now, lords, kindly, if my lords were to go through from 77 up to 86. Now, lords, they have told that section 17 is a full-fledged mechanism which is available. So, therefore, my lords, the argument of 1 or 2 CRPC is not applicable. Therefore, lords, the entire, I don't want to read section, page number, para number 77 up to 85. Now, lords, in as many number of words, the Supreme Court has held that section 17 with regard to seizure and search and also with regard to freezing, it's a self-contained code. It cannot borrow the provisions of the CRPC. And my argument remains same even for BNSS also, because section 4, section 5 of BNSS is same as that of the erstwhile section 4, section 5 of CRPC, and read with section 71 and section 65. So therefore, my lord, those judgments would not be applicable in such cases.
Just, my lords, latest 2025, because they gave Vijay Madan Lal, kindly notice the latest judgment, 2025.
Table tennis match.
No, because they're saying they gave it now, my lords. Vijay Madan Lal, after that, no judgment at the 2025. This is the view, my lords. Paragraph 58 may be noticed, my lords. Paragraph 58. at page
The
24.
Delhi High Court, not of the Supreme
No,
Court.
Delhi High Court. Kindly, my lords, all this is post Vijay Madan Lal. Kindly notice paragraph 54, 58, my lords. The freezing order dated 5/9/2018 themselves do not disclose any such reasons to believe, nor do they refer to any records from which such conclusions can be inferred. On the contrary, the order records that it is suspected that amounts involved in money laundering are lying in the above mentioned bank accounts. 61 may be noticed, my lords. In our considered opinion, does not meet the prescribed standards of formation of reasons to believe. Suspicion, as it's apparent from the definition, is more in the nature of a subjective state of mind, which that may be minimal or no basis at all. Reasons to believe is in the nature of a preliminary objective assessment. Then Radhika Agarwal is quoted, my lord. And thereafter, the quote at paragraph 68, 66, my lords, 66 may be noticed. It is a settled position that the scheme of PMLA is designed to strike a delicate balance between the extensive powers conferred upon the enforcement authorities, fundamental rights of individuals. For this reason, the statutory provisions governing such search and seizure or freezing of properties are hedged with procedural safeguards. These safeguards serve as check against arbitrary action and ensure that the intrusion into private rights is proportionate, lawful, and subject to judicial scrutiny. The efficiency of lawful. Then, my lords, finally, they bring it even under Article 300, Subarticle 1, my lords. Subarticle A, actually. 68, it must also be borne in mind that freezing of a bank account is violation of statutory requirement, has far-reaching consequences. Such action directly impinges upon the constitutional right to property guaranteed under Article 300A of the Constitution of India, which mandates that no person shall be deprived of property except in accordance with law. So even now the position is the same, and also my judgments which I gave earlier.
You have to place on record the details of the total incoming amounts, total winnings and total losses which have occurred.
Deeply obliged.
And the details of all your subsidiaries,
That's one.
associates, etc., if you're carrying on the business, and what their income is, what their turnover and income is.
One last submission.
And you will have to get back on
Yeah,
the
last
bank
submission.
guarantee.
Section number 24 of PMLA, the burden of proof in any proceeding.
Reverse burden.
Oh, no.
The point is,
Foundational facts have to be proved before we go to a burden. That's what is held in
The
Vijay
burden is
Madan
not
Lal
going to
itself. 3 foundational facts.
if I may, my lords, if it can be taken up tomorrow, because we need to
Tomorrow.
consult.
Heard, Shri. Madhu N. Rao for respondent. Shri Sandesh Chota, learned senior counsel for the petitioner. Shri Sandesh Chota, learned senior counsel, submit that the petitioner is willing to offer a bank guarantee as security for the like amounts which have been frozen by the respondent in order to enable the release, defreezing of the said accounts. He also seeks for a day's time to place on record the details of the businesses carried out by the petitioner, its associates, subsidiaries, etc., promoters, etc., outside the Republic of India, the turnover thereof, income, as also income. Learned Shri Madhu N. Rao seeks for a day's time to obtain instructions and make a submission as to whether the bank guarantee would be acceptable or not. Insofar as the provision of the CCTV footage is concerned, Shri Madhu Rao on instructions of so-and-so, who is present before this court, submits that if an application is made by the petitioner under section 21, the same shall be processed and CCTV footage made available subject to the time taken to copy the CCTV footage. His submission is placed on
Placed
record.
on record.
Released tomorrow
Immediately.
Obliged.
in preliminary hearing. ಇದು ಕವರಲ್ಲಿ ಹಾಕ್ಬಿಟ್ಟು ಸ್ಟೇಪಲ್ ಮಾಡಿ ಒಳಗೆ.
My lords, may I seek the leave of this honorable court, my lord, serial number 39, my lord. As I appear for the respondent, my lord, I filed a memo for disposal in the petitioner advocate notification in respect of Pavagada. I think, my lord, the learned counsel,
What does the petitioner want to do? Withdraw?
he just wants to participate in the tender. Because now, during the subsistence of
So you are willing to permit them to participate?
let them, if in accordance with law, my lord, if they.
In accordance with law is again qualified. If you are going to permit them,
My lord, there's a new tender notification, my lords. What had happened, my lords, initially they had challenged one of the tender conditions.
madam, you are mentioning at 1:30.
My lords,
If
so-
you are willing to, for them to participate without any conditions,
My lords,
subject to,
subject to the tender conditions, my lord. Let them participate.
The conditions itself was challenged, my lords. Therefore.
then we'll have to decide. Then there's nothing.
Serial number 91, my lord. 91.
ಬರ್ತೀವಪ್ಪ ಎಲ್ಲೂ ಹೋಗ್ತಾ ಇಲ್ಲ. We'll come back. ಬೇಡ ಅಂತೀರಾ ಬರೋದು? We won't come back.
No,
You
my
won't
lord,
come
I'm
back.
moving a memo, my
91
lord.
ಅಲ್ಲಿ delay
I'm
one
moving
day.
a memo.
Memo.
Only for the reason is that, my lord, after the death of my husband, I made a representation to run the sawmill which is existent from 1978. It is run from 1978. Now the forest department is coming and day to day they are trying to stop the sawmill. And more than laborers, I mean, their livelihood are.
ನಾಳೆ ತಗೊಳ್ಳಿ, tomorrow.
Kindly, my lord.
Item 37.
37.
Item 37, this NCLT, there was some delay in uploading the order. Lord, I have had a discussion with the deputy registrar. She is filing an affidavit. So they have now
He'll
uploaded.
come back. Let Mr.
Very well.
Let Mr. Kumar be there this time.
My lord,
ನಿನ್ನೆ
serial
ಸರಿಯಾಗಿ
number
ಬ್ರೀಫ್ ಮಾಡಿಲ್ಲ, ಸರಿಯಾಗಿ ಬ್ರೀಫ್ ಮಾಡಿ ಅವ್ರು.
I was online. I was not permitted. I was online. I was not keeping well. I was online.
I
was
believe
not
when that
permitted.
matter was taken.
Did you select the number?
Yes. I raised.
ಯಾಕೆ ನೋಡಿ ಹೇಳಿ ಅವ್ರು.
Yesterday.
ಇನ್ನಿಬ್ರು ಅದೇ situation.
That was the problem that was some 15 days back. That was sorted out. Now if you select the list, quote all list number and serial number, all three have to match. Then you are automatically allowed.
Lord, even yesterday, day before yesterday, my lord, they have selected the matter earlier and also after that it is not selecting, like that is the complaint.
Sometimes it comes, it will not permit. That's the problem. Sometimes it won't permit. Sometimes it automatically permits. No,
It is a machine. It doesn't know when not to permit. It just has to follow blindly.
I have to select ABCD items. That's all.
We'll come
Yes.
back.
Kodi tomorrow.
My lord,
Serial number.
Yes. Tomorrow.
My lord, serial number 75, my lords.
My lord, serial number.
We can't take it out of the hat and give you the file. We find out where it is.
my lord, serial number 75, my lord.
Huh.
Kindly take it up after vacation, my lord. After vacation.
75.
Yes, my lord. For petition.
At the request of counsel for the petitioner, it will go to February.
Interim order may be.
ಇದೆಯಾ ಅದಕ್ಕೆ adjournment February interim order
86, my lord.
86.
I filed the memo for withdrawal, my son, for the petitioner.
86 memo of withdrawal dismissed as withdrawn pending IS
But
and
interim order may be extended in 7.
extended, madam.
Serial number
Other-
36, my lord. Afternoon, may I take it?
Yes.
My lord, serial number 40, my lord. For non-amendment, after.
40. Counsel for the petitioner seeks for and grant 3 weeks time, February.
My lord, 47, my lords.
Huh?
6 time after vacation.
47 same order.
Lordship, serial number 48, can it be afternoon? Afternoons.
We are coming back, don't worry. You don't want us to come back, you tell us, we won't come back.
ಅಲ್ಲ 15 ನಾವಲ್ಲ ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ 15 ಅಂತ ಬರದ್ರು ಅಂತಾನ ಒಂದ್ ನಿಮಿಷ ನಮ್ ಬುಕ್ಕಲ್ಲಿ ಹೋಗಿದ್ಯಾ ಅಂತ ನೋಡಿದ್ರೆ ಚೇಂಜ್ ಮಾಡ್ಕೊಡ್ತೀನಿ. ನಾನು ಇಲ್ಲಿರ್ತೀನಿ, ಯಾವ ಸೈನ್ ಆಯ್ತು ಬಿಡ್ತು ನನ್ಗೇನು ಗೊತ್ತಾಗಲ್ಲ, ಎಲ್ಲ ಅಲ್ಲಿ ಬರುತ್ತೆ ಫೈಲ್ಸ್.
ಬಿಕಾಸ್ ನಾನು ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್ ಹೋಗಿ ಬಂದೆ ಆಲ್ರೆಡಿ, ಅದಕ್ಕೆ.
ಅವ್ರು ಬಂದಿರಲ್ಲ ಗೊತ್ತು, ನನಗೆ ಸ್ಟೆನೋಗ್ರಾಫರ್ ಇಂದ ಬರ್ಬೇಕಪ್ಪ, ಆರ್ಡರ್ ಜಡ್ಜ್ ಇಂದ ಸೈನ್ ಹಾಕ್ಬೇಕು. ಅದು ಬಂದಿದ್ಯಾ ಅಂತ ನೋಡ್ಕೊಳಕ್ ನಾನು ಇಲ್ಲಿರ್ತೀನಲ್ಲ, ನೀವ್ ಹೇಳಿದ್ಮೇಲೆ ಅಲ್ಲಿ ಯಾರಿಗಾದ್ರೂ ಹೇಳಿ ನೋಡ್ಸಿಸ್ಬೇಕು.
ಇವಾಗ 47 ಡೇಟ್ ಕೊಟ್ರಲ್ಲ ಆಫ್ಟರ್ 3 weeks ಅಂತ, ಯಾವ
18 ಫೆಬ್ರವರಿ
18 ಫೆಬ್ರವರಿ.
ಹೌದು, ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಸ್ಟ್, ಥರ್ಡ್ ಲಿಸ್ಟ್ ಓದಿದೆ ಒಂದು, ಹೌದು, ಆಮೇಲೆ ಪಾಸ್ಟ್ ಓವರ್ಸ್, ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ.
ಮ್ಯಾಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 58 ರೀಚ್ ಆಗ್ಬೋದಲ್ಲ? ಅಡ್ಜರ್ಮೆಂಟ್ ಸೆಂಟ್ರಲ್ ಆಗಿದೆ ಅಂತ ಅನ್ಸುತ್ತೆ.
58 ಇದೆ,
ರೀಚ್ ಆಗ್ಬೋದು?
ಗೊತ್ತಿಲ್ಲ, ಅದು ಗೊತ್ತಿಲ್ಲ. 48 ಇದೆ ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಆಮೇಲೆ ಥರ್ಡ್ ಲಿಸ್ಟ್, ಆಮೇಲೆ ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಕಂಟಿನ್ಯೂ ಇದೆ. ಇಷ್ಟಿದೆ ಪಾಸ್ಟ್ ಓವರ್ಸ್, ಇಷ್ಟಿದೆ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಒಂದು 21 ಮ್ಯಾಟರ್ ಏನೋ ಇದೆ. 4 ಗಂಟೆಗೆ ಬರೋದು ಅದು. ಅದೇ ಆಮೇಲೆ ಡೇಟ್ ಎಲ್ಲ ಅಪ್ಡೇಟ್ ಮಾಡ್ತೀವಿ, ಚೆಕ್ ಮಾಡ್ಕೊಂಡು ಅಷ್ಟೇ. ಅಲ್ಲಿದ್ಯಾ ಕೊಡು. ಅದು ದಿನಕ್ಕೆ ಒಬ್ಬೊಬ್ರು ಬರ್ತಾರಲ್ವಾ, ಅವ್ರು ಯಾವ್ದೋ ನೆನ್ನೆ 15ರಲ್ಲಿ ಇದ್ರೋ ಏನೋ, ಹಂಗಾಗಿ ಹಂಗ್ ಮಾಡಿರ್ತಾರೆ.
ನಾಳೆ ಒಂದಿದ್ರೆ ಎತ್ಕೊಡೋಗ್ಬೋದು.
ಇನ್ನು ಹೊಸದಾಗೆ ಬರೋದಿಲ್ಲ. ನೀವೇ ಕೊಡ್ಬೇಕು. ಅದು ನಾಳೆ ಮಾತ್ರ ನನ್ನ ಹತ್ರ ಸೈನ್ ಮಾಡಿಸಿ ಕಳಿಸಿ, ಮಿಕ್ಕಿದ್ದೆಲ್ಲ 18 ಫೆಬ್ರವರಿ. ಯಾವತ್ತಿತ್ತು? ಕೋರ್ಟ್ ಹಾಲಲ್ಲಿ ಇರೋದಿಲ್ಲ, ಸ್ಟೆನೋಗ್ರಾಫರ್ ಹತ್ರ ಇರುತ್ತೆ. ಕೋರ್ಟ್ ಹಾಲಲ್ಲಿ ಒಂದು ಫೈಲು ಇರಲ್ಲ. ಇವತ್ತಿನ ಫೈಲ್ ಬಿಟ್ರೆ ಬೇರೆ ಫೈಲ್ಸ್ ಇರಲ್ಲ.
ಸಿಗ್ನೇಚರ್ ಕೇಳ್ತಾರೆ, ನಾವು ಬರ್ಕೊಂಡ್ ಬಂದ್ಬಿಟ್ಟು
ಹೊಸದಾಗೆ ಬರೀತೀನಿ. 18 ಅಂದ್ರೆ ಆಗೋಯ್ತಲ್ಲ, ನಾಳೆಗೆ ಬರೀತೀನಿ. ಫಸ್ಟ್ ರೀಚ್ ಆಗೋದು ಬಿಡೋದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಥರ್ಡ್ ಲಿಸ್ಟ್, ಪಾಸ್ಟ್ ಓವರ್ಸ್, ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ.
ಈ ಫೈಲ್ ಇವತ್ತು ಆಕ್ಚುಲಿ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ. ನಾವು ಅದಕ್ಕೆ ಮೆಮೊ ಮೂವ್ ಮಾಡಿ ಹೇಳಿದಕ್ಕೆ ನಾಳೆ ಅಂತ ಹೇಳಿದ್ರಂತೆ. ಸೊ ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್ ಹೋಗಿದ್ರೆ ಇನ್ನು ಫೈಲೇ ಬಂದಿಲ್ಲ ನಮ್ಗೆ.
ಒಂದ್ ನಿಮಿಷ. ಕೇಸ್ ನಂಬರ್ ಹೇಳಿ ನನಗೆ. ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆಗಿದ್ರೆ ಫೈಲ್, ಒಂದ್ ನಿಮಿಷ ಲಾಗಿನ್ಗೆ ಹೋಗ್ತೀನಿ. ಹೇಳಿ. ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್
39 RP ನಂಬರ್ 394 of 25.
ಲೆವೆಂತ್ ಬಂದಿತ್ತಲ್ಲ, ಅದು ಆರ್ಡರ್ ಇನ್ನ ಅಪ್ಲೋಡೇ ಆಗಿಲ್ಲ.
ಅಲ್ಲ ಇವತ್ತು ಬರ್ಬೇಕು.
ಅದೇ ಅದು ಇಲ್ಲಿ ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆದ್ರೆ ಮಾತ್ರ ನಮ್ಗೆ ಫೈಲ್ ಬಂದಿರುತ್ತೆ, ಇಲ್ಲ ನಾನು ಯಾರಿಗೋ ಸ್ಟೆನೋಗ್ರಾಫರಿಗೆ ಕೊಟ್ಟೆ, ಯಾರಿಗೆ ಅಂತಾನು ಹೇಳ್ತೀನಿ. ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳ್ಬೇಕು ನನಗೆ. ಯಾವತ್ತು 11ನೇ ತಾರೀಕು ಲಿಸ್ಟ್ ಆಗಿತ್ತಲ್ಲ,
ಅದ್ರ ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳ್ಬೇಕಾ?
ಯಾರಿಗೆ ಕೊಟ್ಟೆ ಅಂತ ನನಗೆ.
ಮೇಡಮ್ 35 ಪಾರ್ಟೆಡ್ ಆರ್ಗ್ಯುಮೆಂಟ್
ಇಲ್ಲ, ನಾಳೆ ನಾಳೆ ನೋಡ್ಬೇಕು, ಮಧ್ಯಾಹ್ನ ಕಾಯ್ದು ನೋಡ್ಬೇಕು. ಮತ್ ನಾಳೆ ಇದೆ ಅದು, ಅದ್ರದ್ದು ಮುಗೀತು. ನೆಕ್ಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಥರ್ಡ್ ಲಿಸ್ಟ್, ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಕಂಟಿನ್ಯೂ ಕಾಯ್ಬೇಕು. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 2:30 ಅಂತಾನೆ ಇದೆ, ಹಂಗಾಗಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 2:30, ಥರ್ಡ್ ಲಿಸ್ಟ್ ಅದು 2:30, ಆಮೇಲೆ ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಯಾವ್ದು 2 ಇದೆ, ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ. ಪಾಸಿಟಿವ್ ಆಗಿ ಯೋಚನೆ ಮಾಡ್ಕೊಂಡು ರೀಚ್ ಆಗುತ್ತೆ ಅಂತ ಕಾಯಿರಿ. ಕಾಫಿ ಕುಡ್ಕೊಂಡು ಊಟ ಮಾಡ್ಕೊಂಡು ನಿಧಾನಕ್ಕೆ ಬನ್ನಿ. ಅವತ್ತಿಂದು 12 ಅಲ್ಲ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಎರಡೇ ಅದು PRS ಅಂತ ಚೇಂಬರ್ ಅಲ್ಲಿ ಇರ್ತಾರೆ. PRS ಅಂತ ಅವ್ರ ಕಡೆ ಫೈಲ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಅರ್ಜೆನ್ಸಿ ಇದೆ, ನಾಳೆ ಇವತ್ತೇ ಬರ್ಬೇಕಾಗಿತ್ತು, ಬಂದಿಲ್ಲ. ಅದೇನೋ ಅವ್ರು ಕನೆಕ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆಲ್ಲ ಆರ್ಡರ್ ಆಯ್ತಲ್ವಾ? ಈ ಫೈಲ್ ಬಂದಿದ್ಯೇನಪ್ಪ? ಇದ್ರೆ ಹಿಂಗ್ ತೆಗೆದು ಹಿಂಗೆ ಕೊಟ್ಬಿಡ್ತೀನಿ. ಇದ್ಯಾ? ನೀವು ನೋಡಿದೀರಾ? ಬರ್ಲಿ ಇರಿ, ನಮ್ಮ ಹುಡ್ಗ ಬರ್ಲಿ ಎತ್ಕೊಡ್ತಾರೆ. ಮಾಡಿಸ್ಕೊಳ್ಳಿ. ಕಂಪ್ಯೂಟರ್ ಅದೇ ಇದು ನನ್ನ ಎಲ್ಲರನ್ನು ಅಲೋ, ನಮ್ದು ಬೇರೆ ಸಿಸ್ಟಮ್, ನಮ್ದೇ ಬೇರೆ ತರ ಅಲೋ ಮಾಡ್ಬೇಕು. ಆಯಾ ಕೇಸ್ ಮಾತ್ರ ಎಲ್ರನ್ನು ಒಟ್ಟಿಗೆ ತಗೊಂಡು ಗಲಾಟೆ. ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಥರ್ಡ್ ಲಿಸ್ಟ್, ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಕಂಟಿನ್ಯೂ. ಬರ್ಲಿ ಬಂದಾಗ. ಎರಡು ಟೈಮ್ ಎಷ್ಟು? ಎರಡ ಬರ್ಲಿ ಬಂದಾಗ. ಹಾ ಸರ್ ಮಾಡಿ, ದಿನ ಇದೇನೆ, ಇವತ್ತೇನ್ ಸ್ಪೆಷಲ್ ಏನಿಲ್ಲ. ಯಾರು? ಜಯದೇವಪ್ಪನ್ ಕೇಳ್ಕೊಳ್ಳಿ. ಮುಗ್ದಿರಲ್ಲ, ಮೇ ಬಿ ಕೆಲ್ಸ ಮುಗಿಯಲ್ಲ ಅದು. ದಿನ ರಾತ್ರಿ 10 ಗಂಟೆವರೆಗೂ ಮಾಡ್ತೀವಲ್ವ ಕೆಲ್ಸ. ಅದಕ್ಕೆ ಮುಗಿಯಲ್ಲ ಕೆಲ್ಸ ನಮ್ಮದ್ರಲ್ಲಿ. ಇಡೀ ದಿನ ಒಬ್ರಿದ್ರು ಅವ್ರ ಕೈಲೂ ಆಗಲ್ಲ. ಇನ್ನು ಅರ್ಧ ದಿನಕ್ಕೆ ಸ್ವಲ್ಪ ಹೊತ್ತಿಗೆ ಬಂದ್ರೆ ಎಲ್ಲಿ ಕೆಲ್ಸ ಆಗುತ್ತೆ? ಏನ್ ಬೇಕು ಸರ್? ಕವರಲ್ಲೇ ಹಂಗೆ ಸೀಲ್ಡ್. ಅದೇನೋ ಅವ್ರ ಫೈಲ್ ಇದ್ರೆ ಕೊಟ್ಬಿಡಪ್ಪ. ಅಲ್ಲಿ ಇದೆಯಂತೆ, ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ, ಅಲ್ಲಿ ಇದೆಯಂತ ಇದ್ರೆ ಕೊಟ್ಬಿಡು. ಇಲ್ಲ ಆಗ್ಲಿಲ್ಲ. Until then the respondents are restrained from taking. ಇದೆಯಲ್ಲ, ಇದೆ. ಆದ್ರೆ ಇದು ಅಪ್ಲೋಡ್ ಆಗಿಲ್ವಾ? ಇನ್ನೊಂದ್ಸತಿ ಚೆಕ್ ಮಾಡಿ. ಇವಾಗ ಇದು ನೋಡ್ಬಿಟ್ಮೇಲೆ ಇನ್ನೊಂದ್ಸತಿ ಫೋನ್ ತಗೊಳ್ಳಿ. ನಾನೇನಪ್ಪ ಮಾಡ್ಲಿ ಈಗ? ನಾನು ಹೋಗಿ ಹುಡ್ಕೊಂಬರ್ಲಾ? ನಾನೇನ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದನ್ನ ಅಷ್ಟೇ ಹೇಳಿ, ನನ್ಗೆ ಇನ್ನೇನು ಹೇಳ್ಬೇಡಿ. ನನಗೂ ಅಲ್ಲ, ಈಗ ನಾನೇನ್ ಆಗಿ ಬರ್ತಾರೆ, ಇವಾಗ ಬರಲ್ಲ. ಅಲ್ಲ, ನಿಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಕರೆದಾಗ ಅಲ್ಲವರೆಗೂ ಬರಲ್ಲ ಯಾರು. ಅದು ಬರೀ 1:30 ಒಂದ್ಸತಿ, 10:30 ಒಂದ್ಸತಿ, ಇವಾಗ 2:30 ಒಂದ್ಸತಿ, ಬರೀ ಸಬ್ಮಿಷನ್ ಮಾಡಕ್ಕೋಸ್ಕರ, ಆರ್ಗ್ಯೂ ಮಾಡಕ್ಕಲ್ಲ. ಆರ್ಗ್ಯೂ ಮಾಡೋದಕ್ಕೆ ಕೇಸ್ ಕರೆದಾಗ್ಲೇನೆ ಮಾಡ್ತಾರಾ? ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್, ರೀಚ್ ಆಗುತ್ತೋ ಇಲ್ವೋ ಗೊತ್ತಿಲ್ಲ. ಇಲ್ಲ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಸ್ಟ್, ಥರ್ಡ್ ಲಿಸ್ಟ್ ಪಾಸ್ಟ್ ಓವರ್ಸು ಕಂಟಿನ್ಯೂ. ಈಗ ಸಬ್ಮಿಷನ್ ಮಾಡಿ. ಬೆಳಗ್ಗೆ ಆಯ್ತಲ್ವಾ, ಆಗೋಯ್ತು. ವಿಡ್ರಾನೇ ಅದು. ಆಯ್ತು, ಆಗಿತ್ತು. ಕೇಳಿ ಮೇಡಮ್, ಕೇಳಿ. ನೋಡಿ ಈಗ ಅದೇ ಯಾವ ಮ್ಯಾಟ್ರೋ ಗೊತ್ತಿಲ್ಲ, ಒಟ್ಟಿನಲ್ಲಿ ಎಲ್ರು ಇದ್ದಾರೆ. ಎಲ್ಲಿದೆ? ಇವತ್ತು ಆಗೋಯ್ತು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀವಿ. ಇವತ್ತು ಆಗೋಯ್ತು. ಯಾರು? ಆರ್ಯು. ಹೆಸರು ಅವ್ರು ಕೇಳಿದ್ಮೇಲೆ ಕೊಟ್ರು. ಕೇಳಿದೆ, ಇಲ್ಲಿ ಹಿಂಗ್ ತೋರಿಸ್ತಿತ್ತು, ನಂಗೆ ಹೆಸರು ಬೇಕು ಅಂದಿದ್ದಕ್ಕೆ ಅವ್ರು ಕೊಟ್ರು. ಆಮೇಲೆ ಫೋನ್ ಮಾಡಿ ಕೇಳಿ ತಗೊಂಡಿತ್ತು. ಹಂಗೆ ಯಾರು ಕೊಡಲ್ಲ. ಯಾವಾಗ ಮಾಡ್ಲಿ? ರಾತ್ರಿ 10 ಗಂಟೆಗೆ ಫೋನ್ ಮಾಡಿದ್ದು ಬೇಕು ಕೇಳ್ತಿದ್ದಾರೆ ಅಂತ. ಫೋನ್ ನಂಬರ್ಗೆ ಫೈಲ್ ಯಾವಾಗ ಮಾಡ್ಲಿ ಫೋನು? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೆಲಸ ಇತ್ತು. ಕೇಳಿದ ತಕ್ಷಣ ಹೇಳಲಿಲ್ಲ ಅಂದ್ರೆ ಎಲ್ರಿಗೂ ಕೋಪ. ನನ್ಗೇನೆಲ್ಲ ಗೊತ್ತು ಅನ್ನೋ ಥರ. 4 ಗಂಟೆ ಮೇಲೆ.
Serial number 113. First it will be taken out of terminal by.
We'll see if it.
Some correction. It's our being spoken just for it.
113 is awaiting service.
And it's true, man. That is not order. Notice not order all the respondents. I was.
You want notice to be ordered on all the respondents?
All respondents and the deputy CL is respondent number. It is wrong.
We'll see that.
My Lordship, serial number 97, my Lordship. In the last date of hearing, my Lordship, this court directed us to implead a state as the party, wherein I filed the application, I have served the copies to the other side, my Lordship. If the application is allowed, I'll carry out the necessary amendments, my Lordship.
97, Mr. Sridhar said there's some urgency. He wants.
Yes, my Lordship.
Serial number 96, my Lordship.
I am for petitioner.
We'll see if it reaches. Yes.
My Lord, it is third time it gets reached, my Lord. Never reached, my Lord.
ಏನ್ ಮಾಡೋದಪ್ಪ ಇವಾಗಲೇ ಅರ್ಜೆಂಟ್ ಮಾಡೋಣ. If it reaches, we'll take it up. Yes.
My Lordship, 96 serial number.
90?
Serial number 96, my Lordship.
96.
Yes, my Lord. 61 maybe date ಗೆ maybe ಬಂದ. 61 ಕೊಟ್ಟು.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ?
ಬಂದಿಲ್ಲ.
ಶುರು.
List number 2. Pronouncement.
Unmentioned, my Lord. Sorry. One mentioned list one, serial number 82, my Lord. 82 in list 1, my Lord. This is the bank freezing, my Lord, pursuant an arbitral award. The bank has issued communication saying there's no specific order by the High Court defreezing the account. Therefore, get clarification from the High Court is what they say, my Lord.
Should we go by the list or should we go by each one mentioned?
I'm just requesting.
Please wait.
Please.
Serial number 1, Lakshmi S. Holla. ಒಂದೇ ತಂದಿದ್ದಲ್ಲ, ಇನ್ನೊಂದಲ್ಲಿ.
Okay. Next number. ಇದೆಯಾ?
One ಇದೆ. Serial number 2, Chetan AC.
Review of my answers to point number 1 to 4, no grounds being made out, the petition stands dismissed. Liberty, however, is reserved to the members of the petition to approach the appropriate court seeking for appropriate relief.
Serial number 3, Sakshi M. Krishna.
As this matter pertains to the reissuance of passport of the minor, your lordship directed me to file an affidavit stating that there is no pending proceedings between the parties. I may be permitted to place it on record. My lords, my only submission is your lordship on the last date also has observed that there is some sort of there is no clarity in the divorce decree as well with respect to the custody, but the minor child has been living with the mother since 2016 and the father has made no attempt to contact the child either through the mother or directly, my lords. And by virtue of this affidavit, your lordship on the last date said it could be directed for them to consider the application, because even under the passport rules, my lords, single parent can make an application under Annexure G and the authorities are to consider that application.
Single parent can make subject to the custody
Please.
and any rights of visitation otherwise of the other parent.
Please. And there is a limited visitation rights accorded to the father as well, but since 2016 he has made no attempt to even avail those rights.
So this was by mutual consent, 13B this was.
Please.
And in 13B there is nothing as regards custody.
My lords, in page number 22, that is all it says. The minor child has been living with the mother and will
Correct.
continue to do so in the future as well.
Take the undertaking, that's all.
That should not come in the way of
Where are the visitation rights? Where are the visitation rights?
Case number 28.
Yes.
It is agreed between them that applicant number 2 will meet his daughter, Navika, once a month on any day, preferably Sunday, convenient to her. After giving prior notice to applicant.
Subject to that.
that is only with respect to the visitation, my lords, nothing to
Subject
do
to
with
that.
custody.
This matter they have made as part.
You already booked their ticket, the husband is not interested. Why are you creating problems?
Then only RPO, my lords, I am not able to understand why they are
They send the WhatsApp, no response.
from the effort is being made for the consideration of the passport from August, my lords. And
Yes, but this is where divorces happen and visitation right is there. And they are undertaking that they'll comply with the visitation rights.
If they would take not child to abroad.
Huh.
According to our.
He has not even come once for visitation right is a submission made. He won't appear here and there are issues, then we would always consider. Petitioner is before this court seeking for the following reliefs. Petitioner number 1 is the mother of petition number 2, arising from and out of the petition number 1 and respond number 3 are wife and husband respectively, and from their wedlock, petition number 2 has been born, who is now about 10 years old. The petitioner and respond number 3 have obtained a divorce by mutual consent under section 13B of the Hindu Marriage Act on 2/5/2017. Pursuant thereto, the petitioner has been residing in Bangalore. The petition number 2 daughter has been residing with petition number 1 in Bangalore. The categorical submission made by the counsel for the petitioner is that though under the decree of mutual consent, under the mutual consent divorce, there's visitation right which is provided to the husband stroke father. The father has never visited or exercised the visitation rights from the year 2017. The petitioner having made petition number 1 having made an application on behalf of petition number 2 for issuance of a passport, the said application was not considered by the respondents on the ground that the requirement of Annexure D to the passport rules, Annexure C to the passport rules 1980 have not been complied with, inasmuch as the signature of the father is not found on the application. In the present matter, the petitioner has enclosed the decree of divorce along with the application, categorically stating that the petitioner number 1 and petition number 3's marriage has been dissolved by way of such decree. The only reason why the application was not processed by the respondent is on account of the said decree of divorce not categorically mentioning as to who would be in custody of the minor petitioner number 2, and without the signatures of petition number 2, respondent number 3, the said application of petition number 2 cannot be processed. A perusal of the decree, though silent on custody, would indicate that the petitioner number 1 and petition number 3 have separated in the year 2016, from which date, from 2012-2016, from which date petition number 2 minor has been staying with the petition number 1 mother. And in terms of the said decree, a sum of rupees 51,00,000,000 has been paid by respondent number 3 father, which is to be retained in a fixed deposit in the name of petition number 2. The categorical submission made on oath by the petitioner is that thereafter, that though under the said decree, respondent number 3 would be entitled to meet the minor petition number 2 once a month on any day, preferably Sunday, convenient to her after giving prior notice to petition number 1. The submission made by learned counsel for the petitioner is that respondent number 3 has not exercised the said right from the year 2017 till date. And despite several mails and WhatsApp messages having been sent to respondent number 3 as regards the passport and seeking for as regards the issuance of the passport and for no objection on his part, there is no such document which has been submitted by respondent number 3, and in that background the learned counsel for the petitioner submits that there is no objection as such on part of respondent number 3 for issuance of the passport when such correspondence had ensued. The categorical submission on part of the petitioner and undertaking given is that petition number 1 shall comply with the visitation rights as contained in the decree of divorce aforesaid. In that view of the matter, I am of the considered opinion that the travel which is contemplated by the petitioners is being only for holiday and a passport being required for the same.
Malak, may I make one submission? I have not contended anything regarding the travel.
You had said holiday, no?
No, Malak, I have not.
Only in terms of renewal.
Earlier, they had issued a temporary passport while the divorce proceedings were pending, and subsequently.
Considering that earlier a passport had been issued to the petitioner, to petition number 2, and now what has been sought for is reissuance. and there being no particular objections on part of respondent number 3, despite emails and WhatsApp messages having been sent, the passport could be reissued in favor of petition number 2. As such, I pass the following order. Writ petition is allowed. Respondent number 2 is directed to process and issue the passport of petition number 2 based on the undertaking to be furnished by the petitioner, that the petitioner shall comply with the visitation rights as contained in the decree of divorce dated 1st April 2022 in case number 99 of 2020 passed by the Family Court, Jaipur Metropolitan First Court.
They file an HSC note that the other parent is not giving consent. Will not the passport authority will issue notice
And submit an annexure C, on the basis of which the passport authorities could issue necessary notices to the respondent number 3 and process the
Plus,
application.
may I make one submission? In the month of August, the application was made for reissuance. Nothing could have prevented them to issue a notice to the father.
You should file annexure C, madam.
It is filed, my lords.
You
were
filed
only-
annexure C. Have you filed annexure C?
Please, my lords.
Where is annexure C? Have you filed?
They were directing the petitioner to obtain the consent, and the same was
Have you
communicated.
filed annexure C with the
Not with the
RPO?
affidavit. No, my lords.
Now you file it, they'll process it.
Please, within a time frame, my lords.
Madam, you have wasted time till now.
No,
So
I
please,
understand.
they'll do it.
Obliged.
Pronouncement of order, serial number 1. Lakshmi S. Holder.
Writ petition is partly allowed. Petitioner is granted liberty to file necessary application to Deputy Commissioner Udupi for grant of 10 kgs of sandalwood, which application is directed considered by respondent within 30 days of such submission. And said 10 kgs will be made available to the petitioner as per the applicable policy. The Principal Secretary, Ecology, Forest, etc. is directed to consider whether institutions like the petitioner could grow their own sandalwood trees for the express purpose of usage in religious practices for the purpose of the temple. If so, to formulate a necessary policy in that regard.
Highly obliged.
Serial number 4. K.C. Shivramu.
Going on, completed.
Almost.
Congratulations.
I think AG took a lot of his efforts till 8 o'clock, almost 7:45 now. Okay, I think the draft was ready. I think they had a discussion. If it gets completed, probably we'll report Learned Advocate General.
We'll pass over now.
May I request, my lord, if your lordship do not mistake me, my lord, my learned friend. Can it be had tomorrow at 12:30, your lordship?
Mr. Shivramu, Nale, we'll have it.
Yes.
But don't ask for argument tomorrow.
No, argument kalla. What I am saying is, your lordship, compromise ಆಗಿದೆ ಇದು with the able direction of your lordship. But still something one ಸಣ್ಣ ಪುಟ್ಟದ್ದು ಇದೆ ಅದನ್ನ ನಾನು
ಸಣ್ಣ ಪುಟ್ಟದ್ದು ಇದ್ದೇ
ಇರಲಿ
ಇರುತ್ತೆ. It
ಅದೇನು
will
ತೊಂದರೆ
always
ಇಲ್ಲ.
be there.
Ultimately it will be left to the discretion of this honorable court, your lordship. There is no problem.
We are not.
ಆಗಲ್ಲ.
That's why we told you this is the advocates and court is two wheels of the cycle.
Chariot, there is no
Chariot cycle. ಒಂದು ಇಲ್ಲ ಮುಂದೆ ಹೋಗಲ್ಲ.
Yeah. Yes, your lordship.
So it is. Everybody needs to be happy.
I'm sure the Learned Advocate General will come later. We have another.
Advocate General was a matter ಇದೆ ಅಂತ ಹೋಗಿದ್ದಾರೆ 3:30 ಗೆ
Last 2 days he'll be extremely busy. In that extreme busyness, he has taken so much time.
2.5 hours he had extreme patience.
ನೆನ್ನೆ 7:45 ಗೆ ನಾವು ಕೂತು ಮಾತಾಡಿದೀವಿ ಸ್ವಾಮಿ.
Last 2 days ಅಲ್ಲಿ ಎಷ್ಟು busy ಇರಬೇಕು ಅವರು. He has taken so much time and so much pain.
There's no problem.
ಸಣ್ಣ ಪುಟ್ಟ ನೀವೇ ಮಾಡಿ ಮುಗಿಸಿ.
ಅದು ಸಣ್ಣ ಪುಟ್ಟದ್ದು ಅದು ultimately it will come to your discussion only, your lordship. That's the reason. One small
will pass over, let us see.
Yes, your lordship. That will be there, your lordship. Your lordship will resolve it, your lordship.
Coffee ಕೊಡ್ಕೊಂಡು ಬನ್ನಿ ಅಷ್ಟೊಳಗೆ. Small thing.
Yes,
talk to the coffee and get back and solve the.
That could be done, my lord. That could be sorted out by.
ನೀವಿಬ್ರೇ ಹೋಗಿ ಬನ್ನಿ.
ಅಂದ್ರೆ ಅವರು
ಗೊತ್ತು ಅವ್ರಿಗೂ ಗೊತ್ತು ನನಗೂ ಗೊತ್ತು. Anyway, my lord,
ಅದಕ್ಕೆ
no issue.
Ball will be thrown to the court of law. So that to that extent only.
Now, if we have no problem with the ball being thrown here and deciding it, yes, we'll have to decide.
That's correct. No, That is,
If we have to decide, it has to be one this way or that way.
I mean to say that ball will be thrown to the court of law ಅಂತ ಅಂದ್ರೆ ನಾವೇನು question of law decide ಮಾಡಿ ಅಂತ ನಾವು ಹೇಳುದಿಲ್ಲ. Please use your discretion by this court, my lord ಅಂತ ಹೇಳ್ತೀವಿ ಅಷ್ಟೇ.
ಏನಾದ್ರು ಸಣ್ಣ ಪುಟ್ಟ ಇದ್ರೆ ಬಟ್ ಇದ್ರಲ್ಲಿ ನೀವೇ ಸಾರ್ಟ್ ಔಟ್ ಮಾಡಿ ಮುಗಿಸಿ.
We will, no problem. We spent our time, no problem.
ಊಟ ಆಯ್ತಾ?
ನಾನಂತೂ ಊಟ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಮಾಡಿಲ್ವಾ? ಊಟ ಮಾಡ್ಕೊಂಡು ಬನ್ನಿ.
ನಾವು ಇದು ಈಗಲೇ AG ಆಫೀಸ್ ಇಂದ ಈಗಲೇ ಎದ್ದು ಬರ್ತಾ ಇದ್ದೀನಿ ಇಲ್ಲಿಗೆ ಡೈರೆಕ್ಟ್.
ಇವಾಗವರೆಗೂ ಮೀಟಿಂಗ್ ಇತ್ತ?
ಈಗಲೇ
ನಾವು ಹೋಗ್ಲಿಲ್ಲ because he wanted to talk to them.
ಅಲ್ಲ ಡ್ರಾಫ್ಟ್ ನೋಡ್ಬೇಕು ಅಂತ ಹೇಳಿ ನನಗೆ ಬೆಳಿಗ್ಗೆ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ರು. ಅವ್ರು ಬಿಡು ಇದ್ದಾಗ ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದೆ. ಅವ್ರು 1:15 ಸಿಕ್ಕಿದ್ರು ನನಗೆ, 1:45ಗೆ ಅಲ್ಲಿಗೆ ಹೋದ್ವಿ. ಆಮೇಲೆ ಡಿಸ್ಕಷನ್ ಆದ್ಮೇಲೆ ಇವರು ಎಲ್ಲ ಅಲ್ಲಿಗೆ ಬಂದ್ರು, ಅಲ್ಲಿ ಮಾತಾಡಾಯ್ತು. ಸೊ
9:30
ನಾನು ಈ ಕಡೆ ಈಗ ಬರ್ತಾ ಇದ್ದೆ. ಅವ್ರು ಹೋದ್ಮೇಲೆ 15 ನಿಮಿಷ ಅವ್ರ ಚೇಂಬರ್ಲೆ ಕೂತು ಇವ್ರ ಹತ್ರ ಎಲ್ಲ ಮಾತಾಡಿ ನಾನು ಐ ಆಮ್ ಕಮಿಂಗ್ ಡೈರೆಕ್ಟ್ಲಿ ಟು ದಿ ಕೋರ್ಟ್.
ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಒಂದ್ಸತಿ
ಪ್ಲೀಸ್ Uller.
Because after tomorrow there is no other opportunity after lunch. So ಆಮೇಲೆ ಲಾಸ್ಟ್ ಮೂಮೆಂಟ್ ಅಲ್ಲಿ ಇಶ್ಯೂ ಆಗ್ಕೊಡ್ದು.
ಇಲ್ಲ ಆಗಲ್ಲ.
Should be sorted out completely before vacation. All of you should go on vacation peacefully, celebrate, enjoy the vacation and come.
ಆಲ್ಮೋಸ್ಟ್ ಆಲ್ 90%.
ಏನು ಮುನಿಯಪ್ಪ ಅವರೇ?
ತಮ್ಮಿಂದ ಆಗ್ಬೇಕು ಸ್ವಾಮಿ, ಇದು ಒಂದು ಸಣ್ಣದು ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ಹ್ಯಾಸ್ ಬಿನ್ ಸಾಲ್ವ್ಡ್. ಸಿಂಪಲ್ ಒಂದಿದೆ, ಅದು
ಬರ್ಲಿ, AG ಅವ್ರು ಬರ್ಲಿ. ಏನಾದ್ರು ಇದ್ರೆ ನಮ್ ಕೈಯಲ್ಲಿ ಆಗಿದ್ರೆ we'll do that.
Some matter we had mentioned yesterday, your lordship said posted it for preliminary hearing, a sugar matter. Sugar cane price.
ಫೈಲ್
ಈ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟಿದೆ.
83 ಅಂತ ಬಂದಿದೆ ಅಂತ ಬೆಳಗ್ಗೆ ಹೇಳಿದ್ರು ಶಶಿಧರ್. ವಿಲ್ ಟೇಕ್ ಇಟ್.
ಅದರಲ್ಲೂ learned advocate general is appearing, so opposing us there.
ಅವ್ರು ಬರೋವರೆಗೂ we can't take.
That no, I'm just.
Serial number 5, Vasudeva Naidu.
What is this?
Last occasion, my lordship has requested for furnishing the entire panel.
Looks on the last date.
Panel in Bangalore.
Panel ballots.
Yes.
I would require some time ballots. I've asked, I've sought instructions. I've not received any. First week of after vacation.
Learned counsel for the petitioner has furnished a list of arbitrators empaneled with respondent number 2, who are residing in Bangalore. Copy thereof has been furnished to the counsel for respondent number 1 to 3. She seeks for and is granted 2 weeks time to obtain instructions and make a submission as to whether any other arbitrator is available in Bangalore who is empaneled on respondent number 1 to 3. Relist on 9th January.
Obliged.
Serial number 6, R. Kotwal.
Advocates matter.
7.50%. That advocates coming back now.
Return of Sanad Malus.
Yes. On the last occasion, this one court, please note that he has to refund back. And I pointed out by saying that there is a rate of interest in it is 7.50% on FD.
Very well.
ಅಷ್ಟೇ.
Judicial order not by consent.
He is ready to do. In COVID, he never knew what will happen, so he surrendered. Nobody knew what was happening.
But nevertheless, we did not notice. There is no statute as such, but that's the reason we strained.
1,42,000 was paid after 35 years of practice. That is a reason.
That notes he cannot question. Basic and notes statute, whatever is there, notes he was entitled, that we have paid it.
Very well.
Don't complicate things for yourself.
Very well.
Third, petitioner is before this court seeking for the following views. Petitioner was a practicing advocate who had practiced for more than 25 years, having registered himself with the respondent Karnataka State Bar Council. During COVID-19 pandemic, the petitioner had submitted an application for surrender of his sanad and requested the respondent to make payment of the monies as provided for under the Advocates Welfare.
Karnataka State Welfare Fund Act.
No, rules was in either.
Welfare Fund Act.
Madam.
The Karnataka Advocates Welfare Fund Act 1983. The said application was accepted by the Bar Council and an amount of rupees 1,42,000 was paid to the petitioner by way of deposit into his bank account. And the surrender of Sanad bracket right to practice was accepted by the respondent. Subsequently, the petitioner, apparently having a change of heart and mind, had submitted a representation on 2/11/2020 and 12/7/2022 for cancellation of the withdrawal. However, the said representation were not considered by the respondents, and in that background, the petitioner is before this court seeking for the aforesaid reliefs. The submission of learned counsel for the petitioner is that the petitioner is ready to sought for surrender, withdrawal of the surrender, and the same being accepted, the amount which had been received by the petitioner would be returned back to the respondents. Learned counsel for respondent, however, firstly contended that there is no provision for withdrawal of the surrender made by an advocate, and secondly, he submits that the respondent, having returned the money, has lost income on that money, which forms one of the income for the bar council for running of the bar council.
Not as per definition. As per definition, not it's a voluntary surrender not being made by an advocate. Not a definition says cessation of practice means not it's its own act. Means removal of a name of an advocate from the role maintained by the bar council or non-renewal of leadership certificate on the ground, so and so. Then means retirement. Means stoppage of a practice as an advocate communicated to and recorded by the bar council and trustee committee. Therefore, notes it is his own act. Not we are not forcing him. It is his own act. Notes which says that he has sought for retirement. That means notes he has stopped his practice.
You want us to make those observations?
Earlier, note it was done. Notes.
That question has been answered, Millers.
Now you have arrived at an agreement. We are virtually passing a consent order, recording the submission with our reasoning. But if you want to press that argument, we'll consider it.
I'm not consenting. The judicial order.
Right. Then we'll consider. Then we'll have to make some observation against the bar council. That is why we did not want to.
There's already an order in which you have suffered. The last occasion was pointed. There's an issue already.
Coordinate benches order, Millard, which I have submitted in the last one.
No, but despite that, if you want to persist with this submission, we'll deal with that submission. You want us to deal with it?
That's the reason
bar council, we are asking you for that. We have no problem in dealing with it.
Consent.
That is what we'll observe also.
But this issue has already been dealt with in the coordinate bench.
We'll deal with it in our way. Don't worry. Having heard two. The submission of G. Nataraj, learned counsel for the respondent, is that the petitioner having surrender his sanad and retired from practice voluntarily cannot now seek to withdraw his retirement and come back into practice, and that there is no provision which enables such withdrawal of the surrender. Heard, so and so, peruse papers. The points that would arise for consideration are: one, whether on a surrender of the sanad by an advocate, he can seek for withdrawal of the said surrender and re-registration or restoration of the registration on the rolls of the Karnataka State Bar Council. Two, whether the Karnataka State Bar Council can refuse the withdrawal on the ground that there is no particular provision which is available under the Advocates Welfare Fund so and so Act. Three, what order? Answer to point number one. The advocates, any advocate, in order to practice in a court of law, any lawyer, that is a person who has obtained a degree in law, in order to practice in a court of law, is required to enroll himself with the concerned state bar council where he intends to practice. Insofar as Karnataka is concerned, such registration is required to be made with the Karnataka State Bar Council. The Karnataka Advocates Welfare Fund Act 1983 provides for each of the advocates to purchase advocate welfare stamps from time to time and affix the same on the wakalatnamas which are filed before the court, as also on certain applications which are so provided. This purchase of the advocate welfare stamp is, in a manner of speaking, a contribution made by each of the advocates to the Advocates Welfare Fund, which fund is to be used in terms of the Karnataka Advocates Welfare Fund Act 1983 by the trustees so appointed in the manner prescribed under the said act. By way of surrender of the sanad, that is the right to practice stroke registration with this Karnataka State Bar Council, the petitioner had in fact indicated that he would no longer be practicing in a court of law and he has retired from the practice of law. Subsequently, the petitioner, having a change of mind, had sought to withdraw the said, on such surrender being accepted, the petitioner was paid a sum of rupees 1,42,000 as per the entitlement in terms of the act. Subsequently, the petitioner, having a change of heart stroke mind, had approached the Bar Council with a request to withdraw his earlier surrender and therefore restore his registration with the Karnataka State Bar Council, entitling him to practice in a court of law, thereby excising his fundamental right under Article 19(1)(g) of the Constitution. The said request was rejected by the respondents on the ground that the Act does not provide.
No, we are not rejected it. Where is that considered?
Not processed at all. Apparently on the ground that the Act does not provide for it does not contemplate such a situation and does not provide for withdrawal of the surrender made. The very purpose of the existence of the Karnataka State Bar Council is to enable registration of advocates with the Bar Council to enable them to practice in a court of law and for the Bar Council to exercise such disciplinary proceedings, disciplinary powers and other powers as are provided under the Act. The existence of the Bar Council can only come about with the lawyers who enroll with the Bar Council and not otherwise. In the present case, for reasons best known to the petitioner, during the COVID-19 pandemic, the petitioner chose to surrender his registration stroke sanad and receive the amount as permissible under the Welfare Fund Act, probably not knowing what the future holds due to COVID-19 pandemic. Post the COVID-19 pandemic, the petitioner again wanted to come back into practice and had made a request to the Bar Council to permit the petitioner to carry on with such practice by restoring the registration of the petitioner. The respondents, in my considered opinion, ought to have on their own accepted the said request and allowed the advocate to re-register himself with the Bar Council to exercise his fundamental right under Article 19(1)(g) to practice the profession of law in a court of law, which can only be done by registering with the Karnataka State Bar Council. Instead of doing so, the respondents who are
Registration and not fresh enrollment.
Restoration of
Restoration.
Restoration.
Registration.
Restoration of registration.
ಮೇಲ್ ಮಾಡಕ್ ಕಳ್ಸಿ ನಾನು ಅವಾಗ ಮಾಡ್ತೀನಿ.
The petitioner has now come forward to even make payment of a sum of rupees 1,42,000 received by him, as also to make payment of the due interest which the respondent would have earned during the interregnum period. Despite which the respondents still continue to contend that they cannot allow the revocation of the surrender and re-registration of the petitioner. This, in my considered opinion, is not the right attitude to be expressed, right attitude on part of the Karnataka State Bar Council. I do refrain from saying anything further, keeping in mind the reputation of the Bar Council, since the same leaves much to be desired. In that view of the matter, I answer point number 1 by holding that if a member who has surrender is sanad stroke registration, despite having received and thereafter having received financial benefit in terms of the Advocate Welfare Fund Act, wishes to withdraw the surrender and seeks for re-registration, it would be the bounden duty on part of the Karnataka State Bar Council to permit the same, since non-permitting the same would infringe the fundamental right of a citizen to practice to practice his profession. In this case, the profession of law under Article 19(1)(g) of the Constitution. Point number 2, Enama. Answer to point number 2. In view of my answer to point number 1, it being clear that the Karnataka State Bar Council could not have refused the withdrawal of the surrender and re-registration, I answer point number 2 by holding so and so. What order? In view of my answer to point number 1 and 2, I pass the following order. A writ petition allowed, a mandamus is issued. Respondent is directed to consider the representation of the petitioner dated 19/9/2023, subject to the petitioner making payment of the amount received along with due interest at the rate of 7.5% per annum from the time of receipt till time of payment to the Karnataka State Bar Council, and restore the registration or re-register the petitioner on the rolls of the Bar Council within a period of 15 days from such payment made by the petitioner. We should voluntarily come.
Since there is no statute notes, we are offended.
Then you should say, we should not oppose.
Notes one observation. Registration ಅಂತ ಬಂದ್ರೆ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಫ್ರೆಶ್ ಎನ್ರೋಲ್ಮೆಂಟ್ ಆಗುತ್ತೆ.
Re-registration.
Restoration.
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 Re-registration ಎಲ್ಲ restoration.
Please.
Serial number 7, R. Kotwal.
In this matter, Malats, we don't have any objection for the matter to be referred to mediation.
Mediation.
Last occasion.
Question is not, the writ petition itself is not maintainable.
ನೀವೆಲ್ಲಿಂದ ಬಂದ್ರಿ?
Because Yashoda is not there, I am appearing this.
You are appearing on this side. What is happening?
No, yeah, this is a case not where they are asking for registration of an FIR. But this is, the offences are non-cognizable in nature.
Fine,
Hence,
whatever it
the alternative remedy is to file a PCR.
If both of them are ready to settle their disputes,
then no problem.
These submissions were made before the coordinate bench, Malats also.
Shanawaz
to inform is agreeable for mediation.
Yes. For the counsel for the petitioner and respondent number 4 to 6
Please,
submit that their respective parties are agreeable to for mediation of their disputes to try and resolve the same amicably. In that view of the matter is referred to mediation under the aegis of the Karnataka Mediation Center. So the director Karnataka Mediation Center is directed to appoint a suitable person to try and mediate the dispute between the parties. Since the order is passed in the presence of both the councils, they shall be present before the director Karnataka Mediation Center on when will you? Who is in Dubai? Somebody has to come from Dubai.
Alla, avuru petitioners alla. My lord, petitioners are the senior citizens, my lord.
You will appear.
Yes, yes, they will appear.
On what date?
Any second week of January.
Second week of January. What happened? On 14th January 2026 at 2:30 p.m. Let them sort it out.
Serial number 8.
On the last occasion, your lordship had posed me two questions.
Proceeding under section 34.
Two questions were posed. I am supposed to satisfy your lordship on those 2 points.
Yes, please.
One is it is an appealable order. And the second one is whether I can bring it under 227. Insofar as the first point is concerned, it is not an appealable order because I have exhaustively looked into section 37 of the Arbitration Act. It is not an appealable order.
This is an order passed under?
I filed an application under 34(3) before the trial court, contending that the application submitted by them is barred by limitation.
Yes.
And my application has been dismissed.
Correct.
Against that, I have filed this writ petition.
So 34(3) was for correction. 34(3), what is the relief you had sought for?
34(3) again, what I have contended is that is beyond the period of limitation they have preferred. Therefore, it is not maintainable.
Correct.
So that application has been rejected. And I am questioning the order that has been passed rejecting my application.
Yes.
And your lordship wanted to know whether
Arbitration Act.
whether I could bring it under 227. Halfway I have gone these studies, made the studies. Particular case ಯಾವುದು ಇನ್ನೂ ಸಿಗಲಿಲ್ಲ ನನಗೆ.
Against ಸಿಕ್ಕಿರುತ್ತೆ. Against ಸಿಕ್ಕಿರುತ್ತೆ ಅಂತ. Favorable ಸಿಕ್ಕಿರಲ್ಲ.
Against ಅಂತ ಏನು ಸಿಗಿಲ್ಲ ಅಲ್ಲ. Whether this kind of a case can be brought under 227 ಅಂತ. ಒಂದೇ ಒಂದು ಏನು ಅಂದ್ರೆ they themselves have submitted an order passed by this court. ಅವರ ಸಿನಾಪ್ಸಿಸ್ ಜೊತೆ ಒಳಗೆ ಹಾಕಿದ್ದಾರೆ. At page 19, they in their synopsis.
19 of their citations.
Of the
Yes.
citation. ಅದರೊಳಗೆ application before the trial court was made under 151. It was allowed. Against that, they had come to High Court under 226 and 227. ಇನ್ನು ಸ್ವಲ್ಪ 227 ನಾನು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ ಸಬ್ಮಿಟ್.
You want time?
I had to, because I had to satisfy your lordship. ಮೇಂಟೈನಿಟಿ ಮೇಲೆ ಹೋಗ್ಬಿಟ್ರೆ
ಕಷ್ಟ ಇದು ಮೇಂಟೈನ್ ನೀವು ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡೋದು. But you want time. Counsel for the petition seeks for and is granted 2 weeks time to get ready and address his arguments. Released on 21st January.
First week of January. Maybe first week of January.
First week of January. Released on 7th January.
Please. Much.
Serial number 9.
Please, your lordship. Petitioner is importer and exporter of gold jewelry. He had imported gold jewelry mentioning Canara Bank as the authorized dealer. Now I have to remit the money to clear and retire those bills. In the meantime, some disputes interested between Canara Bank and me have arisen. I have been repeatedly writing them. I will give you my funds. You will simply remit it on the same terms and conditions on the day when I imported it. I can't change the authorized dealer because my bill of entry, my documentation under which the import took place, I have mentioned Canara Bank as the authorized dealer.
Did you get their consent before doing that?
No, this is in the routine. This is in the routine.
Last time your lordship had directed me to produce the interim orders passed in 4 other writ petitions with their filed, my lords. I have produced those interim orders. The lordships may see, my lords. They have filed 4 other writ petitions. My proceedings under NCLT has been stayed. Surface Act proceedings have been stayed till the DRT decides the dispute. The lordships may see the memo which I have filed, my lords, on 29/11/2025.
Yes.
The first order, my lords, at page number 4 may be seen. In page 4, my lords. Order dated 10/10/2023.
Oh, so the proceedings against them have been stayed.
Yes.
And they want you to make.
Yes, my lord.
Is virtually new loan.
No, I am not asking any loan, your lordship. I will give the money.
DRT
I will
you will give them the money.
I will give them the money. They have to only remit it.
He will give
My
them the
lord,
money.
all these
I will
issues are
provide the
before the
funds.
DRT now, my lord.
No,
I
They
don't
have
want
to
to
make an
happen.
application.
Insofar as this transaction is concerned, what Mr. Jawli is saying is, if 100 rupees has to be paid, he will give you the 100 rupees to remit.
My lords, the issue here is this transaction is of the year 2021
Hmm.
and it is to their own subsidiary company. It is admitted in the
Whatever
pleading.
it is,
It is not to some
you know, I
third
have to
party.
required to
It is to
comply.
their own subsidiary company and it is of the year 2021 when this, all these other writ petitions are pending, my lord. They have not raised this issue. Now they have filed a fresh writ petition. Their DRT proceedings, they are dragging it there. Their business, they want it to be run smoothly, my lords, when the disputes are pending. I'm not able to proceed under NCLT. I'm not able to proceed under SURFACE because of these interim orders.
So you're not willing.
Yes, my lords. We have given a reply, my lords.
You
Your
filed your
lordship,
opinion.
I've filed those interim orders. Our
Yes, then
objections are
argue
filed,
on
my lords.
merits, Mr. Jawli, how you are entitled to this, what gives you the right to seek for a mandamus, what is your vested right for a mandamus?
my vested right is as a importer, I have to go through an authorized dealer only as provided
Did
for
you
under
seek
the
for
policy.
the consent of the respondent before nominating them as the AD?
No, this transaction with this bank has been going on for the last 25 years.
Yes, but for
Suddenly
this
there has
particular
been a,
transaction, did you seek their consent?
Please,
You
no,
can change the AD to anybody
they
else.
approved it. They approved it and I imported
Where
it.
is
Your
their
lordship.
approval? Where is their approval? Have they
Those have not
approved this?
been produced to your lordship.
Transactional documents are.
The
Where is that
transaction has
document?
been completed. I have to remit the money back. Otherwise, I will be in violation of the FEMA.
You may be in violation because you have chosen a bank who doesn't want to give you
No, I am
without
not
their
asking them
consent.
any money, your lordship. I am not asking them any money.
They don't want anything to do with you.
No, lordship, but I have secured their interest. They are not mentioning it.
Did you get their consent before you nominated them as the
I will
AD?
have to place that on record, your lordship.
Place it on record. Will you place it tomorrow?
Please, my lords.
Please,
Tomorrow.
your lord.
We'll list tomorrow. If their consent is there, we'll direct them. If their
Please.
consent is not there, we'll dismiss your petition.
Without their consent, the transaction will not go through, my lords.
Show us the consent.
Please.
Serial number 10.
Appearing. The last date of hearing, there was a point mentioned that 2 other petitions are pending. They are already disposed of, your lordship. I'm filing a memo to that extent.
What is this matter? Passport.
Passport, your lordship.
Yes, Mr. Chandibhushan, any objection?
Lordship, may I grant him the
Hand over the passport. You seize the passport.
The passport is seized. It has to be handed over because now it is only 3 months valid more. Let them issue a SVP, short validity passport.
now on that passport, a short validity passport cannot be issued. Let him apply afresh. Not we will issue him a passport. Your Lordship may direct us, subject to he obtaining the permission from the trial court. The
I have
reason is
obtained.
this.
I have obtained, your
If
lordship.
he is obtained, right, my lord. The reason is this: there are about 7 cases against him. So therefore, my lord, we will issue him passport. Subject to, my lord, he obtains the permission. If he has got already obtained the permission, my lord.
Where is that permission?
I have produced it. I have already given the memo along with the permission orders.
When was the memo filed?
Memo dated 2/12, your lordship.
2/12.
2/12, and subsequently objections was raised on the last date of hearing.
We don't have anything of 2/12 here.
Sir,
Yes, sir.
He's been granted permission.
All the permissions have been granted. Now I'm producing
But
one
if-
email.
In 7 matters.
1, 2, 3, 4.
Pending are
5,
7 matters.
6, 7 matters. 7 and 1 is in FIR state.
So in all the 7 matters, you got permission?
2 matters are not my matters. I filed a memo.
Anyway, you'll have
This
to
has
give them.
this has come out of a email. I'm giving an email, your lordship. This has come out
We are
of an
not
email
getting
which
into
has
all
no
those things.
relevance.
To give them that orders.
I shall give that. That only one question arises is under the Negotiable Instruments Act. Because the statute does not mandate under Negotiable Instruments Act. I have a negotiable, I am giving an affidavit telling that there is a case under Negotiable Instruments Act. Rest all cases have obtained permissions.
You deposit that amount.
Your Lordship, that is a disputed transaction.
Negotiable Instruments Act is no case. at
That
all.
is a disputed transaction, and 62F only mandates
The contention that Negotiable Instruments Act criminal proceedings are no proceedings.
according to the Passport Act, that it is a quasi trial.
Those Negotiable Instruments Act are the ones which default people are running away.
Truly,
So you better give that. What is the security you will give there? You give that.
I shall give an undertaking to that extent. I'm filing an affidavit also, Your Lordship.
Petitioner is before this court seeking for the following reliefs. The contingent learned counsel for the petitioner is that the passport of the petitioner having been impounded by the respondent is required to be returned, and since the validity of the passport, since there's only 3 months validity of the
4
passport
months
left, 4 months.
4 months.
Of the validity of the passport which is left, a fresh passport would be new passport, a fresh
Short validity passport.
How will that be? Because it can't be new, it can't be fresh. It has to
Shall
be
be
reissued.
SVP only, short validity passport.
A passport could be reissued to the petitioner, albeit on a short validity.
Much of it.
Learned, Shri Shanti Bhushan learned DSGA submit that there being 7 criminal proceedings against the petitioner. It is for the petitioner to obtain necessary permission for foreign travel in those proceedings and satisfy all the conditions that may be
One point,
imposed
Your Lordship.
by those
It is-
courts, on which basis the short validity passport would be issued by the respondent subject to the petitioner making a application for
Fresh
issuance of a passport.
Fresh. But one submission.
For reissuance of a passport.
There are no 7 cases. The
That is
cases
his
point.
submission.
No, Your Lordship. That is as per the email. I've given one more email.
How many cases are pending?
As per them, it is 7, but that is not, that is through an
That's
email.
how he said.
No,
not
it is
7.
5. It is 5. I've given an affidavit also to that extent.
Which are those 7 pending?
Lord,
According to them.
CC 8102 of 22.
1, 2, 3, 4, 5, 6, 7 cases are pending.
And
Out of
the
which
next one is
2 of
FIR.
FIR.
Out of which 2 of the cases are not mine. I am given an affidavit telling.
Satisfy them.
Yes, Your Lordship. I shall file an affidavit to that extent to them.
7 cases are pending, where charge sheet have been laid, and 1 case which is at the crime stage. In that view of the matter, learned counsel for the petitioner submit that a fresh application would be filed for reissuance of the passport, and the details of permission having been obtained for foreign travel in all the pending cases relating to the petitioner would be furnished with due explanation as regard cases which are not pertaining to the petitioner.
Already sought permissions be considered, Your Lordship, because I have already sought the permissions, because that is sought under the old passport number. That's why. Much of it.
In that view of the matter, I pass the following order. Writ petition is partly allowed. Petitioner is permitted to file a necessary application for reissuance of the passport, accompanied by all orders passed in the pending proceedings where the petitioner has been permitted to travel abroad. Though the said permissions are stated to be granted in respect of the old passport, the respondents are directed to consider the same in respect of the new passport application submitted by the petitioner within a period of 15 days from the date of receipt of a copy of the.
Great. Much obliged. Let one thing be mentioned, Your Lordship. The email what they are relying upon is an impersonated email that has been given. Subsequently, email is also sent telling that I have not sent that email.
This is not the proceeding where we can decide all
That is where they have pointed out there are 7 cases. I have disclosed that there are 5 cases. The only thing is that there
They
are
have 7 numbers with them. They have got case papers with them.
no, Your Lordship. They don't have the case papers. That is what I have given an affidavit now telling that it is just on an email.
How long does it take to take a printout from the e-court's website?
That is what we have done, Your Lordship. It is not on my name.
Give it to them. Why
I
are
shall
you
give.
unnecessarily
But
arguing?
only concern is about this negotiable instruments. Let because I have to travel between.
Exception for Negotiable Instruments Act. It will be in.
I
the
shall
same-
give an undertaking, Your Lordship.
Get permission from there.
Your Lordship.
What is
During
the
the
amount
vacation,
involved?
because I have to travel between Jan 1 to 15.
What is the amount involved?
In the Negotiable Instruments Act, 4 lakhs, Your Lordship.
Consider.
Let it be considered.
He'll consider invest, Shanti Bhushan is it next.
March of.
Serial number 11, VB Shivakumar.
As usual, my lord, central government keeps creating problems, my lord.
Loaded statement.
I would not do if it is,
Not my learned friend, my lord.
We have now Mr. Vikram in between both of you. What are you doing in between?
Preparing for the GBA, my lord.
GBA.
My lord, I have no problem with petitioners, my lord. The problem now, what that Lordship may kindly see the cost title. Anyone who's challenging the tender will make that only the tenderer as a party to the proceedings. Your Lordship may kindly see it's a well thought of writ petition, my lords. Your Lordship may kindly see they anticipated who and all whom they can get objections to be filed, namely the Housing and Urban Affairs, respondent number 2, and National Highway Authority. And the only person who ought to have been made a party is respondent number 1, my lords. Because there's a tendering authority, only person who can have a say. Now, my lords, your Lordship may kindly see the objections which are sought to be filed, my lords.
By
the central government, respondent number 2, my lords.
They not filed their objection.
Not, they have not, that's what. They do not file an objection. They do not file an affidavit, my lords. They file a memo for production of documents addressed to memo of instructions only to the council, not to be given to the court, my lords. It looks like it's
I
only
have said so, my lord. I have said
So
so yesterday.
Memo of instructions.
It is addressed to my colleague and ಹೇಳಿದೆ ನಾನು.
Therefore, my submission is this cannot be taken on record at all, my lords.
Why?
The reason is this is addressed to the council, my lords. And the person who has issued it, Ravi Kumar, Under Secretary, who is not part of the first respondent BMS CL, my lord. He has no authority to issue. The question is 50% shareholding between the central government and the state government. No objection is raised by the central government through email, letter till now to us officially or asking for a board meeting. Under the regulation, the board has delegated to the MD. MD has issued the tender. The person outside, without any authority, gives instruction to the central government. The fact that they made this.
Ravi Kumar is nothing to do with BMRCL?
Absolutely
Kindly
nothing.
say, my lord, Ministry of, he is the under secretary to the Ministry of Housing and
Like
Urban
I am
Affairs.
using Advocate General's logo for you doing any other work apart from my.
Is he an officer in
So many
BMRCL?
officers. Who are the
He is not an officer in BMRCL. My lord, he is an officer in the Ministry of Urban and Housing and Urban Affairs.
Page number 9 of the
The
compilation.
reason is this, my lord, if your lordship could kindly see the memorandum of understanding, it is between the government of India represented by Ministry of Housing and Urban Affairs
produced it, my lord.
and the government of Karnataka.
My lord, page R3, my lord.
You may have a point. Now BMRCL is a separate entity.
Please, my lord.
Once it is a separate entity, do the shareholders be made to be made a party and shareholders have to be heard in a proceeding? A little doubtful. You have your representative on the board.
Please. Lord, all that we are saying is that, my lord, they've not been consulted. They've not been informed about the tender.
File an affidavit.
Please, my lord, I'll file an affidavit.
Can you page 7 maybe kindly see, my lord, just for a moment. my
Memo
lord.
of instruction will not suffice.
I'll file an affidavit to that extent.
What is
Page
this?
9, page 9, my lord. Government of India nominees, Government of Karnataka nominees. None of these people, my lords, who are part of the board raise any objections. Show me which is the clause which I'm permitted to do and page number.
He is not one of these.
No, none of these people. Just because, my lord, my learned friend argument, kindly see the Government of India is written in his letterhead, so he can issue letter to anybody and everybody.
Let's not put it at
And
that.
previous page is
Let's not put it at that, but.
No, your
Kindly
lordship
see,
may
my
kindly
lord,
see page.
kindly see the agreement, my lord, the last page, 16.6.
No, just one, page 7, my lord, page 7 for a moment, my lord.
The authorized signatory for the memorandum of agreement is the Ministry of Housing and Urban Affairs.
That can be.
Yes, but
Page 7, my lord.
see, then in that case, we'll have to hear the shareholders of all government entities.
Please, my lord,
In all
insofar as
tender documents, if we take if we take both your petitioner and your arguments into account, if respond number 2, actually 2, 3, 4, they are not the tender issuing authority. In a tender matter, we will only have to hear the tender issuing authority. Without you are one of the directors or you are part of respond number 1.
no, we are the shareholders of 50% insofar as the.
File an affidavit, file your objection.
Please,
Because there is a board of directors for respond number 1 who will have to take care of respond number 1.
That's true. I'll file an affidavit.
Page 7 for a
I don't
moment.
want to say more, but it has to be done in a proper manner.
Please,
Page
please.
7 for a moment, my lord.
Page 7.
This is the delegation of power to the MD and sub-delegation thereof. The board of directors of the company on 7 so and so have delegated the power to MD for day-to management so and so and so. So all the powers have been delegated, including, my lord, the document which my learned friend has produced along with instructions. BMRCL in connection with implementation of project has generally adopted to follow the due process and norms and rules established undertaking works and procurement of works, material, service for tendering after observing the guidelines and circulars so and so, my lords, where they give the power to the managing director to call for tender. So therefore, my lords,
10 crores and overall 50 crores.
please, my lords,
What is the value of this tender?
this value is 65, minimum bid price is 65 crores.
And it is
This is not a procurement, my lords. This is a revenue tender, my lords.
work service.
This comes under works and your lordship may kindly see the document my learned friend has produced. Subject to policy and principle approved by the board, subject to powers delegated by the board. This is very important. Well, the document which my learned friend has produced, clause 15.5 at page number 19. 19, yes. 19. Page number 19, my lords. Clause 15.5. Subject to the policy and principle approved by the board and subject to powers delegated by the board, general administration and management of the business of BMRCL shall be in the hands of the managing director, who shall have the power and authority on behalf of BMRCL to take decision and enter into all contracts and make decision on all purchases, recruitments, to do all such things that are necessary or desirable. So, therefore, my lord, the question is, first of all, my case is, my lord, they need to be deleted. They have no say filing an affidavit also, my lord, because they have whatever they have to say in the board, and they should either withdraw the delegation or say that you are not authorized without the BMRCL board taking, the government of India, who are board members taking any decision. They are filing any independent decision because, for example, my lord, it's like saying the central government or anybody says, third party state of Karnataka filing objection saying that you cannot, or any authority filing objection to a tender issued by the government of India. Even though it's a joint venture, in the venture, it's a separate legal entity, BMRCL. Whatever, the board has to function independent of it. Either National Highway Authority saying, I don't like, or the central government or the state. Tomorrow, BMRC, tomorrow state government may say that I don't like this tender. So that should, no room should be left for that. Let the company, they are only the shareholders, as the lordship pointed out.
You sort out your issues.
In fact, that is what.
With a tender matter, don't make it into a bigger matter than that.
For a moment,
that's what.
For a moment, kindly look to 15.1 and 2, my lord. 15.1.
We are sort it out and then you make your submissions. We'll have it after vacation.
Please.
Enjoy the Christmas vacation for this sorting out. Because otherwise, to get into this would not be proper in a tender document.
But that apart.
I'm a lady.
Immediately after the other matter, my lords.
What do we observe in the order sheet?
Your lordship, I have for further hearing, my lords, immediately after vacation, my lord.
For what purpose?
No, your lordship may not say, because tomorrow they'll say that your lordships are directed. My case is, my lord.
We don't want to say anything in your favor or in
please,
their
my lord,
favor or against either of you.
Your lordship may simply adjourn for further hearing after vacation, say, sort for time, and your lordship may.
Relist on 12th January at 2:30 PM for further hearing to enable the. You're putting us in a very difficult position to observe any.
No, just your lordship sought for.
For further hearing,
As-
anything that we write can be interpreted very badly for both of you.
I understand.
Interim arrangement shall continue till the next date of hearing.
Please, careful to.
Serial number 12.
On submission in serial number 10, let the order copy be released by tomorrow because I have to move the application. Kind, that's a request.
We'll see.
Your lordship, that. Sorry, your lordship. I have to move an application. That's the only concern. Only humble request.
We'll do one thing. We'll raise now and go on.
No, your.
What is this request you're making? Please have some.
Serial number
There's
12.
not McDonald's. That you can go there and order. ಇವ್ರು ಎಲ್ಲಿದ್ದಾರೆ? AB ಎಲ್ಲಿ? ಶಿವರಾಮ್ ಅವರಲ್ಲಿ.
Shiram was there with me.
Everything is settled? Or?
Everything is settled, my lord. That in fact they have made the correction to the compromise petition also, my lord. I've taken a printout.
What?
The Shiram was saying some 2-3 small issues are left.
That
2-3 alla, only one.
one, my lord. What I said, my lord, it's every work in progress.
Not in his absence.
I think it's better they come also.
Yeah.
We'll just find out whether.
These are very sensitive things.
Yes. In fact, we'll be here. We'll just send word, and as soon as they come, we'll just mention to you.
What the sugar matter? 83.
Sugar matter, there is some urgency for us.
My lord, actually, I'll point out, my lord, there is no urgency because, my lord, there are two stages. My lord. First stage, they have agreed. Second stage is only once the process is over, that 50 rupees arises, my lord. So
their contention is not 200 rupees.
500, my lord, 530. We have given the impact chart.
Good, 500 ಬಂತು. When Shishidhar was saying 900 rupees ಅಂತ ಹೇಳ್ತಾರೆ.
It depends on no, it depends on the recovery of the sugar from a particular mill. But under duress.
Harvesting and transportation charges.
Now the difference is boiled down to between 200 to 500. 200 to 500.
Even more than that, according to.
My lord, honestly, that's not the issue.
Lords, our issue is only this. Procedure under the act. My lords, no doubt central government has central government fixes the FRP.
Nawadgi is also appearing.
ಬರ್ತಾರೆ.
You are asking us to take out of turn. Everybody should be here.
So let them not do anything in the meantime. If the Advocate General wanted the matter after the vacation.
No.
My lord, but in the meantime, let them not, because earlier also, one second. Only one. Earlier also.
Argument now.
My lord, the point is, short point is this, my lord. In the reply, as my learned friend was saying, procedure is required. Here is the case, my lord. Sequence of events. There was a protest. Subsequently, meeting with the farm owners, meeting with the factories. What is most important is.
Before we get into all those things, are you ready to address arguments? Do we need to take up the matter of
on the interim prayer, my lords?
For interim prayer, is there some arrangement or do we have it after vacation?
We'll have it after vacation.
There's no bits. Piecemeal is not.
I'll tell you, lordships.
Or we can start, but the only thing, my lords.
Problem is. We have to continue as and when sugarcane keeps coming into the gates, my lords. With the price fixed, I'll be committed to that price which I have to pay.
No.
Then what happens?
He has to commit what he has given to the notice to the farmers. He is paying only that. We are pursuant to the compromise. They have given a publication saying that we will pay this. Let them pay what they have given notice to the farmers.
Under the threat.
No, not threat. It is their advertisement, their publication, and they already 40% of the sugarcane is purchased at what they have submitted, my lords.
In fact, your lordship may take 26 on the 83.1 for a moment.
And
writ petition number?
Lords, writ number 37-230. 37-230 of 2025.
Your lordship, my file has noted from.
ಆಮೇಲೆ
ಓಕೆ ಆಯ್ತು. ಇವ್ರು ಬಂದ್ರಲ್ಲ,
ಬಂದಿಯಾರ ಅವರು ಬಂದ
ಅಲ್ಲ, ಎಲ್ಲಿ ದಾನಪ್ಪ ಬಂದಿದ್ರಲ್ಲ, ಅಲ್ಲಿ ಶಿವರಾಮ್ ಅವರಲ್ಲಿ
ಕಾಂಪ್ರಮೈಸ್ ಅವ್ರು ಹೇಳಿದ ಪ್ರಕಾರ ಮಾಡಿದ್ರು ಸರ್, ಇವ್ರು ಹೇಳಿದ ಪ್ರಕಾರ ಒಪ್ಪಿಲ್ಲ ಅಂತಂದ್ರೆ ಸರ್, ಅದ್ರಲ್ಲಿ ಏನಿಲ್ಲ ಸ್ವಾಮಿ, ಭಾವಚಿತ್ರ ಫೋಟೋ ಅಸೋಸಿಯೇಷನ್ ಇಡಬೇಕಂತ ಅಷ್ಟೇ ಸ್ವಾಮಿ, ಇವ್ರ ಕಂಡೀಷನ್, ಬೇರೆ ಏನಿಲ್ಲ.
ಅಸೋಸಿಯೇಷನ್ ಇರ್ಬೇಕು ಅಂದ್ರೆ
ಅಂದ್ರೆ ವಕೀಲರ ಭವನ ಇದೆಯಲ್ಲ ಸರ್, ಅಲ್ಲಿ ಭಾವಚಿತ್ರ ಅಂಬೇಡ್ಕರ್ ಭಾವಚಿತ್ರ ಇಟ್ಬಿಡು ಸರ್, ಅಷ್ಟೇ ಸರ್ ಕಂಡೀಷನ್ಸ್ ಏನು ಅಷ್ಟೇ ಸರ್. ಇಲ್ಲಿ ಏನೋ ಫಂಕ್ಷನ್ ಸೆಲೆಬ್ರೇಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಏನಪ್ಪ ಅಂತಂದ್ರೆ ಅವಕಾಶ ಮಾಡಿಕೊಡೋದು ಸರ್, ಇಷ್ಟೇ ಸಮಯದಲ್ಲಿ
with the learned advocate general's
ಎಲ್ಲರೂ
effort,
ಒಪ್ಪಿಟ್ಟಿದ್ದಾರೆ. ನಿಮಿಷ
what learned advocate general's efforts, almost what he has prepared all the points. I'm sorry, I'll go that section. All of us, all.
You are occupying the wrong
We are
side.
No, no.
You shifted.
No worry, no worry.
All of us have agreed on the terms.
May make only one
You are all
submission, Your
together.
Lordship.
Don't worry on that.
That is what I wanted to say. May make one. I definitely, my lord, we are grateful to your lordship's indulgence, my lord, in settling the issue. Your
Nothing for
lordship.
us. You are to be grateful to the AG in
No,
this
no,
particular matter.
with AG also, my lord, I am saying, the indulgence of your lordship and the advocate general, advocate general, your lordship, we were able to come to this conclusion, your lordship. A small line between us, my lord, is only
Yeah,
that.
can I,
My lord,
Your Lordship may kindly, Mr. Shriram, kindly go through the compromise, my lord.
compromise, my lord, that could be seen afterwards, that could be taken into.
Then rest of it can be.
Rest of it can be.
Of course, we don't need, you have compromised.
ಒಂದ್ಸರಿ ನಾವು ನೋಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ಸೇಮ್ ಕಾಪಿ ನಮ್ಮ ಹತ್ರ ನಾವೇನ್ ಡಿಫ್ರೆಂಟ್ ಬರ್ಕೊಂಬಂದಿಲ್ಲ.
ನೀವು ಹೇಳ್ದೆ ಕಥೆ ಆಯ್ತು.
ಅವ್ರು ಕೊಟ್ಟದ್ದೇ ನಾನು ಕೊಟ್ಟಿರೋದು
ಅಷ್ಟೇ ಕೊಟ್ಟಿದ್ರೆ ಸರಿ ಬಿಡಿ, ನೋ ಪ್ರಾಬ್ಲಮ್. ರಾಜ್ಯ ಸಂತಾನ ಮೆಮೊ ಮಹಾಪರಿವರ್ತನ ದಿವನ
Very balanced way of
what we have agreed on.
basing it on record also.
Please, in fact,
That
it
has
is.
to be signed by all of us.
We'll sign it.
Without making any this one on anybody, very balanced, yes.
We're very
That is
balanced.
what we have agreed, my lords.
No,
If
one
something-
thing what they realized, all are members of the AAB. It's not, we are not, they should not speak outside AAB. Let them speak within the AAB, and everybody has equal rights. I mean, there's nobody less or more in this organization, my lord. So therefore, keeping that in mind, my lord, I thank Mr. Shivram, Vivek Reddy, Panindar, and Ravi Shankar, all of them, my lord. Even Mr. Manjunath, everybody cooperated, my lord, and other members. I'm sorry.
Members, senior members, everyone.
Everybody.
Nobody is saying anything, your lordship.
ನಾಲ್ಕು ಜನ ಹೋಗಿ ಅಂದ್ರೆ ಇಷ್ಟು ಜನ ಹೆಸರು ಬರ್ತಾ ಇದೆ.
Alala, I mean, in fact, my lord, after yesterday, again, between 1:30 to 2:30, we sat during lunchtime also, my lord.
Time also.
You are not allowed to have lunch also.
No, both of us did not. Both of us did not. Now, till now.
So it's closed now.
It's closed in that.
On those terms, if parties can sign, nobody has signed. But if something else is being placed, that is the difficulty which.
Having said that, my lord, there's what Mr. Shivram.
That, my lord, last.
Yes.
That memo, my lord, may see, my lord. That's what the request, my lord, in the beginning I made, my lord, and but they are making on the other. That was, my lord, then, my lord, when the former secretary was there and treasurer was there with the present president was there, my lord. It was so happened at that time, your lordship. All that they want is, my lord, let there be installment. All these cannot be, can be ignored, your lordship. Without going into any aspect of the matter, they will be satisfied, your lordship. That's all the, that's all the issue, my lord.
Leave it to you to.
More than that, we are in a begging end, your lordship.
What is the easiest in my chamber? 14th April, 26th November, and 6th December.
That was in the association, that was installed in the association when the secretary, former secretary was there, under the leadership of the present president only. Therefore, it is my, I wanted to bring it to a lordship's notice, my lord. I have
One other aspect, if I may suggest to all of them, my lord. What I was thinking, my lord, like there's other issue in regarding to other matters and all, my lord. The AB is functioning. The lordship has suggested appointing Udayawalla committee and all. Whatever the grievance is, my lord, this is an ongoing process which cannot depending on all members, my lord. Therefore, let it be looked into, let it be addressed at that Because let us move forward. That's what I'm looking at.
The way you are saying it appears that that committee will be permanent committee, but
Not permanent, my lord. As and when
that
it
committee has to be formed.
ಅವತ್ತು ಸಮಸ್ಯೆ ಇರುವುದಿಲ್ಲ.
Cannot be.
There will be no problem at all, Your Lordship. I can assure to this honorable court, my lord, there cannot be any. That's all my humble request, Your Lordship.
This settlement terms which have been praised are very balanced and very nicely done. We have to appreciate all of you for that.
Yes.
The highest will go here.
Most for the.
All of them. But for Your Lordship's indulgence, with the leadership of our advocate, respected Advocate General, my lord, we were able to arrive at a conclusion. Every member with wholehearted agreed, my lord, except in
This one we leave it to that committee as suggested by the Advocate General. Because if, see, any particular decision we pass,
no,
we can pass the decision, but we are, it may not be in all of your interest to pass an order.
My lord, I need not say anything, my lord. How it should be put into to the committee, my lord, may record it under this.
As a record, man.
That's all, my lord.
As to will record.
Yes, Your Lord.
That will record it. Let the committee discuss amongst you.
That's all.
And let the.
Because it was there.
This matter, it is better that you resolve it amicably, whichever way that it has to be resolved.
It is all, but for that, Your Lordship, it was already there. Otherwise, they would not have demanded that also.
Again, we don't want to say anything.
Yes, Your Lordship.
We are holding back from saying anything because it may not be proper for us to say anything.
Committee positively let them consider, Your Lordship. That's all, Your Lordship. It is within their hand, Your Lordship. Yes, Your Lordship.
All the posts have been withdrawn, all deleted, all the complaints have been withdrawn.
All the cases are withdrawn. It's no adversity case, my lord.
Will
be withdrawn.
Because there is one criminal petition here. They have to cooperate in getting it squashed. One FIR filed by this side. That, my lord, we'll have to cooperate in getting that also closed by the report of.
Both can be brought together.
That is what we are saying. It has not been paused yet.
And the suspension resolution.
What are the timelines for each of this happening?
And
Same to be published
within a day or two itself. All immediately, washing also at the earliest, everything.
Washing probably immediately on the opening only we'll have to do it.
Yes, ಎರಡು ಕೇಸು ಪಾಸಿಂಗ್ ಎರಡು
Social media post has to be withdrawn.
ಅದನ್ನು ಮಾಡ್ತಾರೆ.
Both.
ಏನಿದೆ ಅದು ಏನಿದೆ ಅದು.
And in future, don't post. ಎಲ್ಲ ಫೇಸ್ಬುಕ್ ಎಲ್ಲ ಡಿಲೀಟ್ ಮಾಡಿ.
ನಮಗೆ ಬರುವುದೇ ಇಲ್ಲ ಅದು. ಯಾರ ಹೆಸರು ಹೇಳ್ಬೇಡಿ ಸರ್ ದಯವಿಟ್ಟು.
Now it is closed.
ಯಾರು ಇದು ಮಾಡಬೇಕು ಹೋಗಬೇಡಿಯಪ್ಪ.
ಆಯ್ತು ಇದ್ರಿ. ಸ್ವಲ್ಪ ಇರಿ. ಸ್ವಲ್ಪ ಇರಿ ಗೋಪಾಲ್. Please don't use anybody's name, sir. Please put an end to it. Please put an end, sir.
We compromise if they side.
Thankfully, 15 days vacation is there.
It will probably cool down.
ಇಲ್ಲಾದ್ರೆ ಇನ್ನ ಸಿಮರಿಂಗ್ ಆಗ್ತಾ ಇತ್ತು ಒಂದು 15 days. ಮುನಿಯಪ್ಪನವ್ರೆ ಇನ್ನು 15 ದಿನ ಆರಾಮಾಗಿ ವೆಕೇಶನ್ ಇದೆ.
So far as the other issues, it is there in the libraries, but the council will have to take a call and with the committee.
No, leave it to the court, sir.
We'll let the committee consider all of it. Let the committee consider.
Court will decide. Court will decide.
Let the committee consider it. Mr. Shriram has also said.
ಏನ್ ಮಾತಾಡ್ತೀರಿ ನೀವು? ಸ್ವಲ್ಪ ಇರಿ ನೀವು. ಕರೀರಿ ಅವ್ರಿಗೆ. Please ಪಾಪ ಇಲ್ಲಿ.
ಸ್ವಾಮಿ ಆ ಎರಡು ಮೆಮೋಸ್ ನಂಬಲ್ ಮೈ ಲಾರ್ಡ್ ಮೈ ಲಾರ್ಡ್ ಆ ಎರಡು ಕಾಂಪ್ರಮೈಸ್ ಸೆಟ್ಲ್ಮೆಂಟ್ ಮೆಮೋಸ್ ಏನು ಕೊಟ್ಟಿದ್ದೀವಿ ನಾವು ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಮತ್ತೆ ಕನ್ನಡದಲ್ಲಿ ಆ ಎರಡನ್ನು ತಾವು ಗಣನೆಗೆ ತಗೊಂಡು ಒಂದು ಉತ್ತಮವಾದ ಒಂದು ಸಂದೇಶನ ಈ ಸಮಾಜಕ್ಕೆ ರವಾನಿಸಬೇಕು ಅಂತ ನಾವೆಲ್ಲ ಕೇಳ್ಕೊತೀವಿ.
ನಿಮ್ಮ ಇದ್ರಲ್ಲಿ
ನಾವೆಲ್ಲ ಅನ್ಯೋನ್ಯವಾಗಿ ಮುಂದಿನ ದಿನಗಳಲ್ಲಿ ಬಹಳ ಚೆನ್ನಾಗಿರ್ತೀವಿ ಸ್ವಾಮಿ ಇದೆಲ್ಲ ಆದ್ರೆ.
ಪ್ಲೀಸ್ ಅದಿರ್ಬೇಕು. ದಟ್ ಇಸ್ ದ ಮೋಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್.
ಏನಿಲ್ಲ ಏನೋ ಸ್ಪರ್ ಆಫ್ ದಿ ಮೂಮೆಂಟ್ ಏನೋ ಆಗಿದೆ ಅಲ್ಲಿ ದಟ್ ವಿ ಕ್ಲೀನ್.
ಸೊ ಇದು ಯು ವಿಲ್ ನೌ ಸೈನ್ ದಿಸ್ ಅಂಡ್
ಸೈನ್ ಮಾಡ್ತಾರೆ.
with the elected body. ಇಲ್ಲ ಅಂದ್ರೆ ನಾವು sign ಮಾಡೋದಕ್ಕೆ ಕಷ್ಟ.
Right now it is the committee which will have to consider all of it. You cannot say governing body. Let the committee consider it. They're trying to resolve all your issues.
Discuss ಮಾಡೋ ಮಧ್ಯ ಮಾತಾಡ್ತಾರೆ.
That will be a little difficult for us to say.
Only on that one issue.
Now, there are so many bigger issues being considered by the committee. So you let the committee consider it, and you are there, you are represented before the committee, you place your stand before the committee. Let the committee consider it. It is, if that, then the committee will not be able to take any decision and it will wind up at that. Whole purpose is different.
ಇಲ್ಲ ಸರ್ ಸುಮ್ಮನೆ ಬಾ.
Obviously, committee is not deciding anything. They are discussing with all of you.
Lord, somehow we have to bring in.
You place your stand before them, they will place their stand before the committee.
Actually, committee ಮುಂದೆ ಇರೋದು ಆ issue ಬೇರೆ issue. But this issue.
ಇದು ಒಂದು issue ಇದೆ, ಇದನ್ನು let it be discussed before the committee. Whatever, see, why we are not passing orders is, orders will have to be on either side. This we can now at least request you, and if the committee munde, they can tell you what to do. Normally it is, we are not mediating, we are adjudicating, we are deciding. Deciding can be only two ways.
Pass an order.
Naturally,
Obviously, you are there. How many people are there? Some 18 people are there.
No,
speaking to the committee.
now it is increased to another 10 years.
Inna 10 ಆಗಿದೆಯಾ?
Women representation.
ಎಲ್ಲ ಇದೆ.
ಕಮಿಟಿ ನಮ್ಮನ್ನ ಬೈಕೊಂಡಂಗ್ ಮಾಡಬೇಡಿ ಅಷ್ಟೇ.
ನಮ್ಮನ್ನ ಬೈಕೊಂಡೇ ಬೈಕತ್ತಾರೆ ಅದರಲ್ಲಿ.
ನಮ್ಮನ್ನ ಬೈಕೊಂಡ ನಿಮ್ಮನ್ನ
ಬೈಕೊಳ್ತಾರೆ. ನಮ್ಮನ್ನ ಬೈಕೊಂಡ್ರು ಪರವಾಗಿಲ್ಲ, ಕೋರ್ಟ್ ಬೈದಾರೆ ಸರಿ.
Because we have committee should not be put into a. So what do we record, that you are going to sign this?
Sign this and.
Any other committee member, please.
No, we have objection. Can't make. No, that we can't. No. No, that may not be fair. That statement.
ಅಲ್ಲಪ್ಪ ಅಲ್ಲಿ ಕಮಿಟಿ ಬೇರೆ ಇದೆ ಬಿಡಪ್ಪ, ಅಲ್ಲಿ
ಕಮಿಟಿ ಬೇರೆ ಇದೆ.
ಆ ಕಮಿಟಿ ಬೇರೆ, ಉದಯವಾಳ ಸಾಹೇಬ್ರೆಲ್ಲ ಇದಾರೆ, ಇರ್ಲಿ ಬಿಡಿ, ಏನು ಇಲ್ಲ, ಅವರು ನಮ್ಮ ಅಡ್ವೊಕೇಟನೇ, ಡೋಂಟ್ ವರಿ. ನಾವೆಲ್ಲ
What do you want us to record now?
ಏನು ಆಗುದಿಲ್ಲ, ಡೋಂಟ್ ವರಿ.
Your Lordship may record the memo what we have given, my lords. And Your Lordship, insofar the other memo is concerned, Your Lordship may refer it to the committee, my lords.
Election committee
ಅವರೇ ಬೇಡ ಅಂತಲ್ಲ ಬಿಟ್ಟು.
ಅವರೇ ಬೇಡ ಅಂದ್ರೆ ನಾವೇನು ಮಾಡೋಕ್ಕಾಗಲ್ಲ.
Then nothing will go through. We will have to hear you and decide. Then this whole thing will not go through.
ಇರಪ್ಪ.
My lord, Your Lordship, with great care, the committee comprises of Mr. Udayavalla, Ashok Karnataka, Mr. Shivram is there, everybody is there, my lord. So the question of saying that, and it's a recommendatory, as Your Lordship knows, sir.
We agree with you completely.
The question of anybody.
The president is saying
therefore, my
something
lord,
else.
Your Lordship not go by it individual statement, my lord.
Individual statement ಮಾಡ್ತಾ ಹೋದ್ರೆ there is no end.
There's no end to it, my lord.
We have to hear Mr.
Go by
Shivram.
whatever Shivram and.
I made it clear, my lord, on my part, my lord, I request my learned friend not to raise any.
So therefore.
We have to hear Mr. Shivram and Mr. Panindra.
That's all.
If Mr.
What they
Panindra
want-
consents to it,
And Mr. Shivram, that's
What
all.
association wants is, they don't want to come under
No,
this
no.
committee, that's what
No.
president is telling you, lordship.
No.
ಅಲ್ಲ, ಅವ್ರ concerns ಇದೆ, I'm trying to.
ತಾವೇನ್ ಮಾಡ್ತಾ
whatever you say, if you are agreeable, we'll refer. There's a mediation, consent.
They are open.
ಇನ್ನೊಂದು ಅರ್ಧ ಗಂಟೆ ಹೋಗಿ ಬರ್ತೀರಾ? ಇಲ್ಲ ಇವಾಗ್ಲೇ ಹೇಳ್ತೀರಾ. ಬಿಸಿ ಕಾಫಿ ಬದಲು ಕೋಲ್ಡ್ ಡ್ರಿಂಕ್ಸ್ ಸ್ವಲ್ಪ ತಗೊಳ್ಳಿ. ಬಿಸಿ ಕಾಫಿ ಕೊಡಿಸ್ಬೇಡಿ.
But the English version, I think all of us have agreed.
All of you have agreed, but this is subject to this.
Something else is added.
Yes.
Whatever is added, everything has to be resolved. This is subject to this and third mele. If you are not agreeable for this, this will go. You cannot say this should happen, this should not happen. Via media, as the Advocate General submitted, is this goes before the committee. This we accept here. But once you say that this will go before the committee, you have to stick to it. That the committee will have to look at it. And if this continues, it will be a big problem.
Let us, sorry, we are on the last.
We are here. Tomorrow is the last day. We are here. No problem. If it yesterday all of you spent till 8:30, we don't mind spending till 8:30. Don't worry.
Shivram has confidence in.
He's also part of the committee.
We should not be part.
ನಾನು ನಿಮ್ಮ ಎದುರುಗಡೆನೆ ಹೇಳಿದ್ದೀನಿ, ಹೊರಗಡೆ ಕರ್ಕೊಂಡೋಗಿ ಏನು ಹೇಳ್ತಾ ಇಲ್ಲ. I am open to there is no problem at all. Please resolve that issue. We can clear it. There is no
The suggestion by the learned Advocate General is the best.
Best.
That the committee can look at it.
You have to go by that.
They will find the signed memo will give you.
ಈಗಲೇ ಮಾಡಿಸ್ತೀನಿ.
ಇದೊಂದು ನೋಡ್ಕೊಂಡು ಬನ್ನಿ. ಇದು ಯಾವುದು? ಇವಾಗ ನೀವು ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು. ನಮ್ಗೇನಿಲ್ಲ. If all of you are agreeable, we'll adjourn. This will come, but
4:15
sugar matter, if you are all
4:15.
ಯಾವಾಗ ಸರ್?
ಈಗ
In fact, according to the ordinance,
ಮಧ್ಯದಲ್ಲಿ ಭಾನುಪ್ರಕಾಶ್ ಚಾನ್ಸ್ ಸಿಕ್ಕಿದ್ದೆ.
we point out all this tomorrow.
No, if you're all agreeable, yes. If you're not agreeable, then we can't. ನಿಮ್ದೇ ಮ್ಯಾಟ್ರಿಗೆ ಹೇಳ್ತಾ ಇರೋದವ್ರು. ಶುಗರ್ ಅಂತ ಇದಾರೆ. ನೀವು ಹೋಗಿ ಬನ್ನಿ. ಬಿಸಿ ಕಾಫಿ ಮಾತ್ರ ಕುಡಿಬೇಡಿ ಅಷ್ಟೇ. ಇವತ್ ಮಾಡಿ ಮುಗಿಸಿ ನಾಳೆ ಆಮೇಲೆ if you are not able to do this to me and nale if they insist on argument, we won't be able to do anything. That is why muksi
tomorrow in the morning hours, my lord. Again, it will be
only
morning hours in the early, my lord.
ನೀವು ಮಾರ್ನಿಂಗ್ ಅಂದಿದ್ದೆ. AG has settled all these things now. He knows how this one is. No problem.
My lord, yesterday your lordship said it should be in the preliminary hearing. Today registry has posted in the B group at 83.
Anyway, if it had come there also, it would not have reached, because the other matter went on for a long time. So it has not caused you any issue.
Therefore, my request is
tomorrow it will come in preliminary hearing.
Preliminary hearing on the top of it.
Everything is
preliminary hearing.
83.
Control will come and mention will be by 11:30, 12 after first lordship.
The first would be all the fresh matters. After that would be.
Please.
After that.
Please.
After the fresh matter.
You may posted it to them.
Is there a call list model?
83 relist tomorrow in preliminary hearing.
List number 2, serial number 12.
Just for the petitioner for interim relief, my lords. Please. There's a need for 4 lakhs.
4 lakhs.
Other than that,
So allow them to operate that.
for interim relief may be given, my lords.
That is what. That's why he wanted to find out yesterday how much is the lien. Now he's got the information. It's 4 instruction that it's 4 lakhs. Rest of it you can operate.
Let the petition be like that only, my lords.
Yakappa.
Like my lord, and there is a technical issue in this case actually, my lords. and like they furnish a records of the lien thing. Well, the same thing, my lords, I have received 50,000 from the accused, my lords. It is like with respect to the one transaction ID. So this NCRP, my lords, with respect to the same transaction ID, they have filed duplicate entries and it has come close to
And now that,
5 lakhs. So that's the reason, like, I will let the petition be like that only, my lords. Just interim relief may be given, my lords. Like, because since that SOP comes, it will become like easier for me to make submissions. So let that interim relief may be given.
Respondent bank is directed to maintain a lien in respect of the petitioner's account only as regards the lien notices which have been received by the respondent bank, and permit the petitioner to operate the account as regards the balance amounts till the next date of hearing. Relist on 8/1.
Obliged, my lords.
Serial number 13. Hari case.
FIR has been filed. The DG has filed a memo enclosing the FIR. She submitted
Hand
that
delivery of the
investigation.
interim order, my lords.
Not necessary. She submitted that investigation is going on. A submission is placed on record. The file is closed.
Serial number 14. Baba Jan SP.
My lord, in this matter, my lord, R2 is not BBMP.
Who is R2? Joint Commissioner Alankar Rage, Kodgeli Subdivision, Sakar Nagar. Who is respondent number 2? Yarappa idru?
Only I am appearing for 6 to 17 filed application.
Adaitappa, who were the parties earlier? Who had appeared in the
NK
matter?
Ramesh, plus R2.
They shown it as my lord survey department. It doesn't come on.
Joint Commissioner Survey Department.
Since Pawan Kumar's name is shown, my lord, for R2.
BBMP is not saying it's not BBMP.
The petitioner needs to.
Jurisdictional city surveyor for the purpose of the survey as sought for in the present petition, which shall be considered and needful done by the jurisdictional city surveyor within the period of 8
Would have to be
weeks.
carried out. That is a submission made by Mr. Ramesh. So Mr. Ramesh had appeared earlier. Now he's no longer on the panel.
Please. Anyways, my lord, since my lord Pawan Kumar instructed me to say this.
So this property comes under your jurisdiction.
Please, my lord.
So unless you'll have to verify and make your submission as to whether you have any claim on this property or not.
Oh, my lord, we don't have any objections for the survey.
Of this amended.
Please, my lord.
Even as per the amended.
He has to make a representation before the government, my lord, then the government can serve.
That is what you will have to say. I have no.
Yes, sir.
For this you took 3 adjournments and now you come and say I'm not a party. In spite of you having instructions. IA number 1 of 25 has been filed, seeking to add one more property, accepting the reasons stated in the in the affidavit in support of said application is allowed. Petitioner is permitted to carry out the amendment and file amended petition. In that view of the matter, the order dated 2nd March 2023 shall apply even insofar as the amended petition and the newly included property is concerned. Suitable representation can be made by the petitioner to respond number to the jurisdictional city surveyor attached to the city survey office, bringing the above to a notice of the said surveyor, who is directed to comply with the order dated 2nd March 2023.
Okay.
Bill number 15. Vandana PL.
My lords, my lord, in the last date of hearing, learned AG has short for time to furnish the
For the special
remuneration
public
details.
prosecutor.
Yes, my lord.
My lords,
One aspect is, my lord,
advocate on record is unwell, my lords. Kindly have it after the vacation.
Continue the prosecution.
Lord, here in this case, my lord, the trial is stalled, my lord. That's the only reason.
No stay.
Huh?
There is a stay.
I just want to bring my, notice to my lord. Kindly, my lord, just have a look at this, my lord. Kindly have a look at this judgment. Page number 29. my lord. In this case, my lord, paragraph number 12, 3 lines from the bottom. my lord. But to read it completely would be better.
Yes.
The other aspect is with regard to the special public prosecutor not having any claim with the government regarding his remuneration. In that regard, paragraph 32 of the said order states that ordinarily SPP should be paid out of the state funds, even if it appears in support of a private complaint. But there may be some special cases where special public prosecutor remuneration may be collected from private sources. In the instant case, taking note of the said observation of this court, the state government has stated that the impugned notifications SPP would have no claim with the government regarding this remuneration, as he has been appointed at the instance of the applicant respondent number 4 and 5 hearing. It has been, that then the Shiva Reddy's case is mentioned. It has been held.
Shiva Reddy's case has been considered and this has been expanded.
Yes, ma'am. Next, and should be deposit the fees in advance to the government and the SPP be paid out of that by the government. By such a condition being prescribed in the impugned order, I do not think there is any violation of the right of the accused towards a fair trial. The proceeding of this court. And not only to this effect, more.
I appear for responding 5 and 6, my lord.
Yes.
Right, in this case, Lord may kindly come to paragraph, page number 15, another judgment, Lord. Page number 15. Paragraph number 11. The accused has no the delay aspect, right? Then the accused has no locus standi to question the appointment of the SPP made at the behest of the complainant victim. On an application made by the victim, the state is bound to accede to such a request, subject to restrictions of qualification.
That we already said that we'll
Yes,
fix a
ma'am.
time
That
frame.
is settled. Yes, ma'am.
Now.
And as far as Shiva Reddy's case, ma'am, Shiva Reddy's case not in here in page number 5.
This has been stuck here for 2 years. So now we'll fix a time and that is not a major issue.
Yes, ma'am. We will. And not just that, we have also.
The payment
Yes,
which Ms. Shyam Sundar had argued. So this judgment is now holding forth unless something else is shown. We'll have it tomorrow. Please ask him to come tomorrow.
Grateful.
Yes, that's fine.
We won't grant you any further time tomorrow.
Grateful, my lord.
2:30 minute tomorrow?
2:30 ಬಂದ್ರೆ ನೀವೇ ಬರ್ಬೇಕಷ್ಟೇ.
Sorry.
Learned counsel for the petitioner seeks for a day's time. Learned counsel for learned additional advocate general has filed a memo along with certain decisions. The same is taken on record. Release tomorrow. It's made clear that no further adjournment would be granted.
Grateful.
Serial number 16. Mahesh Kiran Shetty, connected matter.
Your lords, appearing on behalf of petitioner, your lords.
Yes.
Let's kindly pass over the matter, your
Lord, in
lords.
serial number
Spur won't
16.
reach. Pass over. Yes.
Serial number 17.
I would like to submit this memo.
Paid the cost? In memo.
ಇದು ಡ್ಯೂರಿಂಗ್ ಇದು ಫೈನಾನ್ಷಿಯಲ್ ಪ್ರಾಬ್ಲಮ್ ಇತ್ತು ಕಟ್ಟಕ್ಕಾಗ್ಲಿಲ್ಲ ಅಂಡ್ ಟುಡೇ ವೆನ್ ಹಿ ಹ್ಯಾಡ್ ಬೀನ್ ಟು pay that, they said time ಕೊಟ್ರದ್ ಆಗೋಗಿದೆ, ಇವಾಗ ತೊಗೊಳಕ್ಕಾಗಲ್ಲ, get the direction from the court ಅಂತ ಹೇಳಿದ್ರಂತೆ.
Counsel for the petitioner has filed a memo stating that the petitioner is now willing to make payment of the costs which have been imposed. Hence, the time which had been set by this court is extended by a period of another 15 days to enable the petitioner to do so.
Much obliged.
18.
Appearing for petitioner, my lord. My lord, extremely sorry, my lord. We did not file the compliance memo. It has been
File
done
now?
today. We will file by tomorrow itself, my lord. The payment has been.
Requesting counsel for the petitioner read this tomorrow.
19.
For the petitioner.
For
Applied for my
respondent numbers
son's-
1 and 2, Your Lordship.
I've applied for my son's passport. So he has a.
Raghunath is appearing for the father.
Somebody
I
has
appear for
filed.
the father.
For the mother, somebody has filed wakalat, Your Lordship.
No,
Who
he's a,
is
no, I've
the
applied for,
proposed respondent?
I've applied for his passport.
Normally, the mother applies for the passport. This
Yeah,
time
the father has a
father is-
16-year-old
Father has
boy.
applied, mother has been impleted. Is yet to be.
Senior has, is out of session, Your Lordship.
Is any objection?
Yes, Your Lordship, senior is out of session, kindly push it.
Senior out of station is not a reason to grant in these kind of matters. Phone ಮಾಡಿ ಕೇಳಿ ಅವ್ರಿಗೆ ಏನ್
The 2nd January, the cricket tournament, he's going to Dubai. He's a cricketer.
Lordship, adjournment ತಗೊಳಕ್ ಹೇಳಿದ್ದಾರೆ ನಮ್ಮ next.
No adjournment. Pass over, please get your instruction.
At least it's memo.
ಮಗುಗೆ cricket tournament ಇದೆ, is being selected. Without the passport, he won't be able to participate in the cricket tournament which is being held. Don't destroy the child's future on hopes on that. Get the instructions. ನಿಮ್ ರಘುನಾಥ್ ಫೋನ್ ಮಾಡಿ pass over. He can, if he wants, he can appear through VC. ಇಲ್ಲ ನಿಮ್ಗೆ ಹೇಳಿ. ಅರ್ಥ ಆಯ್ತಲ್ಲ ಏನ್ ಹೇಳಿದ್ದು ಅಂತ. ಮಗು ಅಬ್ರಾಡ್ ಹೋಗ್ಬೇಕು ಕ್ರಿಕೆಟ್ ಆಡಕ್ಕೆ, ಕಾಪಿ ಇದೆ ತಾನೇ ಪೆಟಿಷನ್? ಅವ್ರು ನೋಡಿದಾರಲ್ಲ ರಘುನಾಥ್ ಅವರು. ಅರ್ಜೆಂಟ್ ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು, ನಾವು ಡಿಲೇ ಮಾಡಿದ್ರೆ ಆಮೇಲೆ ಪಾಸ್ಪೋರ್ಟ್ ಸಿಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಹೋಗಕ್ಕಾಗಲ್ಲ. ಸೊ ಅದನ್ನ ಫೋಟೋ ತಗೊಂಡ್ಬಿಟ್ಟು ನಿಮ್ ಸೀನಿಯರ್ ಕಳಿಸ್ಬಿಟ್ಟು ವೆರಿಫೈ ಮಾಡಿ. ಪಾಸ್
233 matters.
ಇನ್ನ ಒಂದಿದೆಯಲ್ಲಮ್ಮ ಲಿಸ್ಟ್ 3.
List 3.
Yes.
Serial number 1. Yes, sir. Kamalacharan.
Detention officer.
Judgment, you wanted to make your submission on that judgment.
My lord, that judgment of in Cariappa's judgment, my lords, I am not pressing into action at all in this matter, my lords, because the settled position between the parties has, insofar as the rights that are created, insofar as the lands are concerned, are settled in the RSA. That judgment has become
We'll stick
final.
to that.
We'll stick to that. Those whatever limited, my submission is that the limited rights that have been vested with the holder and the subsequent transferee, who is the plaintiff and his son, etc., that will be still continue. And the transferability aspect I have argued before, my lords. My only submission would be that insofar as this finding in Cariappa's case, which is a later judgment of this honorable court, is that the right of transferability may be recognized by virtue of that. But insofar as the right becoming
pressing that, you're pressing
to
that.
that limited extent, my lords, not insofar as the change of tenure and the right. I
You're
will
not relying on that, then we don't need to ask the advocate.
No, then I will stick to my first submission, my lords, because the rights that have been crystallized insofar as my predecessor are entitled in the RSA, I will not argue beyond that, my lords. Because even though
transferability,
on transferability, section 3 I have submitted, my lords, I have placed also judgments on record. Whatever is the right that was originally obtained is something that is transferable under the Transfer of Property Act. The plaintiff himself, in whose favor those rights were conferred by the judgment of the RSA and the suit, etc., he himself was not the original grantee. He is a transferee, two heads removed.
Of
So
a
therefore-
transferee.
And that is binding even
Pursuant to an auction conduct.
Yes, please. Pursuant to an auction also. And by virtue of that, The government today cannot say that it is not transferable because that judgment will be binding on them also. As that.
That judgment doesn't speak, RSA judgment doesn't speak.
But
of
then
anything about transfer.
nonetheless, the facts of that case, which is very well known to the government, was that it was filed by a subsequent transferee from the original grantee. That is, and it was not a ground that was raised at all.
Judgment is a law on the point that it decides. This issue has not been decided by that judgment. So if you are not pressing the other
This
judgment.
second judgment, my lords, I think the law will not favor me if I try to press that judgment, because even though for a third party it may appear to be that the position of law was not correctly referred to in the RSA by virtue of the regulations of the court regulations. It may be per incurium for a third party, but insofar as a inter se dispute and a finding that has been given between the parties, I cannot go behind that, please.
Then there's nothing anyway.
Yeah.
As far as the
Transfer
is concerned, return submissions and briefs notes are.
Finally.
Really.
Final written submission, finally. Final.
It was ready by last time only.
Yes.
As far as transfer is concerned, the rule 141,
That you have.
no doubt, you can unite, but transferring it to a third party, that's not allowed. Because I will be permitted to give only that much. 141. Jama Malays contain the right of cultivation of cardamom words for Christo. So they do not have any proprietary rights on the Malays. Jama Malays are not transferable and treated as rentals also within the reserve forest. They shall have the right to cultivate, inherit, all that, but not to transfer. 141 is very clear of that.
That is what you argued. We'll have to consider that.
Yes.
Only issue that you put across to both of you was only this, that on account of non-payment of land revenue, you bought it for sale, you transferred it.
Yes. Yes. As far as that aspect is not still there.
To a person who is not the Malaydar. In fact, to a district judge, which is even brings the law and judiciary into that. The district judge bought it. Then he sold it to their vendors. The vendors sold it to them.
How may not the virtue of this rule?
Until all that time, until the PIL came, you did not raise any issue on this.
Things were all clarified in the PIL, moreover, not in the writ appeal also. In the writ appeal, now not sitting on the judgment.
Now, AGA has filed as written submission, the same is taken on record, reserved.
One word in reply insofar as this regulation is. My lord, this is only the manual, my lord. It's all internal instructions within a department. It is not part of the act. It is not a rule, my lord.
We'll have to consider this.
I have taken those stands in my synopsis and taken judgments.
You have argued that. We'll have to see what it.
Yes, please.
What is this IA for recalling which has been said to be pending of 10/3/25?
One impleading application was filed, my lord.
Order sheet.
That I think that application I filed. See what happened, my lords, was that while the matter was being heard.
So what do you want to do?
No, I had that day, my lords, without too much of hearing, that application was allowed. But later we found out the person who filed that impleading applicant is a far-off descendant of the original grantee. Or he at least claims to be. So therefore, my application seeking to.
But anyway, he is not.
No, anyway, he's not there anyway. That's great.
Great.
230 mood matters. Arnachalam Kumar.
For the petitioner, my lords, I am the complainant in this case, my lords. I am seeking for interim relief, my lords, not to defreeze, my lords.
Not to defreeze.
Yes, my lords. I am the complainant Investigation authority has sent me mail that my the complaint case will be closed.
Where is
I'm
the
just
email?
furnishing that that particular email. Yesterday they sent me at 5:30, my lords. So that was a said urgency to move the matter, my lords. And it does not say like why they are using my case. My submission is that they are in. My lords, it's actually an online betting case, my lords, and the accused is a very big person. So that's the reason, like they're not registering an FIR. So that may be apart, my lords. Just I'm pressing for interim relief, my lords, not to defreeze.
Any instructions? How much is the amount?
My lords, like my complaint was for to 32 lakhs, my lords, but they put a lien to 12 lakh rupees, like that was recovered. But the thing is, now they are sending me mail that like we are not registering an FIR and will release the funds to the that accused only. But they are not doing anything, my lords, actually.
Don't release it for now. Later, get your instruction makers, because once money is released, then we can't get it. The respondent are restrained from any manner. They had asked for release of the amount. Now we are not releasing in their favor. You are releasing somewhere else. Our respondents are directed to continue the lien on the accounts as per acknowledgement number so and so. You are given your account. Which is the account where the lien is?
My lords, they place lien close to 122 accounts.
Where is that account number?
Annexure H, my lords.
Annexure H. Your prayer, you are given your account number.
Lord, it is in the report. My lords, the Annexure H is the action taken report, my lords. This NCRP, my lords, upon each complaint, they will file a consolidated like report stating on which are the transactions they put a lien. So it is close to 122.
Council, we are not asking you for the money. We have no interest in knowing how much. Which is the account on which the lien is being placed? Where is that details?
Plus that they need to submit. My lords,
So what order are we going to pass? Continue the lien?
Not to defreeze the said account until the.
Which account?
Plus not to defreeze the said accounts upon the said acknowledgement numbers, my lords, and there are 5 acknowledgements. That is there in the said last annexure that I filed along with the memo, my lords. That is the latest action taken report. It reflects 5 complaints and the relevant transaction that was put on hold. So it clearly says that I mean the first 5, see number 1, 2, 3, 5 are my complaints, my lords, and I want an interim relief, like so that no lien is unliened upon this 5 acknowledgements.
Annexure, there are 124 liens.
Yes, my lords.
124 plus 5. 124 liens.
Yes, my lords.
And 5 action taken.
My lords, 5 are the acknowledgement. That was a complaint filed by me, my lords. My lords, since it is happening in 3 accounts, so they told me to file through 5 acknowledgements. That is basically a complaint, my lords. So, my lords, my submission is that
Lord,
let
these are
them
not
not
account
unlean
fraud, these
upon
are
this
UPI transaction, my lord.
Yes.
It seems the
maybe UPI
subcategory, my lord, these are.
Lien will have to be on a particular account, which is not able to tell us. How do we continue that?
My lords, lien on the 5 complaint
account number, you know, to release the money to his account number. The account number on which the lien is there, you have not mentioned it anywhere.
Plus, my lord, this NCRP only furnishes me action taken report, my lords. It says the complaint that was filed by me and the lien that was placed pursuant to the 5 complaints that will be reflected in the action taken report. So my submission is that all the 124 transaction that was on lien should be kept like that only, my lords.
Lord, it may be taken tomorrow, my lord, I will take instruction and.
Instruction, this is, Lord, AGA seeks for and is granted a day's time to obtain instruction, make a submission, relist tomorrow. A memo filed by counsel for the petitioner is taken on record.
Ganapati Bhatt.
The impugned order is at my lord's annexure M, page 158 for the my lord's,
Page?
158, my lords. That's the senior citizen tribunal. My lords has passed an order as against the daughter-in-law, my lords, of respondent number 2 to evict from the shared household, my lords, which is the matrimonial house.
The ex parte order.
Please, my lords. I have not given you any opportunity, my lords.
Let me see the page number 155, my lords.
Yes.
There is a writ petition proceedings which is pending before the honorable court. And my lords may see the order, my lords.
May I submit, my lords?
2012-2024, my lords.
2012?
2024, my lords. Item number 10, my lords.
But there are various litigation pending before this court as well
Please,
as trial
my
court.
lords, the honorable court has directed, my lords, either to give the rupees of 25,000 or to give, my lords, 2 BHK residential house, my lords. The respondent, my lords, already we have given the 2 BHK residential house to them, but they are not shifting to that house, my lords. In pursuant to that, my lords, we have.
My submission to the court is that.
Go before the same court seeking for a modification or a clarification.
Please, my lords, but
The order passed by coordinate.
I was not even given an opportunity to contest this proceedings, my lords.
So we cannot pass an order as regards the order passed by a coordinate bench. If you want to seek for modification, move that.
But that I have taken steps, my lord. My submission to the court is that.
We can pass orders in your favor. Any orders in this?
My lords, may kindly
When
see,
there's an
my lords,
order.
my lords, may kindly see the police aid has been given, my lords. She has a 6-year-old daughter, my lords.
Mr. Counsel, there is an order passed by a coordinate bench of
Please,
this
my-
court
my-
which is
my lords, may kindly
being
see that.
implemented.
Please.
You cannot come before this court for that.
No, my lords, may kindly see that order, please, my lords. Until, under the such circumstances, until the disposal of the writ petition, the respondent shall provide. My lords, that order has been passed, considering the safety of petitioner, that is me, my lords. Considering my safety, my lords, that order was passed. I am the petitioner there, my lords. My lords, there is a protection order in my favor. My lords may kindly see.
Mr. But
Please, my lords.
it's in your petition that an order has been passed saying that you have to vacate
My lords, it is not a.
and receiving 25,000 rupees.
I am not receiving 25,000.
They're going
My
to
lords, they
pay
are
you
depositing.
25,000.
My lords, they are- my lords, that order, my lords may kindly see. They say that they have provided a 2 BHK. My lords, it is not suitable for accommodation, my lords. That is my case.
You cannot file another petition when a petition is pending.
My lords, I am not challenging those orders. My lords, my lords, pendency of this, my lords, they file another petition before this court seeking
This
implementation
is
of
an
this order.
abuse of the process of court.
My lords, they have gone before the assistant commissioner. I have not gone before the
There's
assistant.
a writ petition which is pending
Please, my lords.
where the dispute is being resolved.
My lords, that
You
is
have
in,
filed another petition.
my lords, that
You
is
should
in.
have moved it in that matter. Not like
But
filing
this is
another.
a separate order, my lords, not, my lords, this order. My
Sorry.
lords, annexure M is, my lords, passed by the assistant commissioner, my lords. But during the pendency of the writ petition, they go before the assistant
If you're
commissioner.
not satisfied with that case, you'll have to move that court,
Please, my lords.
not keep quiet. And thereafter come before this court.
My lords, that is pending for consideration, my lords. Pendency of that, my lords,
And
this order has
ADA
been
access
passed.
notice for respondent 1, she so and so. Access notice for respondent number 2 to 4. The list between the parties already pending in WP number 20867 of 2024, which was recently registered on 6/11/2025. It was not permissible for the petitioner to have filed the present petition, which is in as much, which amounts to challenging the order dated 2012/2024 passed in the said petition. Though this court could impose costs on the petitioner, considering the relationship between the petitioner and the respondent, this court refrains from doing so. Liberty is however reserved to the petitioner to move the said court for such relief as may be advised.
Please.
Obligement.
Naveen DH.
I represent the petitioner, my lords.
Yes.
My lords, my lords, Lordships may kindly turn to page 23. Petitioner files a complaint before the District Consumer Forum and the complaint is allowed. Subsequently, an execution petition is filed, my lords. Lordships may then kindly turn to page number 38. The respondent number 3.
The opposite party is who?
Opposite party is the respondent number 3, my lords.
Yes.
Now the respondent number 3 files an appeal before the State Consumer Forum.
Hmm.
There is an order which is passed without giving an opportunity to me of being heard, and the order is modified. Subsequently, Lordships may kindly turn to page
Being heard, you
39.
didn't. How is it that
They say party in person, but have not been given an opportunity of being heard in the matter.
you cannot say that before this court?
My Lordships may kindly turn to page 39. Page 39, Consumer Forum releases 6,70,839 in my favor.
You were heard as a party in person, and thereafter the orders had been passed. That is what is record of the court.
That is recorded by the court.
Then?
But the fact remains that I was not given an opportunity of being
Then
heard.
you should move that court and tell
I
them
have
that
in
you did
fact
not.
moved. I have in fact moved a review petition.
Follow it there.
And I have sought for stay of further proceedings. In fact,
Why are you filing this?
the court has not considered my application. I am ready to deposit this money. And now, there is a warrant which is there against me, which is at page number 15, Page number 15.
Counsel, your client is trying to act smart.
I am ready to deposit. Immediately, I will deposit before
After
this court.
suffering an order and making a submission that you have not been heard.
In that matter, I have not been heard, If I can secure the order
For
sheet,
that court only to consider.
if I can secure the order sheet, I will be able to substantiate and demonstrate that I was not heard in the matter.
The order clearly indicates that you are as a party in person have been heard. That is what the reference is
The
being
order
made.
says order depicts as party in person,
Yes.
But the fact remains I have not participated in the proceeding at all, I have not participated in the proceeding at all. And even the order is modified to such an extent that it is not even the compensation which was awarded for mental agony, My lordships may kindly turn to page 23. The District Consumer Forum awards 12,51,000, The order now by the State Consumer Forum would be modified to such an extent that it is only 50,000 rupees what I'm entitled to. In fact, I have lost my title deeds pertaining to the mortgage property,
There is an order passed.
There is an order passed. I am not shying away, I'm ready to deposit the
Why do you
entire
have to
money.
go to the National Commission?
The entire money, whatever is in dispute, I am ready to deposit before this court. But I have sought for stay of the non-bailable warrants which is issued by the District Consumer Forum. Lordships may kindly turn to page 15.
If you deposit there, they will be recalled.
In fact, I've made a submission,
You can't be having parallel proceedings.
I've made my submission. There is an ongoing process, where I have to file the entire petition online. There is no provision for filing a review petition, This is my difficulty. This is my difficulty because I'll have to take it under section 40 of the Consumer Protection Act. I'll have to
There is a
file a
warrant
review
which has
petition.
been issued. Warrant is only for recovery of the money, right?
Warrant is only for recovery of the money,
So if you pay the money, it will automatically stand recorded.
I will deposit the money, If District Consumer
Not
Forum can
necessary
be
here.
considered, if District Consumer Forum can be directed, I will deposit the money before the District Consumer Forum, At page 15 is the arrest notice, There are proceedings under 72 of the Act which are undertaken. No notice has
Order
been
was
ordered.
passed directing you to appear on 1/12/25. Instead of going there, you file this on 17/12/25.
There is an arrest warrant against me, There is a non-bailable arrest warrant against me.
You are willing to deposit, you could have gone there.
I've made my submission. I've gone there. I've made my submission before the court. If
This-
District Consumer Forum
this
can be
is not-
directed, I will go
Petitioner is
deposit the
before
money
this
there.
court seeking for the following reliefs. An arrest notice had been issued by the second additional district
My lord,
consumer
for a
dispute
moment, if I can submit,
redressal commission.
this arrest notice was affixed along with the non-bailable warrant, which is at page 17. In fact, I've
Then
produced
please
the
wait for our
non-bailable warrant.
orders. Had been issued by so and so in consumer complaint number 568 of 2013 on account of the petitioner not having complied with the order date 11/9/2025 and in subsequent notice issued on 12/9/2025 to refund the amount of rupees 6,70,839. The said arrest notice is in fact worded as a show cause notice as to calling upon the petitioner to appear before the commission on 1/12/2025 without fail and to show cause why action shall not be taken against him for offense punishable under section 72 of the Consumer Protection Act 2019, failing which non-bailable warrant would be issued against him.
The next sheet, page
Just a
17 is the
moment.
non-bailable warrant.
Can you please wait?
Please.
Along with the said arrest notice, a non-bailable arrest warrant had also been enclosed with therewith, indicating that action under section 72 of the Consumer Protection Act 2019 would be taken. And further directing the petitioner, your submission again here is wrong.
My lord,
This has been issued on 2nd December 25.
my lords, this notice is not issued on me, my lords. It is affixed over my house, my lords. It is affixed over my
Because
house.
you
I
did
can
not
file
do
an
112.
affidavit. My lords, I can file an affidavit. Both these notices were affixed over my house, my lords.
When you saw them.
My lords,
When you saw them.
on 17th, my lords. On 13th, my lords. On 13th,
The learned counsel for the petitioner submit that both the arrest warrant and arrest warrant, non-bailable arrest warrant had been affixed on the house of the petitioner, which the petitioner came to know subsequently, and therefore the petitioner has approached this court. Be that as it may, the petitioner now contends that the petitioner is willing to make payment of a sum of rupees 6,70,839, and that the petitioner has filed an application for recall.
I have made an application for, I will make an application for recall, my lords. My lords, review I have filed before the State Consumer Forum. District Forum, I'll approach along with the application. I'll have to keep the petitioner also present, my lords.
The petitioner submits that a review petition having been filed before the State Commission, you would be filing a recall application before the District Forum. In that view of the matter, taking into consideration that the petitioner is willing to deposit the aforesaid amount of rupees 6,70,839 within
2 weeks, my lords. 1 week, my lords. At least a
days.
My lords, 2 days.
Sorry, this is what shows your abuse of the process. We are going
Please,
to
my
discuss
lords,
this.
2 days, my lords.
Within 2 days, the operation of the non-bailable arrest warrant is stayed till such deposit, subject to the said deposit having been made, until the consideration of the recall application filed by the petitioner. With the above observation, the petition stands disposed.
Hand delivery of the copy.
Needless to say, if the deposit is not made within 2 days, the above order would stand automatically recalled.
Please, my lords.
Show your bona fides there.
My lords, have hand delivery of the copy.
Hand delivery.
Grateful, my lords.
Yes. Have it tomorrow morning. They want to consult the governing council. He is a little handicapped.
Tomorrow morning, if it doesn't resolve, then we'll have
10
to
minutes,
hear
yes, because
and pass orders.
I know. I have told them, ಅವ್ರಿಗೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
Then
They
we
seem
won't.
to have, if
Mr.
your lordship
Manindra,
sees the memo for a moment, or Kannada,
we have seen it.
last para.
Whatever it is, we are placing it before the committee.
Last para ಒಂದ್ಸಾರಿ ಓದು. ಒಂದ್ಸಾರಿ last para ಓದು. ಒಂದ್ಸಾರಿ request.
ಓದಿ ಆಯ್ತು ಆವಾಗ್ಲೇನೆ.
Last para ಓದಿಲ್ಲ.
Now, if that doesn't happen, your first memo will not be taken into account.
That's what I have indicated.
Then get ready to address arguments tomorrow.
I will still, but
We are telling you to.
Milords, I understand, Milords,
If you don't address arguments, we are not going to adjourn the matter.
I have made it clear. If it does not, yes.
Then if that is so, then argue now only, we'll close it. Why tomorrow? Why tomorrow?
Governing council are just.
Why do you want to put pressure on us on the last day?
ಅವ್ರ ಮೇಲೆ ಪ್ರೆಷರ್ ಹಾಕಕ್ ನೋಡ್ತಾ
We'll
ಇದ್ದೀನಿ.
grant the interim order and then consider it.
I want to put pressure on them,
By putting pressure on us.
not on my lords.
But can you see the last para?
Nobody, we understand. Let the committee, whatever you have, your grievance place it. ಬೇಡ ಬಿಡಿ, ನಾಳೆ ಅಡ್ರೆಸ್ ಮಾಡಿ.
ಬೆಂಗಳೂರು ವಕೀಲರ ಸಂಘದ ಯಾವುದೇ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಅಲ್ಲಿ ವಾದಿಗಳಿಗೂ ಸರಸಮಾನವಾಗಿ ವೇದಿಕೆಯಲ್ಲಿ ಅವಕಾಶ ನೀಡಬೇಕೆಂದು ಪ್ರಾರ್ಥನೆ.
ಆಯ್ತು.
ಸ್ಟೇಜ್ ಮೇಲೆ ಕೂರಿಸ್ಕೊಂಡ್ಬಿಡಿ, ಆರ್ಡರ್ ಮಾಡ್ಬಿಡಿ, ಸ್ಟೇಜ್ ಮೇಲೆ ಕೂರಿಸ್ಕೊಂಡ್ಬಿಡಿ. ಏನಿದೆ, ವಾಟ್ ಇಸ್ ದೇರ್? What is there?
We are not passing any order.
This association, why should it go to the committee? Why should such a thing? It is so anti-democratic. They got 50 votes there.
Then it doesn't look like it will settle. Please argue the matter.
ಇಂಥ clauses, unreasonable clauses ಹಾಕಿದ್ರೆ how can we? Very humbly I am asking.
The committee, you want us,
ಹೇಳೋದಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. ನಾನು ಹೋಗಿ ಒಂದು ಸಂಘದಲ್ಲಿ unelected ನಾನು ನಾನು ಹೋಗಿ ನನ್ನ ವೇದಿಕೆ ನನ್ನ ಜಾಗ ಕೊಡಿ ಅಂತ
Mr. Reddy, we have no problem in deciding the matter.
Sir,
You argue the matter, we'll decide. ನೀವು ಸೆಟಲ್ಮೆಂಟ್ ಅಂದ್ರೆ ಎಲ್ಲ ಕಮಿಟಿಗೆ ಹೋಗ್ಲಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಇಂಥದನ್ನೆಲ್ಲ we cannot.
It's up to you, it's a mediation, it's by consent.
Sir,
If no consent, nothing, it is by order.
sir, no, that your lordships have clearly indicated, we have no
Sure.
grounds on that issue.
You argument ಮಾಡಿ, any matter you argue, we will take it up.
Very clear, we are nothing against your lordships is making every effort to bridge the gap. But these are too unreasonable for us.
Let the committee will consider and say it is unreasonable.
I'll for the governing council, in the morning meeting, then I'll come back to your lordships. Or they will argue, that will assure.
The committee itself probably may say it is unreasonable. Who knows?
ಇಂಥದನ್ನೆಲ್ಲ we cannot.
You note,
ಬೆಳಗ್ಗೆ
tomorrow argue.
Bullets,
That
I
will
will stay.
assure your lordship.
Because then, because if the first memo
No, no,
doesn't go through,
naturally, my lords,
then a lot of people will have problems.
we have, my lords, I have tried my thing. ಇನ್ನೊಬ್ರು ಇದಾರೆ ಇದ್ರಲ್ಲಿ, ಇವತ್ತು ಬಂದಿಲ್ಲ ಅವ್ರೆಲ್ಲ ಕೈಗೆ ಸಿಗ್ತಾ ಇಲ್ಲ ನಂಗೆ. ರವಿಶಂಕರ್ ಆಲ್ಸೋ, ಅವರು is not trace of, ಅವರೆಲ್ಲ ಫೋನ್ ಎತ್ತುತ್ತಾ ಇಲ್ಲ, so I want to try.
He must be jumping from one court to the other.
So I want to try with his thing also to.
Tomorrow, serial number, list 2, serial number 4. Release tomorrow.
Please.
So far as our side, my lord, we have signed the proposal.
ಇಟ್ಕೊಂಡಿರ್ರಿ, ಕೊಡ್ಬೇಡಿ.
ಆಗ್ಲಿ ಸರ್, ಅಲ್ಲ ಕೊಡುವೆ ನಾಳೆ ತಗೋತೀವಿ ಕೇಸು ಅಂದ್ರು, ಅದಕ್ಕೆ
ಕೊಡ್ಬೇಡಿ, ಆಮೇಲೆ ನಿಮ್
ನಮ್ಮ ಹತ್ರನೇ ಐತೆ ಸರ್.
If it doesn't go through, we'll hear you.
Please.
If it goes through, fine.
We are ready
We
for
can only, we can only probably say, request you to look at it and make it go. ಅಷ್ಟೇ ಮಾಡಕ್ಕಾಗದ್ ನಾವು. ತಗೊಳ್ಳಿ. Urgent matters, fast over urgent matters.
Passed over matters. List number 1, serial number 2, Vasudeva Naidu.
ಎಲ್ಲಪ್ಪ? Honest.
He was held up in to argue ಮಾಡ್ತಾ ಇದ್ರು. Just left, I received a message. 2 messages.
Pass over.
Serial number 34.
Lord, as per your lordship direction, my lord, I did, my lord.
That is senior advocate is leading me in this matter.
Morning also made.
We are not
same
going to
submission.
grant. First time, yes, not second time.
Lord, Annexure D, my lord, your lordship may kindly peruse Annexure D, running page number 25, my lord.
Annexure D, page
25, my lord.
25.
This partnership deed registered between the, my lord, brother, sister-in-law and petitioner. The name and style of the partnership deed is, my lord, Messrs. Mithila Land Developers, running page number 27. Then, my lord, without the knowledge of the petitioner, my lord, he has registered one more partition deed that is in between the husband and wife, running page number 43, Annexure G.
Page 45.
43, 43, sir.
43. With the same name.
With the same name, my lord. Very next page,
Land
44.
Developers, this is also Mithila Land Developers.
Yes, ma'am. Then, my lord,
Address-
without the knowledge of the petitioner, my lord,
Just a moment.
Sorry,
Address
sorry.
is 46 Betterly. This address is changed. Yes.
Yes, my lord. Again, my lord, Messrs. Mithila Land Developers, my lord. Then, my lord, they have, without the knowledge of the petitioner, my lord, reconstituted the partnership deed, running page number 53, Annexure J. In between, again, husband and
What
wife.
is this 40?
53.
No, 43 is Kemparaj and Bindyaraj.
Yes, why husband and wife. Then, my lord, a reconstitution deed of partnership deed, again, my lord, in between husband and wife. That is, my lord, Annexure J, running page number 53. Wherein, my lord, again, under the same name and style of Messrs. Mithila Land Developers.
So what is the change? Why was this required?
Just, my lord, because my learned friend to produce this copy, accordingly, he has taken adjournment, last date of hearing. Then, my lord, I have filed a memo before this honorable court to produce the bank statement, my lord, wherein he has illegally transferred from the earlier Mithila Land Developers to second Mithila Land Developers 3,41,86,500. Memo dated, my lord, 12th December.
Yes.
I have stated in my memo, my lord, first registered on dated 14/3/2017, that is, my lord, as per Annex D, running page number 25, my lord. Second one, my lord, 17/10/2023, my lord, wherein total amount has been transferred, my lord, 3,41,86,500. Out of that, my lord, 1,19,000, my lord, withdraw has a personal reason between the husband and wife. Where next page I have explained, my lord.
This is from the current account of Mithila Land Developers.
Yes, my lord. In total, my lord, 3,41,86,000.
These transfers occurred between the period of
Between the period of, my lord, that is 12th April 2023, my lord, till now, my lord. Entire bank statement I have placed, my lord.
the second, this one was on 6th September 23.
Yes, my lord.
So till 6th September, the earlier partnership was there.
Yes, my lord. That is what, my lord, date and page number, annexure, everything I have mentioned, my lord, in the memo. Then, my lord.
The same account continues.
Yes, ma'am. Same account continued. But however, my lord, from earlier Mithila account to next Mithila account, the following the amounts has been transferred, my lord. Then one more submission, my lord. After allowing the, my lord, impleading application under Order 1 Rule 10, my lord, they have filed, my lord, anticipatory bail application before the learned magistrate, session court, my lord. It is pending for consideration for objection by the PP tomorrow, my lord.
That's okay.
Please, my lord, I brought to knowledge, my lord.
That's fine.
Please.
Now your complaint only is not registered.
Yes, ma'am. Then
Where
the
is the
refusal of the
anticipatory bail?
complaint, my lord, the civil dispute is there, that is annexure C, my lord, endorsement, running page number 24, my lord. Civil Swarupadagide. That is what, my lord, it has rejected for register. 173.
Have you filed any proceedings?
No, my lord, no. Because, my lord, if they will not receive the complaint, my lord, then I can go before the higher authority. Here they refused. If I am going higher authority does not have any power to set aside this order, my lord, this order.
Non-action, you can go against the highest authority.
Yes, my lord. Only non-action if it is not registered.
Is a rejection.
And I have made, my lord, prima facie, I have made cognizance of offense before the competent authority. This is the fraud has been committed.
What is the provision on
173, my lord.
154 is 173.
Yes, my lord. 154 CRPC, now 173 BNS. Subclause 4, my lord.
No change in the wording.
Yes, ma'am.
Proviso on that.
In identical circumstance, this honorable high court, my lord, I have a opportunity to assist. Annexure M was passed, my lord, in the year 2021.
But subsection 4 says any person aggrieved by refusal.
The refusal. Here not refused. Here rejected.
Record the information.
Yes, ma'am. Here rejected, my lord.
Rejection.
Please, ma'am.
So it only restricts it to refusal.
Yes, ma'am. For the rejection, my lord, there is no provision. My humble submission before this honorable court, my lord, I have made out, my lord, cognizable offense as per section.
What is the judgment of the coordinate bench you say?
That is running page number 67, my lord.
67.
Annexure M, my lord, wherein FIR was not registered, my lord, strictly followed the Lalita Kumari judgment, my lord. And directed the police to register the FIR, my lord, and hold the investigation. Bharati. 908.
Lalita Kumari Kodi?
Yes, ma'am.
121. Last one. One 120.
Here, my lord, intentionally police, my lord, must be, my lord, inform the proposed accused, my lord. Accordingly, they have filed a pleading application. Where already FIR was registered, my lord, against my father as my.
That's a different
Yes, yes. When my lord has directed to secure the, my lord, wound certificate, on that time that police has informed the present proposed accused. Accordingly, pleading application filed, my lord.
Yes.
But filing my objections.
So you waited till his argument to file your.
Lord, I would have filed at the threshold, my lord. What has happened is I require.
When you took a password, you did not serve him.
Lord, the objections were not even
You
ready.
served
my lord.
him.
Lord, yesterday.
Have you served a copy?
Not
on
yet,
him?
my lord. This was prepared only now, my lord. I'll also make the submission. Yesterday, after your lordships
Mr.
heard the last
Counsel,
matter.
your conduct will be seen in the manner in which you conduct the proceedings.
My lord, I'll explain why. My lord, certain documents which were not, my lord, there was a submission.
But
made.
it's okay, fine.
But
We are not going to adjourn on that basis.
please, please.
Sorry. Yes.
My lord, I'll first answer your lordships as to why there was a.
You served a copy, even now.
Sir, sorry.
Don't try doing all these things.
My lord, I'll explain why there was a necessity to file this only today. My lord, I'll take your lordships to.
We understand the need for filing today. We don't understand you not having served.
My lord, this was only prepared today, my lords. I'll take your lordships through Annexure R16, which is at
So
page
in the
460.
morning when adjournment, when password was sought for, the senior counsel would appear. This is not ready.
This was not ready, my lord.
So what was the reason for password? Not being ready or senior counsel?
My lord, senior counsel was not available, my lord. That is one. Even otherwise, there were certain legal contentions which had to be addressed.
We'll
Whether
deal
this
with-
was prepared or not, their legal contentions
Try
still.
all these tricks.
My lord, I'll explain, my lord, why there was a necessity to file this only now.
We're not saying don't file.
My lord, certain documents were not even available, my lord. Still last evening, I in fact made that.
Your arguments.
My lord, page 460, my lords, if your lordships were to take.
460.
460, my lords.
Yes.
My lord, this is the sale deed which has been executed by the petitioner, my lord. This property is the asset of the partnership firm. Likewise, my lord, there is another annex.
1125.
Sorry, my lord.
It is 27/11/25.
Please. Similarly, my lord, on the same day,
This
another.
is executed by whom?
Sorry, my lord.
Executed by whom?
Executed by the petitioner before this court.
What is the petitioner's name? B.H. Nagaraju. Yes.
Similarly, my lord, another sale deed is also executed. Annexure R17 at page 476. Both these properties, my lord, are assets of the partnership firm.
Yes.
My lord, now the petitioner comes before this court claiming to be a very virtuous man. My lord, this is what has happened. I only wanted to bring to your lordships the notice about this execution of these sale deeds.
Your complaint, that also they'll investigate.
Please, my lord, I'll come back to the merits of the matter, my lord. This document was not even available, my lords, till last evening. What happened is we only realized about the execution of these sale deeds after in the arbitration proceedings which have been going on between the parties. There was a submission made. In fact, there was an application made, my lord. 2 applications are made under section 17 of the Arbitration Conciliation Act. One is filed by me, another one is filed by them. My lord, there is a declaration sought by me before the arbitral tribunal that this properties, though was secured in the name of this petitioner, entire contribution came to be paid by the respondent number 2 therein, my lord, the partnership.
Initiated any proceedings as regards that?
My lord, I came to realize about the execution of these deeds only 2-3 days ago, my lord, when the.
You don't need our permission to initiate, so please initiate.
I would do that, my lord. Coming back to the merits. My lord, at the very threshold, I've raised an objection that this writ petition itself is not maintainable. My lord, I've reproduced the relevant paragraphs of the judgments of the Honorable Supreme Court, my lord, I'll also rely upon those judgments. One of the
Page.
judgments, my lord, came to be passed on, my lord, on the last date. Sakiri Vasu, my lord, that holds the field.
Page.
My lord, reproduction, my lord, of the
Give us the judgment, don't want reproduction.
my lord, the judgment was passed on my lord, last date. It should be the part of the record of the file. Sakiri Vasu.
Can I pass?
Cody, you are not willing to give it to us.
I'm sorry, my lord. My apologies, my lord.
Lord, this judgment is 2008, my lord. Lalita Kumari 14, my lord.
Let him address his arguments.
My lord, the discussion, in fact, starts at page para 11, my lords. May I read?
Yes.
In this connection, we would like to state that if a person has a grievance that the police station is not registering the FIR under section 154 CRPC, then he can approach the superintendent of police under section 154(3) CRPC by an application in writing. Even if that does not yield any satisfactory result in the sense that either the FIR is still not registered or that even after registration, if no proper investigation is held, it is open to the aggrieved person to file an application under section 156(3) CRPC before the learned magistrate concerned. If such an application under section 153 is filed before the magistrate can direct the FIR to be registered and also act and can also direct a proper investigation to be made. In a case where, according to the aggrieved person, no proper investigation was made, the magistrate can also, under the provision, monitor the investigations also. I'll skip to para 13, Malats. The same view was taken by this court in the case of Dalveer Singh versus State of Delhi. We would further clarify that even if an FIR has been registered and even if the police has made the investigation or is actually making the investigation, which the aggrieved person feels is not proper, such a person can approach the magistrate under section 156(3) CRPC, and if the magistrate is satisfied that the order that he can order a proper investigation and take the suitable steps and pass appropriate orders as he thinks necessary for ensuring proper investigation, so on. I'll skip to para 15. Section 156(3) provides for a check by the magistrate on the police performing its duties under chapter 12 of CRPC. In cases where the magistrate finds that the police has not done its duty of investigation, the case at all, or has not done it satisfactorily, he can issue a direction to the police to do so, to do the investigation properly, and can monitor the same. The power in the magistrate to order further investigation under section 156(3) is an independent power and does not affect the powers of the investigating officer to further investigate the case even after submission of his report section 173(8). Hence, the magistrate can order reopening of the investigation even after the police submits the final report. Para 25, Malot, I'll skip to. We have elaborated on the above matter because we often find that when someone is a grievance that his FIR has not been registered at the police station and or proper investigation is not done by the police, he rushes to the High Court to file a writ petition or a petition under section 482 CRPC. We are of the opinion that the High Court should not encourage this practice and should ordinarily refuse to interfere in such matters and relegate the petitioner to his alternating remedy. First, under section 154(3) and section 36 CRPC before the police officers concerned. If that is so, if that is of no avail, by approaching the magistrate concerned under section 156(3). If a person has a grievance that the affair has not been registered by the police, his first remedy is to approach the superintendent of police under section 154(3) CRPC or other police officer referred to in section 36 CRPC. If despite approaching the superintendent of police or the officer referred to in section 36, his grievance still persists, then he can approach a magistrate under section 156(3) CRPC instead of rushing to the High Court by way of a writ petition or a petition under section 482 CRPC. Moreover, he has a further remedy of filing a criminal complaint under section 200 CRPC. Why then should writ petitions or section 482 petitions be entertained when there are so many alternative remedies? As we have already observed above, the magistrate has very wide powers to direct registration of an FIR and to ensure a proper investigation, and for this purpose he can monitor the investigation to ensure that the investigation is done properly. The High Court should discourage the practice of filing a writ petition or petition under section 482 CRPC simply because a person has a grievance that his FIR has not been registered by the police, or after being registered, proper investigation has not been done by the police. For this grievance, the remedy lies under section 36 and 154(3) before the police officers concerned, and if that is of no avail, under section 156(3) CRPC before the magistrate or by filing a criminal complaint under section 200 and not by filing a writ petition. But taking cue from this judgments, there are a series of judgments. I'll also refer to another judgment, my lord, of the Honorable Supreme
Finally, all these were considered. Lalita Kumari is the final word on it.
My lord, my apologies, my lord.
After Lalita Kumari, there's nothing.
Well, Lalita
Kumari is
Kumari's
the constitutional
judgment.
bench judgment.
Well, Lalita Kumari's judgment would only postulate what are the duties of the police officer. Whenever a cognizable offence is made out, it is the duty of the police officer to register an FIR. That is all what is said. My lord, it does not permit a party to file writ petition, my lord. And these aspects were not even considered in Lalita Kumari. These judgments have not been set aside, my lord, or different views. I'm sorry.
Judgment, Mr. Counsel.
Please, my lord. It only stipulates, my lord, the alternative remedy that is available to the aggrieved person is still to approach the superintendent of police and to if he were to have a grievance with that also, his further remedy would be to approach the jurisdictional magistrate. My lord, another judgment on this.
20.5. So we'll direct enquiry against your officers.
Lord, I would also justify as to why this is a civil remedy and why the endorsement issued by the police is correct. Lord, I would also refer to another judgment of the Supreme Court wherein it is said wherever there are partnership disputes, more so where there are litigations pending between the partners, no invocation of criminal proceedings can be made for the reason that the provisions under which the petitioner has now been seeking indulgence of this Honorable Court, my lord, there is already a stipulation by the Supreme Court which still holds the field that provisions such as cheating, blood, breach of trust does not even occur in cases of partnership firm. But I'll refer to that also. Malad, this
doesn't occur in a partnership firm.
It should not. Malad, that invocation, Malad, what is said is, I'll refer to that judgment. But what is said in that judgment?
Refer fast.
Please.
Yes.
But para number 3 and onwards. Para 3 and onwards, Malad. Learned Counsel appearing for respondent number 5 and State of Gujarat submitted that on a bare reading of the complaint lodged, it appears no offence was made out, and whenever a complaint is lodged automatically and in a routine manner, FIR is not registered. In any event, it is submitted that petition under Article 32 of the Constitution is not a proper remedy. Chapter 12 of the code relates to information to the police, so and so. But I'll skip to para 5, Malad. Section 156 deals with police officers' power to investigate cognizable cases, and the same reads as follows, so and so. Para 6, when the information is laid before the police, but no action in that behalf is taken, the complainant can, under section 190, read with section 200 of the code, lay the complaint before the magistrate, having jurisdiction to take cognizance of the offence, and the magistrate is required to inquire into the complaint as provided in chapter so and so of the code. In case the magistrate, after recording evidence, finds a prima facie case, instead of issuing process to the accused, he is empowered to direct the police concerned to investigate into the offence under chapter 12 of the code and to submit a report. If he finds that the complaint does not disclose any offence, to take further action, he is empowered to dismiss the complaint under section 203 of the code. In case he finds that the complaint evidence recorded prima facie discloses an offence, he is empowered to take cognizance of the offence and could issue process to the accused. These aspects have been highlighted by this court in so and so. The above position, it was specifically observed that the writ petition in such cases is not to be entertained. The above position was again highlighted in so and so. Whenever any information is received by the police about the alleged commission of offence, which is a cognizable one, there is duty to register the FIR. There can be no dispute on that score. The only question is whether a writ can be issued to the police authorities to register the same. The basic question is as to what course to be adopted if the police does not do it. As was held in All India Institute of Medical Sciences case, and reiterated in Gangadhar's case, the remedy available is to set out above by filing a complaint before the magistrate. Though it was faintly suggested that there was conflict in so and so, we find that view expressed in Ramesh Kumar case related to the action required to be taken by the police, and when any cognizable offence is brought to its notice, full stop. The Ramesh Kumar's case, the basic issue did not relate to the methodology of to be adopted, which was expressly dealt with in All India so and so. The view expressed in Ramesh Kumar so and so was reiterated in so and so. The course available when the police does not carry out the statutory requirements under section 154 was directly in issue in so and so. The correct position in law, therefore, is that the police officials ought to register the FIR whenever facts brought to their notice show that cognizable offence has been made out. In case the police officials fail to do so, the modalities to be adopted are set out in section 190, read with section 200 of the code. It appears that the present case, initially the case was tagged by so and so. Subsequently, these writ petitions were dealing so and so. The writ petition are finally disposed of with the following directions. If any person is aggrieved by the inaction of the police in registering the FIR, the modalities contained in section 190, read with section 200 of the code, are to be adopted and observed. It is open to any person aggrieved by the inaction of the police officials to adopt this remedy in terms of the aforesaid provisions. So far as non-grant of sanction aspect is concerned, it's so and so. But, there's one other short judgment, one-page judgment.
Yes.
Well, at paras 2 and 3. If I may read. This court has held in Sakiri Vasu versus State of UP that if a person has a grievance that his FIR has not been registered by the police or having been registered, proper investigation is not being done, then the remedy of the aggrieved person is not to go to the High Court under Article 226 of the Constitution of India, but to approach the magistrate concerned under Section 156(3) CRPC. If such an application under Section 156(3) CRPC is made and magistrate is prima facie satisfied, he can direct the FIR to be registered, or if it has already been registered, he can direct proper investigation to be done, which includes, in his discretion, if he deems it necessary, recommending change of the investigating officer so that a proper investigation is done in the matter. We have said this in Sakiri Vasu's case because what we have found in this country is that high courts have been flooded with writ petitions praying for registration of the first information report or praying for a proper investigation. We are of the opinion that if the high courts entertain such writ petitions, then they will be flooded with such writ petitions and will not be able to do any other work except dealing with such writ petitions. Hence, we have held that the complainant must avail of his alternate remedy to approach the magistrate concerned under Section 156(3) CRPC, and if he does so, the magistrate will ensure, if prima facie he is satisfied, registration of the first information report and also ensure a proper investigation in the matter. And he can also monitor the investigations also. In view of the settled position in Sakiri Vasu, the impugned judgment of the High Court cannot be sustained and is hereby set aside. Magistrate concerned is directed to ensure proper investigation, so on. There are a series of judgments, Malad. There are a few other judgments. I would not rely upon that. But
whatever you rely upon.
Malad, I've also indicated, Malad, in my writ petition that first of the objections I've raised in the writ petition is the maintainability of the writ petition. First of the objections that I've raised in my statement of objections. Malad, another aspect which I've raised is the doctrine of sameness. Malad. Doctrine of sameness. So also I've touched upon the double jeopardy. Malad, what has happened is the complaint primarily deals with two issues. One of the issue, Malad, is an attack on my father. Malad, that I've substantiated, Malad.
By you on your father.
Malad, that is the allegation, Malad. I've also produced, Malad, the documents which would show that it is a self-fall.
Thankfully, today you used your father. Yesterday you said his father.
I'm sorry, Malad. I learned my Malad. If I may point out to annexure R1, R2, and R3. These are the discharge summaries, Malad.
Yes.
But these discharge summaries date prior to the allegation, the date of allegation, Malad. There is already a complaint which is already indicated, Malad, by the petitioner in the subject complaint. But some indulgence was sought, Malad, by this Honorable Court to Malad, inquire with the state as to why there was no invocation of Section 307 or whatever. Malad, there are already two writ petitions, Malad, which one is filed by me, one is filed by them. They have sought the indulgence of this Honorable Court, Malad, for a direction against the police to register an FIR for Section.
What do you want to do with annexure R1, R2, R3?
Malad, these are to show that the allegations are false.
Oh, and what is your contention? Just because you produce is other medical.
Malad, based on these medical records, Malad, there is already a stay granted by this Honorable Court. Malad, there are of the two allegations, Malad, substantially the other allegations pertain to the partnership dispute. But this very slightly touches upon this dispute. Hence, I am required to answer, my lord, only to show that I am not, my lord, as alleged by the petitioner, attacked my father or whatever. My lord, I am not, only to show my bona fides. My lord. That is why I've produced these documents.
Yes.
All three are discharge summaries. My lord, the primary, my lord, the substantial objection that I've raised to the writ petition is that my lord, civil proceedings which are pending both before the courts and also before the arbitral tribunal is to be given a cloak of criminality. The petitioner has filed the subject complaint. My lord, there is rightfully an endorsement issued by the police that it is, my lord, civil in nature and no indulgence can be shown by the court. No indulgence can be shown by the police. But R4 at page 31 is first of the legal notices, my lord, that I issued invoking the arbitration clause, my lord. Second of the notices, my lord, is at page 37. And at page 40, my lords, is the order in CMP, my lord, wherein a sole arbitrator came to be appointed.
Hmm.
48, my lord, is the claim petition that I filed. He's already filed a counterclaim, my lord, in the subject arbitral proceedings. That is at page 180, my lords. 180, my lord, 180.
What are the relief sought for?
Well, the relief is for dissolution of the firm and settlement of accounts.
Which firm? The first firm or second firm?
First firm, my lords. No relief is sought as against the second firm.
So second firm, according to you, is separate.
Second firm, I've clearly taken a contention before the arbitral tribunal, is a separate entity having constituted with a due execution of a partnership
The
firm,
same name.
partnership deed, though in the same name, my lord. I've explained that. My lord, I've also, my lord, the right whether the present respondents have in relation to the constitution of a subsequent firm in the same name is only to be decided by the arbitral tribunal.
And what do you have to say about that withdrawal of the monies that has been pointed out?
Well, withdrawal of the monies, my lord,
The account
is
of the
undertaken in the usual course of business. My lord, our entire, my lord, both the partnership firms, no substantial investment is made by any of the partners. The entire, my lord, it's a real estate firm. The entire business is undertaken only with the contributions of third parties. My lord, we get in investors. My lord, that is how the partnership has been
For
functioning.
investigation.
My lord, we get in amounts, my lord, through certain investors, and the investors, with the help of the money that is contributed by the investors, properties are purchased, it is converted into sites, and it is sold. My lord, similar is the modality of the second partnership firm. My lord, what has happened is there are certain amounts which my lord, the investors wanted to take back from the first partnership firm after the petitioner started causing some troubles in the partnership firm. But that amounts of the investors came to be transferred to the second of the accounts.
All that will be investigated.
But now I'll place reliance on.
Anything else?
But there's one judgment, my lord, of the Honorable Supreme Court. Request my senior, my lord, to.
Yes, senior is not available today. That is what Mr. Panindra and Mr. Yes. Yes, which is the decision? Give it fast.
Please. Lord, this is the judgment, my lord, which I referred to initially, which holds that there cannot be invocation of criminal proceedings in a partnership dispute, which is sought to be done by the petitioner herein.
Yes.
But my lord, I won't take much time, my lord. I'll directly go to the last page where where the ratio is indicated. If I may only read the last page, my lord,
These are all your defenses. We are concerned with why the police don't register
my lord, there is no,
this kind of complaints.
my lord, I'll read this and I'll
refuse it. It's not registering, it's refusal.
my lord, my submission is there is no cognizable offense
And
which
the
is made
accused
out.
does not need to be heard in any of the proceedings. We don't need to hear you.
But
We
that,
gave you an opportunity of trying and settling the matter. You don't want to do that.
but I'm open to settlement, my lord, even today.
You have this one of saying his father.
My lord, that was by slip of tongue, my lord. That is my mistake, my lord.
Let the registration happen.
My lord, I'll just read this judgment, my
Yes,
lord. I'll
please.
explain why it is relevant.
And I just only say this, since your lordship said, Pawan Chandra Shetty is also there. I've not yet argued this matter. Lordship may treat this matter as part of it. I will see whether I can facilitate a settlement in the matter. Without
not
getting
part,
into merits.
it
If it
is-
doesn't happen, my lords, I'll instruct my colleague, let him not go on the merits of the matter, and
The police are not registering any of the complaints.
that I am myself.
We are getting a lot of these issues. We agree with what the apex court said, will be flooded. But if the police don't discharge their functions, where will a poor citizen go?
Plenary jurisdiction of your lordships, my lord. There is nothing which the Supreme Court would say that, no, this you do, that you don't do. I'm not for one, but I'm suggesting, lords, if your lordships have said this, if there is anything where I can use my offices to see whether there is a possibility of.
And in this
Lordships may
matter,
treat this
there's
matter as part of
specific
it.
allegation made against the police that they are colluding with your clients. So
what
that is
happens-
more the reason why it should be registered.
So I understand, my lords. Now, the parties are already before the civil proceedings. If anything has happened, he will get back the relief. But if there is a criminality, my lords, so far as partnership is concerned, these disputes, I understand, my lords, that it is not that but there should be, these are all business ventures. There shouldn't be any,
The business venture has gone further.
no, I'm just saying.
We see the picture, photograph of the father.
I've seen that, lords, that is his own father, which he says that he's been assaulted there. Lords, I don't want to stand on that. If your lordships feels
Nearly
that-
around 20 stitches on the head.
What I could gather.
And the
from
police only registered 323
No, what I could gather from.
when
the
there's an injury on the head
instructions-
with 20 stitches.
It's a
Not done.
massive blow.
Not done
But
at
what I
all.
could gather, minutes from the instructions which I received was fall which had, but without getting into all these things. If your
The
lordship
father
had
has given a
suggested-
complaint against the
I would
son.
I would not have even got up because he's been arguing well, minutes. I don't want to, because it will be discouraging my younger friend. But if your lordship feels that this is a matter where your lordships can facilitate some.
Any matter is ready for settlement.
I
The
will
other
see that.
matter, when you are not there, Paninda was trying to reach, but that also is getting settled.
Lords, yesterday, of course, I will have to, so AG is not here, minutes.
So what do you want to do? You try settlement?
No, my lord, it is not possible, my lord. It is not possible.
After having caused all that.
His father is also under the trap, and he is not in the house. The brother is also petitioner.
Let it be ready, let the investigation happen.
No,
People
because-
cannot get away with these kind of things.
It is something like this. 420 and 406 is what they are alleging. As far as assault is concerned, minutes, of course, that is one aspect of the matter. So far as that assault is concerned, is subject matter of the earlier complaint. But the earlier complaint, because there cannot be two investigations on the.
That's a
basis of the
different
same
one, this is different.
But the dates, if your lordships were to see, minutes, the stitches, the dates on which that.
That complaint is for different purpose by the father, this is by the son.
The injury which they are alleging, minutes, is pertaining to the same date. It is between the same
We are not
period.
dealing with that matter here.
No, not at all. The reason why I am submitting this is, one of the contentions raised by them is that whatever he is alleging in this statement, his complaint, is something which is already there in the earlier complaint, not something which is new. But once that complaint was taken cognizance of by the police and thereafterwards by this honorable court by granting an interim order, that cannot be circumvented by filing one more complaint.
That's a
Essentially
different
what
thing.
was
That's
said.
a completely different thing. Don't try and
If
mix.
your lordships were to see the period for which it is done, my lords, I
It's
can
not the
just-
period. The allegations are different. That allegation is of a, though 323 has been registered, that should have been a
assault,
307.
that's the reason. If your lordships were to see the period for which that.
That is
offence
for
alleged
assault.
And what has been
This
said.
is for 420. This is a different thing.
Not so far as section 420 is concerned, my lords. If your lordships were to see the ingredients of the complaint.
Mr. Ravi Shankar, you're come back laterally and trying to argue.
I leave it at that.
One submission on settlement is fine, not
Because
the other
I
things.
just wanted to see, my lords, if there
He's
is
already
something.
been argued on it. He
I
has
know, my
done-
lords, he's doing a good job.
He has done a good job. Success is a different thing.
No, that should never be a.
Yes, anything else you have?
But this last of the judgments, my lord, I'll only read this and I'll stop there. I passed on with this judgment.
Which one?
Uh, Lord Velji Raghavji Patel, the one that I passed on at the end.
You have passed it on now?
I passed it on. I passed it on.
Velji Raghavji, yes.
At the last page.
Hmm.
I'll just read the last page. Lord. Reading the two together, the meaning seems to be only this, that as working partner, the appellant should carry on the work of recovery of the dues of the partnership, and that in respect of the dues from one Kabal Singh, it was decided they should be deposited in the bank. It does not follow from this that any of the other partners was precluded from making the recovery. Further, even if this is to be said to be a mandate to the appellant, item number 16 authorizes him to spend the money for the business of the partnership. That is to say, if the money was required for the business of the partnership, it was not obligatory upon the appellant to deposit it in the bank. In our opinion, therefore, the appellant cannot be said to have been guilty of criminal breach of trust, even with respect to the dues realized by him from Kabal Singh, and in not depositing them in the bank as alleged by the prosecution. Next, please. Thank you. The next point, that is the ratio. Mr. Please.
Last paragraph is the ratio.
The para number 9. Mr. Chatterjee finally contends that the act of the appellant will at least amount to the dishonest misappropriation of property, even though it will not amount to criminal breach of trust, and therefore his conviction should be altered from 1 under 409 to under 403. Section 403 runs this: whoever dishonestly misappropriates or converts to his own use any immovable property which shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. It is obvious that an owner of property, in whichever way he uses his property and with whatever intention, will not be liable for misappropriation